na tao.
Yes, oo.
Second, alam nyo yung harmful effect, like yung sa nangyaring live streaming ng pamamaril, tinatanggal naman ni Meta yon. Ang problema lang, dapat real-time at mabilis yung
Yes.
pagtanggal ng
Mabagal
harm.
sila,
Kasi
mabagal.
mabagal. Yun ang problema nila. Nag-a-agree naman sila. Hindi pwede dapat nasa platform namin yan. O sige, pero bakit ang bagal? Lagi nila tinuturo dun sa mga fact verifier, pinapasa nila sa ibang tao eh. Sa akin, huwag niyo ipasa.
Saan ba
may
headquarters nitong
responsibilidad.
Meta na ito? Saan ang headquarters
Meron ba
nila?
sila dito sa Pilipinas?
Yun nga, wala nga.
Wala.
Kaya nga sabi ko rin,
Wala.
dapat sila magtayo rin na opisina dito. Kaya nga lilipad pa ako ng Singapore.
Naku,
Pinalilipad
Diyos ko
pa naman ako sa San Francisco. Sabi ko, ang layo niyan. Meet halfway na lang tayo. Singapore na lang. Kaya Singapore kami magmi-meeting. Oo.
Sige po, sige. Baka namin yung update. In the
Update tayo,
meantime,
Secretary.
salamat.
Sir,
Thank you.
thank you.
Okay, maraming salamat.
Magandang
Secretary
umaga
Henry
po.
Aguda, DICT. Oras mga kapuso, alas 8:56. Radyo na.
TV pa.
Labanan ng fake news.
Dapat totoo.
DZBB, Balitang Totoo.
So eto na nga ang latest.
May bagong source of all trending buzz na tayo.
Dahil nandito na ang inyong newest Sunday Night Kachismisan!
Every Sunday, 8:30 p.m. starting September 13 on GTV.
DZBB, Balitang Totoo. DZBB, Balitang Tama, Balitang Totoo.
Nako, ang dami ko sanang gusto sabihin pa, kaya lang wala tayong oras.
Bukas na yan, mahirit na yan, oo.
Nandiyan na po si Pare Orly.
At si Connie Season.
One-on-one.
Walang personalan.
Salamat sa oras. Ako po si Joel Reyes.
Ako po si Rowena Salvacion.
Mga kapuso, dito po sa DCWB, walang kinikilingan.
Walang pinoprotektahan.
Noon at ngayon, serbisyong totoo.
August 26, 2026, Day 19 ng impeachment trial ni Vice President Sara Duterte. Magandang umaga, ako po si Pia Arcangel at samahan niyo po ang buong pwersa ng GMA News sa aming special coverage, The Vice President on Trial. Gagawin po ngayong araw ang cross-examination kay Office of the Vice President, Assistant Secretary at Assistant Chief of Staff Lemuel Ortonio. At sa direct examination kay Ortonio kahapon, Day 18, binusisi ng prosecution ang letter request noong August 2022 para sa 250 million pesos na confidential funds na pirmado ng Vice Presidente. Mayroong man daw mga paliwanag kung bakit nanghihingi ang Vice Presidente ng confidential funds. Ipinunto ng prosekusyon na walang anumang dokumentong sumusuporta sa request gaya ng programa, proyekto o aktibidad na may kaugnayan sa national security at peace and order. Kahit Agosto po nag-request, Setyembre na naaprubahan ng Vice at naisumite sa DBM ang Physical and Financial Plan. Kinumpirma yan ni Ortonio.
For the OVP's request for confidential funds, in this letter, walang computation na binigay. Tama ba?
That's correct. No
there was
computation.
also no projection provided in the same letter. And also, there was no physical and financial plan attached to the letter. In fact, there was no attachment supporting the OVP's request for confidential funds. Correct?
There were no attachments, ma'am. In the context of the plans and programs of the office, there has already been plans already at the beginning of the term of the Vice President in July of 2022.
Tinanong din si Ortonio tungkol sa paggamit ng confidential funds para makabili ng supplies gaya ng pagkain at gamot, lalo na't may pondo naman ng OVP para sa ganoong programa. Ayon kay Ortonio, mga informant ang bumili ng mga ito gamit ang ibinigay ng confidential funds.
Funding. But as to the
Hindi mo
activities...
natin anong si Ms. Acosta at ang security officer na iyong nabanggit kung nasaan ang supposed official receipts bilang patunay na ito nga ay nabili, mga supplies na ito.
Ma'am, the explanation that was provided to me, ma'am, was that binigay po ang pera directly doon sa mga informants and agents, and the informants and agents na po yung bumili ng mga medical and food supplies. So, it's the acknowledgement receipt, which is the proof of the release of the funds to the informants or the agent.
Lumabas din po sa paglilitis na alam ng Vice Presidente ang tungkol sa confidential funds. At dahil po dyan, tinawag ng prosekusyon na arkitekto at mastermind umano ng paggamit ng confidential funds si Vice President Duterte. Nag-object o tumutol ang depensa sa pahayag at ipina-strike off sa record ng korte.
Mr. Ortonio, kanina sinabi mo na si Vice President mismo ang humingi ng confidential fund. Siya rin ang nag-decide kung anong amount, kung magkanong amount ang i-request. At pinirmahan niya rin ang approval para sa pag-release ng pondo. Pinirmahan niya rin ang mga liquidation reports at certification supporting the liquidation reports. Tama ba?
Yes.
Okay. In short, you will agree with me. This whole confidential funds matter, ang arkitekto at mastermind nito ay si Vice President Sara Duterte.
Your Honor, please. Your Honor, please. Objection.
Sustained.
Sa huling bahagi ng direct examination, nagreklamo ang depensa sa mga pananalitang ginamit ng prosekusyon.
Remind the prosecution, Your Honor, not to use inappropriate words, Your Honor, like scam, mastermind, nagsisinungaling. We are not supposed to make insinuations, accusations, or conclusions, Your Honor.
It does seem that it's becoming a, I would rather use the word habit than pattern, for the panel of prosecutors to close their direct with such strong statements.
We apologize if sometimes we get carried away by our zeal and our passion, Your Honor. But we at the prosecution, we just want to call a spade a spade.
At nagbabantay po sa Senado si Sandra Aguinaldo. Sandra, good morning.
Yes, Pia, inaasahan nga ngayong araw yung cross-examination dito po kay ASEC Lemuel Ortonio. Ito po yung Assistant Chief of Staff ng Office of the Vice President. Ibig sabihin po, Pia, ay inaasahan na tatanungin naman siya ng abogado ng bise. Pagkatapos naman yan, yung inaasahan din yung tinatawag na redirect kung saan maaaring magtanong naman po muli yung prosecution sa kanya. At gaya nung nakikita naman natin sa mga nagdaang witness ay magtatanong naman po kasunod niyan yung mga senador o senator judges para nga po sila rin ay makapaghingi ng paglilinaw mula dito sa witness na ito na kung inyo pong matatandaan ay naideklarang hostile witness kahapon. Kung sakali po na maagang matapos ito, ayon kay Representative Joel Chua ay naisabpina naman itong si Colonel Manaros Boransing ng Armed Forces of the Philippines at inaasahan po na naririto siya mamaya dahil kumbaga yung bili na rin ito, Pia, ng presiding officer na kailangan laging may nakaabang nakasunod na witness sakaling matapos kaagad yung testimonya nung nauna sa kanya. Isa po ito sa 3 sundalo at dating sundalo na pinasabina ng impeachment court sa hiling ng prosecution. Ayon po kay Representative Chua, inaasahan today yung pagdating din po ni Colonel Magtanggol Panopio at Colonel Adonis Badjao. Bagamat sa tingin niya ay si Boransing lamang yung posibleng maisalang sakaling meron pang oras ngayong araw na ito. A backgrounder naman po, kaya may tinatawag po na sundalo dito sa impeachment court, ay kaugnay po ito doon sa confidential fund ng Department of Education, kung saan noong nasa Kamara po ay nabanggit na rin na merong certificate na nagmula sa DepEd para sa kanilang liquidation sa COA kaugnay sa paggamit ng confidential fund ng DepEd para po sa leadership seminar. Pero kalaunan ay sinabi po ng mga sundalo sa kanilang testimonya na ang ginamit po dyan ay ibang pondo at ito po ay nagmula umano sa LGU at iba pang ahensya ng gobyerno. So yan muna, Pia, ang inaabangan dito sa Senado. At maidagdag ko pala, Pia, yung tanong mo kahapon na kung matutuloy kaya yung ruling ng impeachment court kaugnay doon sa pag-discuss ng merito umano ng magkabilang panig o yung tinatawag nating umano'y pag-violate sa sub judice rule. Pia, gaya ng tanong mo, hindi yan natuloy kahapon dahil nawala na oras, pero inaasahan na naman yan today. Pia?
O nga, Sandra, yun ang inaabangan kahapon, pero sinabi nga ni Presiding Officer Cheese Escudero, ipagpapaliban muna muli. Pero sabi niya, di ba, Sandra, sa pag-uumpisa ng trial ngayong araw, uunahin na nila yung pahayag ni Attorney Ligutan, ang kanyang manifestation bilang tugon sa nangyari noong nakaraang linggo. Tama ba? Nakaraang linggo yun, di ba, Sandra, nung siya daw ay nag-post habang ongoing ang trial, tapos nagreklamo tungkol dito yung depensa.
Yes, tama ka, Pia, dahil nga sabi naman nila, pati na rin si Attorney Bantug ay talagang pinaghandaan naman nila na mailabas na yung ruling. Kaya lang talaga daw nawawala ng oras, kaya hindi ito na ilalabas. Kumbaga priority nila talaga na masagad yung oras para naman doon sa witness at doon sa mismong mahalagang testimonya dito sa trial. Pero ganun pa man, Pia, sinabi rin naman ni Attorney Ligutan na ready rin naman siya. In fact, ilang araw na rin niya sinasabi na kung siya'y pagbibigyan ay ready muna siyang mailahad yung kanyang panig kaugnay sa bagay na yan. Pia?
Pero mukhang, Sandra, talagang itutuloy na rin yun at timing rin dahil nga kahapon ay, hindi naman ito tungkol sa mga bagay na sinabi outside of impeachment court, pero nag-manifestation at tumutol muli ang depensa doon sa mga salita na ginamit ng prosecution sa kanilang pagtatapos ng direct examination. Tingin mo ba, Sandra, ito ba pwede nilang isama doon sa ruling kung ano man? Kasi sinabi ni Presiding Officer Cheese Escudero, hindi dapat ginagamit yung mga ganitong salita tulad ng nagamit na ng prosecution tulad ng scam or yung pagsisinungaling at iba pang mga salita.
Yes, Pia, o nga kahapon meron siyang pahiwatig no, na parang isasama niya to dun sa ruling niya. Ganun pa man, maganda pa rin abangan dahil ang sinasabi ni Attorney Tonggol kagabi dun sa kanyang briefing, ayun nga, merong, kumbaga napagsabihan yung prosecution sa bagay na ito, yung pag-i-issue ng strong statement bilang pang-wrap up doon sa kanilang sa testimonya no, ng kanilang witness. Kapag tapos na sila ay nag-wrap up tapos nagwawakas sila sa paggamit ng strong statement, yun yung ginamit niyang term. At ito nga po yung tinutulan muli ng depensa kahapon at nagkaroon nga ng diskusyon tungkol dyan. At kung iyo mapapansin, Pia, yun nanindigan din yung prosecution no, na we're calling a spade a spade. Sabi niya nga sa pangwakas na salita no, ng kanilang abogado. So yan yung aabangan natin na Pia kung ano ang magiging ruling, kung isasama ba ito ni presiding officer sa ruling niya ngayong araw na ito. Pia?
At Sandra, inaasahan din ba natin na may anunsyo na tungkol sa kung anumang pagbabago, kung meron man no, sa schedule ng impeachment? Dahil kahapon, bago nagtapos ang trial, muling nagtanong si Senator Mig Zubiri, siyempre bilang majority floor leader, inaayos nila yung kalendaryo ng Senado kung pwede ba nilang ilipat or kung ililipat ba yung oras ng impeachment trial sa hapon.
Yes, Pia, pinag-uusapan na nga yan, pero as of yesterday, nagtanong tayo, wala pa kasing naganap na caucus. Bagamat talagang parang yan na yung mainit no, na usapin, talagang pinag-uusapan among the senators. May nauulinigan lang tayo na dapat pwede na siya ipatupad next week. At dahil holiday yung Monday, pwede raw ng Tuesday na ipatupad. Ganun pa man, kasi kailangan nga, di ba sinasabi ng Senate President din at saka ng presiding officer, syempre kailangan din na adjustment no, on all parties para dyan. Kailangan may anunsyo siya ng maaga-aga, hindi pwedeng ura-urada. So yan, Pia, sa tingin ko sa ngayon ay wala pa talagang malinaw no, na desisyon ang Senado kaugnay sa bagay na yan. Pia?
Sandra, pwede mo bang ikwento sa amin or ipaliwanag sa amin ano ba nga ang schedule ngayon sa Senado ng mga senador? Kasi noong isang araw, bago pa man mag-umpisa yung impeachment trial ng alas 10 na umaga, may mga committee hearing na, di ba? Araw-araw ba may mga committee hearing even before the trial? Tsaka, syempre, may session pa sa hapon, may mga sumasabay pa ba dito, Sandra?
Pia, sa week na to, no, simula nung Monday bale, yung pa lang yung committee hearing na pinangunahan ni Senador Chis Escudero, yun lang yung sumingit ng before the trial ng 10 a.m. So far, wala pa namang naulit. Pero ang kalakaran po dito, pagdating naman po ng Huwebes at Biyernes, ay may mga hearings na po na nagaganap. Ngayon, may paalala nga uli si Senator Mig Zubiri tungkol dyan kasi magiging busy na raw sila talaga at papasok na yung usapin kaugnay sa pagpapasa ng national budget para next week, inaantabayanan na nila yung pagpasok niyan. So talagang bukod dun sa hearings ng mga komite, ay papasok pa yung hearings para sa national budget. Kaya po sabi ni Senator Chis Escudero, bago daw talaga sila mag-rule tungkol sa change of schedule, aabangan nila yung calendar na ipapasa naman po ng Finance Committee na siyang mangangasiwa po dun sa mga hearings na ito. Pia?
Alright, maraming salamat, Sandra Aguinaldo. At para po tulungan tayong talakayin at himayin ang nangyari sa impeachment court, makakasama po natin ngayong araw si UP College of Law Associate Dean Professor Paulo Tamase. Prof, good morning.
Good morning, Pia, at sa inyo mga taga-subaybay.
Nako, Prof, yung nangyari po kahapon, direct examination, second direct examination of a hostile witness. Paano nyo ikukumpara yung direct examination sa hostile witness kahapon, kaya Ginoong Ortonio, doon sa naging testimonya naman ng first hostile witness na si Ginang Acosta?
Mas malaman, mas madami tayong nakuha definitely with the second hostile witness, si Asek Ortonio. Siguro for two important reasons. Una, yung witness mismo. Si Gina Acosta was an SDO, but batay doon sa testimony niya, mukhang ginagawa lang niya kung ano yung ipag-utos ni Vice President Duterte or ni Colonel Chica. So in that sense, para nagiging pass-through lang siya nung pera doon sa confidential funds. Pero si ASEC Ortonio, dahil doon sa posisyon niya as internal affairs, siya actually yung may knowledge ng operations. Yung kung ano yung nasa likod ng pera, kung ano yung dahilan kung bakit ganito yung pagpapaliwanag nila, etc. So madami tayong napulot from yesterday. Yung isa pa siguro na noticeable ay siguro sa style na rin nung examination niya, both Gina Acosta and ASEC Ortonio were hostile witness. Ibig sabihin nun, pwede silang idiretsuhin nung abogado ng prosecutor na yes or no leading questions. But yung kay Gina Acosta, tumagal lang mahigit isang araw yung testimony niya. And I think at some point kasi hindi kinakahon yung questions para sa kanya. Kahit na resistant naman siya at consistent siya na hindi niya kaya sagutin or ayaw niya sagutin yung questions. Kahapon mas, I think, thoughtful, deliberate yung questioning in the sense na very few times lang tinanong si ASEC Ortonio ng open-ended na tanong. And most questions by Attorney Divina Gracia were yes or no. And therefore, malinaw yung kwento na gusto ipakita ng prosecution. Of course, yung hilot niyan is today. So, hindi natin alam kung yung defense, mas extensive yung cross-examination nila. Batay na rin doon sa style ni Attorney Ferrer from before. But also because mukhang maraming kailangan ipaliwanag today si ASEC Ortonio, yung witness, hindi katulad ni Gina Acosta noon na very narrow naman kasi yung testimony niya.
Na-establish naman po na talagang aprobado, supervised, and under the authority of, and with approval of Vice President Sara Duterte, yung pagkuha ng pag-request, pag-withdraw at pag-disburse ng confidential funds. So, ang tanong ngayon, Prof, is tama ba yung paraan na ginamit nila sa paggawa ng lahat ng ito? At kung paano ito ginamit?
Well, mukhang, I think yun yung isang key takeaway from yesterday. Kino-confirm ni ASEC Ortonio yung past observations, whether by the Commission on Audit or by Gina Acosta's own admissions, na may mga problema yung pagsunod, pagtalima nila doon sa joint circular. May mga personnel na parang hindi dapat na pagkatiwalaan ng pondo. May mga expenses na mukhang hindi pasok doon sa allowable expenses, na covered naman by a normal appropriation. Ibig sabihin po nun, kung isusuma total yun, maraming defects doon sa compliance sa joint circular. Now, sa batas, ang ibig sabihin nun ay pag hindi po kasi sumunod doon sa joint circular, may problema doon sa liquidation, nagkakaroon ng presumption or pagpapalagay, no, na nagkamali at nagkaroon ng personal na gamit doon sa pondo. So, nagiging burden ngayon nung kampo ni VP Sara ng defense na ipakita na wala talagang nangyari na questionable doon sa confidential funds. But yung dalawa pang mahalaga na lumabas, bukod doon sa direction, involvement, yung sabi nga ng prosecution, mastermind or architect, no? Yung pagiging ganoon ni VP Sara dito, ay una, marami doon sa dokumento na ipakita ng prosecution, mukhang pretextual at pro forma. Ibig sabihin nun, parang nauna yung gastos bago yung pagpapaliwanag. So, nauna munang humingi ng confidential funds bago sila nagsubmit ng plano. Which means humingi muna sila ng pera bago sila nag-isip kung ano yung gagawin. Parang yun yung sinasuggest ng prosecution. Hindi natin alam kung malilinis or mahihilot yan today nung depensa. Yung isa naman ay pro forma. So, paulit-ulit yung figures, paulit-ulit yung items, which makes you question, or syempre, natural magtanong, seryoso ba itong mga plano na ito? Or seryoso ba yung mga programa kung kada taon, kada quarter, paulit-ulit lang at pare-pareho yung inire-report? So baka wala, I think yung suggestion ng prosecution is wala talagang underlying na programa yung paghingi ng pondo. Humingi yung pondo dahil available yung pondo. Parang ganoon lang yung naging dahilan nila.
Pwede po ba nating linawin, Prof? Kasi di ba nga ang sabi nila, humingi kayo ng pondo, wala naman kayong attachments dun sa request na kung paano nyo gagamitin or kung para saan gagamitin. Pero na-approve yung pondo kahit wala yung mga attachments na yon, kahit walang paliwanag na gano'n. So wala po bang pananagutan or pwede bang gamitin argumento ng depensa na in-approve naman kahit na walang mga attachments?
Magandang tanong yan. No? So magkaibang punto yan. Una sa lahat, definitely may pananagutan yung executive department dito. May pananagutan yung DBM at the time. May pananagutan yung Pangulo for approving yung confidential funds. Mas malaking commentary yung naging dito sa kaso na ito, yung ang lalaki nitong mga pondo na ito na sobrang flexible, parang walang underlying na fixed government program or project. So, kung milyon-milyon, daan-daang milyon yung ginagastos para dito, saan talaga pumupunta yung pera? Definitely by approving something na mukhang hindi backed up by proper plans, proper programs, may accountability, may responsibilidad din yung mga opisyal na nakatataas, no, na nag-aproba nun. Iba yun sa issue ng pananagutan ni VP Sara. Kasi dalawang punto yun eh. Kung totoo nga na nagkawaldas or nawala yung confidential funds, una sa lahat, hindi porke o papayag yung executive, wala ka ng responsibilidad na sumunod doon sa joint circular. Kasi kung nagkamali doon sa grant, hindi ibig sabihin na wala ka ng ibang obligasyon kung paano mo susuportahan yung mga transactions na iyon. Kailangan mo humingi ng sapat na resibo doon sa suppliers na established naman. Kailangan mo humingi ng mga acknowledgement receipts na nagpapakita ng allowable expenses. Pasok dapat doon sa allowed sa confidential funds. Yung isa pa ay, let's say nagkamali ng grant. Hindi ibig sabihin nun na dapat gastusin mo yung pera. And yun yung lumabas doon kahapon na I think yung prosecution, sinusubukan nilang patunayan na hinabol nung VP yung pag-clear out nung confidential funds kada quarter na simot talaga, walang naiwan. In fact, may isang quarter na parang sobra pa ng 150,000, may butal. So, ibig sabihin nun, very rarely nangyayari sa gobyerno yung ganoon. Usually, kung nagkaroon ng budget para sa isang bagay, tapos masyado ng late na approve, hindi natapos kaagad, yung government humihingi ng extension, yung agency humihingi ng extension, usually 2 years yung pinapayagan, but hindi kasi siguro nag-a-apply sa confidential funds yun. Medyo special yung confidential funds. And therefore, ang trabaho ay pag may sobra, ibalik. Hindi kailangan ubusin. And I think yun yung nag-raise nung red flags at suspicions since the first witnesses actually dun sa confidential funds.
Kasi pagbalik, zero na.
Pagbalik zero, and alam naman natin, kahit yung normal na bumibili na consumer, bihirang-bihira yung babalik sa iyo yung mga transactions na ang lilinis nung zero sa dulo. No? Parang walang
sukli.
Perfect no, yung transaction.
Walang 0.05, 0.43, ganyan.
Considering may tax yan, lalo na pag government. So maraming issue na ganoon, I think na lumalabas doon sa confidential funds testimony kahapon.
At ito yung, kaya nga tinatanong kahapon ng prosecution, ano bang nangyayari sa pera kapag naibalik, kung hindi naubos, at ang sinasabi nila, ibabalik sa National Treasury. Tama
Yes,
po yun?
but ang nangyari so far is walang naibalik. No? Maraming interesting points doon sa testimony kabilang na actually yung rounded figures, but meron pang isang punto yung nag-abono pa. Si Asek Ortonio allegedly. Una sa lahat, hindi po unusual sa gobyerno yon. Minsan yung gobyerno mabagal talaga gumalaw. So nag-aabono yung mga public officers. Pero yung abono po kasi dito, usually suportado yan ng resibo din kung para saan ginastos. And kung ikaw yung nag-abono, obviously speaking from personal experience, ini-ensure mo na mayroong resibo yan para mahingi mo ulit sa gobyerno yung bayad. Pero ma-reimburse ka, no? Pero hindi makita yun doon sa presentation kahapon. Yung isa pa siguro last, no? May every time yung COA bumabalik sa kanila, na point out na iba-iba yung dahilan na naibibigay. So, yun yung sinasabi nung na parang pretextual reasoning. Naghahanap na lang nung dahilan na maibigay, pero hindi talaga mai-supply yung totoong dahilan kung bakit ganoon yung transaction. So, madaming ganoon na points yesterday. Hopefully nga ma-clean up today kasi sa dami nung nailabas, mas interesting actually to find out kung ano yung palagay ng defense na nakatama sa kanila. Yun yung malalaman natin from the cross-examination.
Meron din kasing lumabas kahapon na may binigay daw sa informant tapos walang naibalik na sukli. Tapos pati yung, parang yung pagbigay rin dun sa informant, parang all-in na yon. So ikaw na rin, yung informant na rin daw bibili ng gamot, supplies, or kung ano man kailangan niya dun sa perang yon.
Yes. And unusual yun certainly. Now, meron bang paraan para patunayan na tama talaga nangyari talaga yun? Of course, meron, no? But yung isa pa nga na lumabas kahapon is yung documentation nung OVP para dito. Hindi ganoon ka-detailed or hindi ganoon ka-linaw. Nakita din natin yan sa past witnesses. So, paano mo naman ipapaliwanag na binigyan mo ng 150,000? For example, yung isang informant, siya na bahala sa lahat. Aba, wala ba talagang ibabalik na sukli yun? Pera ng bayan yun. So, yung mga ganoon na mistakes, dalawa lang naman yan Either sa sobrang dami ng mistake na iyon, nagpapakita siya ng kapabayaan nung opisina ng Vice President doon sa napakalaking halaga na involved kahapon. or sa confidential funds rather. Yung pangalawa ay, kung hindi ka pabayaan, mayroon bang mas malicious na intent behind it? Tinake advantage ba yung difficulty ng confidential funds, yung inherent secrecy ng confidential operations upang mapunta yung pera somewhere else for whatever purpose na hindi provide sa circular. So yun yung mga tanong na lumalabas sa isip ng taong bayan ngayon sa nanonood nito. But something to emphasize it is actually nagiging burden na to increasingly ng depensa. Paano nyo ngayon ipapaliwanag? No? And unfortunately, dahil doon sa sistema natin, sa second half pa ng impeachment trial, maririnig yung pagpapaliwanag na iyon.
Alright, well Professor, pag-usapan pa po natin ito ng mas mahaba mamaya. Pero ngayon po mga kapuso, bagitin lang po natin na napapanood ang ating live stream ng GMA News Special Coverage, The Vice President on Trial, sa ating YouTube page na youtube.com/@gmanews, pati na sa ating Facebook page na facebook.com/gmanews. At simula po 9:45 na umaga, mapapanood na rin ito sa GTV. At ngayon kuha po tayo ng latest sa sitwasyon sa Senado mula kay Ian Cruz. Ian, magandang umaga.
Magandang umaga, Pia. Ngayon nga ang Day 19 ng impeachment trial laban kay Vice President Sara Duterte. At Pia, kani-kanina lamang nakita na natin na nagsimula ng magdatingan yung magkabilang panig. Nakita na natin ang lead prosecutor na si Representative Jervil Luisro. Kadarating lang din itong si Representative Joel Chua. At syempre sa panig ng depensa, nakita na natin si Attorney Michael Powa, ganyan si Attorney Sheila Sison. At ngayong araw, Pia, ay inaasahan nga ang cross-examination ng depensa sa ikalawang hostile witness na si ASEC Lemuel Ortonio ng Office of the Vice President. At kanina sa pagdating nitong si Attorney Christine Ferrer ay tinanong natin siya kung gaano ba katagal o kahaba yung giging cross-examination niya dito nga kay ASEC Ortonio. Dahil nga kahapon, Pia, kung matatandaan mo, buong umaga at hanggang doon sa pagtatapos ng trial ay ginugol yan sa direct examination ni Attorney May Divina Gracia. Pero nung tanungin natin ngayon lamang umaga, itong si Attorney Christine Ferrer ay ayaw niyang magsabi kung gaano ba kahaba yung itatagal ng kanyang cross-examination dito kay ASEC Ortonio. At binanggit nga rin natin sa kanya na mahaba yung naging direct examination at ayaw niyang sabihin, tingnan na lamang daw mamaya. At sa testimonya nga ni Ortonio, Pia, ay binanggit niya kahapon na originally 250 million pesos talaga ang nais ng prosecution ng OVP na makuha na confidential funds noong 2022. Pero yun nga 125 million lamang yung in-release na pondo ng DBM at yan ay para sa fourth quarter ng 2022. At sinabi rin nga niya doon sa kanyang direct examination na yung mga pondo o yung intelligence funds na ginamit or confidential funds na ginamit para sa pagbili ng gamot, ng supplies at iba pa gaya ng chairs and tables, sinabi niya na binigyan nila ng pera ang agent at yun na raw ang bumili nitong medisina, ng supplies at ng chairs and tables. Kaya naman nung iulat sa kanila ng security officer na si Colonel Raymond Dante La Chica ay cash daw ang ibinigay at hindi yung mismong medicine o supplies na pinag-uusapan nga dito sa impeachment court. At kahapon din, Pia, ay nabanggit ni Attorney May Divina Gracia na tila scam itong ginawa dito sa paggamit ng confidential funds ng OVP at ang tila mastermind umano ay si VP Sara Duterte. Of course, nag-object si Attorney Christine Ferrer at pina-strike out nga niya sa impeachment court at ginawa naman ito ng korte at patuloy na nagpapaalala na maging maingat sa paggamit ng mga salita. At ngayong araw, Pia, inaasahan din na maglalabas ng ruling si Presiding Officer Cheese Escudero patungkol doon sa August 12 manifestation ni Defense Counsel Sheila Sison. Patungkol yan doon sa naipost ni Attorney Virgil Liguta naman ng prosecution patungkol doon sa mga misleading question. Inaasahang magkakaroon ng paalala o maaaring magkaroon ng order at warning ang presiding officer patungkol nga dun sa Rule 18 o yan yung sub judice rule na hindi dapat na didiscuss sa publiko at sa labas ng impeachment court yung merits nitong kaso o itong impeachment trial na gumugulo nga sa mga sandaling ito. At Pia, inaasahan nga mamayang alas 10 ng umaga ay magpapatuloy itong day 19 ng impeachment trial laban kay Vice President Sara Duterte. Balik muna sa iyo, Pia.
Iyan, kahapon bago nagtapos yung trial ay nabanggit ni Presiding Officer Chis Escudero yung report sa kanya ng Medical Bureau ng Senado na talagang bumisita sila at isinilip ang kalagayan ni Edward Fajardo na siya dapat tetestigo sana kahapon dahil nga nag-submit ito ng medical certificate na siya ay patuloy na nagpapagaling. At ang sabi kahapon, Iyan, may dahil 2 weeks daw ang itinalagang bed rest ay ipatatawag pa rin siya after nung lapse ng 2 weeks na yon. So, ibig sabihin, Iyan, itutuloy pa rin ang kanyang pagtestigo sa impeachment court?
Yes, Pia, ang schedule initially, nabanggit din ni Representative Jerbil Luisro na nais nila na sa September 7 na iharap itong si Edward Fajardo sapagkat yun nga, Pia, nagpapagaling pa siya ngayon sa ospital. At of course, Pia, itong mga bagay na ito hindi pa natin matitiyak sapagkat alam natin na marami pa ring nakalinya para sa prosecution. Si Lemuel Ortonio ngayon at meron pang 3 na officer ng AFP. Isa dyan ay retirado na magpapatunay din naman doon sa paggamit ng confidential funds ng Department of Education. So, kung papayagan na ba at iaalaw na itong si Edward Fajardo, of course, ang nakikita natin dyan, Pia, at ang binabanggit sa atin ng mga source natin, kailangan din siyempre na may pahintulot yan ng kanyang doktor dahil alam natin at nabanggit din sa open court na na-ICU itong si Edward Fajardo. So, malalaman natin sa mga susunod pang araw kung talaga bang kakayanin na niya na mag-testify, Pia, dahil alam natin na hindi ganun kadali ang umupo doon sa witness stand bilang isang testigo dahil nga syempre magpe-prepare ka, maraming itatanong sa iyo, lalo na at inaasahang magiging hostile witness din siya gaya ni na Acosta at nito ngang si Lemuel Ortonio. And Pia, may dagdag ko na rin, natanong din natin si Representative Joel Chua patungkol naman doon sa tinatanong din ng mga senador na bakit hindi patawagin si Colonel Raymond Dante La Chica, na dating security officer ng Office of the Vice President. At ang sinasabi ni Gina Acosta na doon niya tinurn over at inirelease itong mga confidential funds ng OVP. Pero sabi ni Chua, sa ngayon ay talagang pinag-aaralan pa nila kung kinakailangan pa bang ipatawag itong si Colonel Dante La Chica. At tinanong nga natin siya kanina kung bakit ba hindi nila maipatawag sa ngayon itong si Colonel La Chica. Sabi niya ay hindi nga daw kasi nila alam kung ano ba ang maaring sabihin nito doon sa impeachment court. Hindi pa nga raw nila naririnig yung testimonya nito. So, hindi nila alam kung ano ang maaari niya sabihin, kung magsasabi ba siya ng totoo o gaya ng mga unang testigo nila, naging hostile witness na yun nga, hindi nagiging evasive umano ayon sa kanya. So, yan ang isa sa mga consideration nila ngayon at sinasabi rin niya, Pia, na doon pa lamang naman sa testimonya ni Gina Acosta na itinurn over niya yung pera at hindi naman siya disbursing officer, doon pa lang ay nakita na hindi talaga sumunod doon sa joint circular ng DBM at COA itong OVP patungkol nga sa confidential funds. Kaya naman sa tingin nila baka nga hindi na kailanganin itong testimony ni si Colonel La Chica. At may chance pa rin naman daw na matanong nila ito kung sakali naman na yung defense ang mag-present sa kanya bilang witness dahil sabi ni Representative Joel Chua, common naman nila na witness itong si La Chica. Kaya pwede pa rin nilang matanong kung ipipresenta nga siya ng defense, Pia.
Alright, Ian, yun nga actually ang itatanong ko kasi sabi ni Attorney Tonggol kahapon na base dun sa pre-trial conference na nailista rin naman si Colonel La Chica. So, ang depensa ba, sinasabi ba nila or binabanggit ba nila kung sila ba ay inclined na ipatawag bilang sarili nilang testigo si si Colonel La Chica pagdating ng oras na sila na ang nagpipresenta ng kanilang mga argumento?
Well, Pia, tulad ng prosecution, tinanong din natin ang defense team sa pamagitan ni Attorney Michael Powa. Ang sinasabi rin niya, Pia, patuloy din nilang pinag-aaralan kung kakailanganin pa rin daw na ipresenta nila itong common witness nga ng prosecution and defense si Colonel Chica, sapagkat sabi ni Attorney Powa, kung sa tingin nila ay naipaliwanag na nila doon sa mga nauna ring mga testigo yung mga punto na dapat nilang klaruhin, baka hindi rin nga nila ipresenta itong sila Chica. Pero sa ngayon, hindi pa yan din pinalpiyan, gaya sa prosecution. Sila ay talagang nag-aaral at alam natin, may mga strategies talaga, ang defense, ganun din ang prosecution. So talagang lahat ng mga steps, even itong pagpipresent ng mga witness, talagang calculated yan, Pia, dahil nga mahalaga para sa magkabilang panig na syempre kung ano yung ilalabas mo, dapat makakapuntos ka doon at hindi makakasama doon sa target na output ng inyong panig, Pia.
Alright, maraming salamat, Ian Cruz. At balikan po natin ang ating diskusyon kasama si Professor Paulo Tamase, Assistant Dean ng UP College of Law. Professor Tamase, kahapon, napag-usapan na natin yung naging takbo ng testimonya or ng direct examination care of the prosecution. Pero doon sa pagtatapos ng kanilang direct examination, nagamit ulit yung salitang scam. Tapos ginamit rin yung salitang nagsisinungaling at yung isa pang salita, mastermind, na inalmahan ng depensa. Na pinanigan naman ni Presiding Officer Chis Escudero. Ano po ba yung patakaran? For example, in a regular court. Kasi ito papastrike off the record pero narinig na ng publiko. In a regular court, kapag nagamit ang mga ganitong klaseng salita or may mga ganitong klaseng insinuations, ano ang ginagawa ng hukom?
Well, in a regular court, pwede talaga i-strike out yung statements na gano'n orally. Kailangan lang siguro linisin yung sinabi ni Senator Cayetano kahapon na hindi yun pwede sa pleading. Generally, pwede yan pasulat, yung mas forceful na ganoon na conclusions, lalo na at certain stages. So, pag sinusuma total mo na yung kaso mo, magpa-file ka na ng memorandum, malinaw naman sa iyo yung ebidensya, pwede mong isama yun doon sa memorandum kasi privileged ang pleadings. Protektado yun na pwedeng gamitin ng abogado yung salita na yun. But dito siguro nagbe-blend yung impeachment process bilang political at bilang legal. So on the legal side, tama sila ni Senator Escudero. Dapat talaga ma-strike out yung statement na iyon kasi parang piniprejudge yung testigo or piniprejudge in that case si VP Sara Duterte. Siguro mahalaga din i-highlight kasi na ilang beses na siya sinubukan gawin ng prosecutor or prosecution. And alam naman natin na ginagawa nila yun kasi nakikinig yung taong bayan. But that said, pag tinignan mo yung taong bayan, mahirap din kasi minsan i-explain sa kanila sa mga hindi nag-aral ng abogasya, sa mga hindi naman sinusubaybayan to lagi, kung ano ba talaga yung punto ng prosecution. Very clear yung konsepto ng mastermind or very clear yung konsepto ng architect kumpara doon sa gagamit ka ng technical words like key perpetrator or parang co-conspirator, di ba? Parang malilito lagi yung taong bayan or malilito lalo. So, mahirap yung trabaho ng impeachment court, ng Senado, but I think sinusubukan naman nila i-meet yung gitna noon. Ano ba yung balanse noong political at noong legal? Tignan natin, for example, yung offer of testimony ni Attorney Divina Gracia yesterday. Yung offer of testimony sa korte, sobrang dry niyan usually. Usually, tatanungin mo lang na this witness is being presented to prove the following. Yung unang fact na gusto mo, yung second fact na gusto mo, yung third, etc. Pero kahapon, yung offer of testimony ni Attorney Divina Gracia sa simula, di ba? Parang may halo na onti na yung may halo na indications, may halo na rhetoric ng kaonte na hindi siya I think as explosive, as direct as yung attempted opening statement ni Senator Laila, but mas malinaw bigla sa taong bayan kung para saan ba talaga yung testigo or para saan yung testimonya. So yun yung isang maganda example na kaya balansehin yung legal at yung political. Sobra siguro yung paulit-ulit na scam, paulit-ulit na mastermind, pwedeng hayaan ng prosecutor or prosecution na gawin yun ng mga spokespersons nila as long as hindi sila members ng prosecution team. But within the Senate itself, baka ideal to keep to a more careful language. But on the part of the prosecution, maraming estilo na available sa kanila and magiging available din sa defense, gaya nung ginawa ni Atty. De Vinagracia kahapon sa simula. Yung parang naisingit na niya kung para saan ba talaga itong testigo na ito. At ano yung relationship niya doon sa larger responsibility ni VP Sara para sa confidential funds.
Ano po yung pagkakaiba nung ginawa ni Attorney De Vinagracia dun sa sinasabi? Kasi sabi ng depensa, medyo tumutol din sila noong umpisa.
Yes.
Sabi na, these are already conclusions of law. How do you draw the line? I mean, make the distinction.
Well, respectfully, medyo unusual yung objection nung depensa doon kasi ang offer of testimony is precisely to highlight kung ano yung gusto mo malaman from the witness. And therefore, they may include conclusions of fact. Purpose lang naman kung para saan mo pinapakita yung testigo.
So, hindi mo pa sinasabi na napatunayan na.
Yes,
patutunayan pa lang.
Yes, patutunayan. Ito yung magiging effect ng pagpipresenta ng testigo. Yun yung reason for it. At kaya ganoon yun kasi sa rules of court natin, sinusubukan mong ikulong yung testigo to ensure na yun lang yung itetestigo niya. Hindi yung kung ano-ano na gusto lang niya sabihin. So may ganun na rule sa rules of court natin na parang para mapaayos yung trial. So in that sense, yung sinasabi kasi or yung objection in defense kahapon was parang sound bites yung ibang parte dito. Pero mixed legal and political process talaga siya. So ibig sabihin nun, may mga bagay na kailangan mabusisi, mabagal, carefully explained para doon sa senators. But dahil yung publiko mismo ay involved in the trial, kailangan may mga bagay na kaya intindihin, kaya i-digest nung mamamayan na nagtatrabaho habang ongoing itong trial na ito. Or walang opportunity na panoorin yung buong 5-6 hours every day. So to that extent, I think okay lang yung ginawa ng prosecution. Kailangan lang ng pag-iingat para hindi naman maging or ma-violate yung direction ng Senate President na dapat na walang opening statements na for these purposes.
Pwede ko bang balikan yung isa dun sa mga ginawa rin or yung naging direksyon ng prosecution sa kanilang direct examination kahapon? Kasi pinapakita nila na yung predecessor ni Vice President Sara Duterte na si former Vice President Leni Robredo, wala siyang confidential funds na natanggap. Bakit mahalaga na ipakita na yung OVP nung panahon ni Vice President or former Vice President Leni Robredo, walang confidential funds? Tapos ito, sinasabi nila, kay Vice President Sara Duterte may confidential funds. Although pinakita na noon, di ba, ng depensa na panahon ni former Vice President Binay, nagkaroon naman ng confidential funds. Although, syempre, very different amount yung natanggap.
May legal reason, may political reason. Unahin natin yung political this time. Isang key argument, usually for the prosecution and for yung people against the Vice President, is that kaya nyo patakbuhin yung opisina nyo without these funds. And highlighting that makes a strong political point na hindi necessary para magpatuloy ng maayos yung opisina mo na humingi ka ng mga pondo na ito. So, regardless of what side you are on, I think generally understood naman na maganda yung pagpapatakbo ng OVP nung time ni Vice President Robredo. May social services, especially during the pandemic, etc. So, kaya patakbuhin yung opisina with a smaller budget and within a budget na walang confidential, flexible funds. The legal point, however, is para ipakita kung bakit parang nagmamadali yung OVP. So, kaya nila kailangan humingi ng confidential funds ay dahil nagsisimula yung termino niya June 30. Ibig sabihin, tapos na yung kalahati ng taon. Tapos parang bakit hinahabol bigla? So, bahagi siya dun sa larger legal narrative nila na hindi nyo kailangan yung pondo, minadali ninyo yung paglabas ng pondo, kung ano-ano yung mga ginawa nyong report or justification para lumabas yung pera, kahit mukhang hindi nyo naman siya kailangan. So pasok siya ulit dun sa pretextual or pro forma na argument ng prosecution.
So anong gusto nyo makita ngayong araw na ito, Professor, from the cross-examination?
So from the cross-examination, honestly, gusto ko marinig yung mga bakit. There were many points in the testimony yesterday. Kaya din mabilis relatively kahapon. Considering sa dami nung naisabi ni ASEC Ortonio, mabilis lang siya dahil hindi binapayagan ng prosecution na mag-explain si ASEC Ortonio. And tama yun, prerogative niya yun on questioning a hostile witness or in leading questions for a hostile witness. precisely yung purpose nun ay para hindi mailigaw yung prosecution na kung ano-ano yung sasabihin ng hostile witness. Para kung ano lang yung katotohanan and yung facts na gusto natin malaman.
Alright.
But binibigyan sila ng pagkakataon this time in depensa na mailinaw yun by asking questions to explain yung answers kahapon.
Thank you, Professor. Magandang umaga po. August 26, 2026, Day 19 ng impeachment trial ni Vice President Sara Duterte. Ako po si Pia Arcangel. Samahan niyo po ang buong pwersa ng GMA News sa aming special coverage, The Vice President on Trial. Gagawin po ngayong araw ang cross-examination kay Office of the Vice President, Assistant Secretary at Assistant Chief of Staff Lemuel Ortonio. Sa direct examination kay Ortonio kahapon, Day 18, binusisi ng prosecution ang letter request noong August 2022 para sa 250 million pesos na confidential funds na pirmado ng Vice Presidente. At mayroon man daw mga paliwanag kung bakit nang hihingi ang Vice Presidente ng confidential funds, ipinunto ng prosecution na walang anumang dokumentong sumusuporta sa request, gaya po ng programa, proyekto o aktibidad na may kaugnayan sa national security at peace and order. Kahit Agosto nag-request, Setyembre na naaprubahan ng Vice at naisumite sa DBM ang Physical and Financial Plan. Kinumpimayan ni Ortonio. Tinanong din si Ortonio tungkol sa paggamit ng confidential funds para makabili ng supplies, gaya ng pagkain at gamot, lalo na't may pondo naman ng OVP para sa ganoong programa. Ang kay Ortonio, mga informant ang bumili ng mga ito gamit ang ibinigay ng confidential funds. Ang patunay raw ay mga acknowledgement receipt. Lumabas din sa paglilitis na alam ng Vice Presidente ang tungkol sa confidential funds mula sa pag-request, pagtalaga ng halaga, hanggang sa pag-aproba sa release, liquidation at certification ito. At dahil dyan, tinawag ng prosecution na arkitekto at mastermind umano ng paggamit ng confidential funds si Vice President Duterte. Tumutol o nag-object ang depensa sa pahayag at ipinatanggal o ipina-strike off sa record ng korte ang pahayag na ito. Sa huling bahagi ng direct examination, nagreklamo ang depensa sa mga pananalitang ginagamit ng prosekusyon gaya ng scam at mastermind. Humingi ng paumanhin ang prosekusyon at sinabing gusto lang daw nilang ilarawan ang umano'y nangyari bilang calling a spade a spade. At katulong po natin sa pagbabantay sa Senado si Joseph Morong. Joseph, good morning.
Good morning, Pia. Day 19 tayo ng impeachment trial laban kay Vice President Sara Duterte. And just as a brief summary nung testimony nitong si Ortonio, who is the OVP Deputy Chief of Staff. Kasi paalala muna natin sa ating mga kababayan, ang pinag-uusapan natin dito, Article 1, yun pong alleged misuse and misappropriation o hindi wastong paggamit ng confidential funds. So narinig na natin yung dalawang opisyal ng Office of the Vice President kung paano ginastos yan. So kahapon, doon sa testimonya nitong si Ortonio, lumabas na si Vice President Duterte knows, alam, authorized, pinayagan, at nasa kanyang supervision yung lahat ng nangyari doon sa 500 million na confidential funds ng Office of the Vice President in terms of request, paghingi, release, paglalabas ng encashment ng mga cheque, at saka yung spending, paggastos, kasama na dyan yung pagbabayad dun sa mga umano'y kaduda-duda mga tao tulad nila Mary Grace Piatos, at yung liquidation ng pondo na yon, yung report nila sa Commission on Audit kung paano nila ginamit yung pondo na yan from 2022, fourth quarter, first, second, third quarter of 2023. Sabi nga ng prosecution, scam. Pagsasalarawan nila dyan, scam, at ang arkitekto niyan ay si Vice President Duterte na syempre yung mga ganyang comments ay stricken off the record ng Senate Impeachment Court. Ngayon, si Ortonio yesterday, may bagong impormasyon siya doon tungkol sa kung paano naggastos yung pera. Apparently, according to him, and based on the report of Colonel Lachica and Gina Costa, yung pera na ibinayad nila sa informants at saka sa mga agents ay sila na yung bimili. Nung nakita natin ang mga resibo ng mga medicine, food aid, mga chairs, computer tables, at chairs, computers, and saka mga tables. So sabi, kaya walang official receipts kung saan binili yung mga gamit na yon ay dahil yung mga confidential informants and agents na yung bumili nun dun sa mga confidential activities. Ngayon, sinabi naman ni Presiding Officer Chis Escudero na tatalakayin muna nila bago yung cross-examination nitong si Ortonio ng defense, yung issue ng sub judice. Nagreklamo kasi yung defense dun sa pinost nitong si Private Prosecutor Attorney Virgil Ligutan tungkol dun sa aspect ng pinapayagan ba yung misleading questions during the trial. Ngayon, nakausap natin itong si Attorney Ligutan at tinanong natin in broad strokes kung paano yung magiging paliwanag niya sa Senate Impeachment Court. Narito ang kanyang payag. In broad strokes, how are you going to maybe justify what you said, what you posted?
You will hear from me in like 30 minutes. You will hear from me.
Kadi lang. Paano yun? Broad strokes lang.
I'm a teacher. That's what I do. I teach.
Okay.
I stopped teaching. And then I miss my students. If you see something, if you sense a mistake,
okay,
you correct it on Facebook. Your own Facebook account. It's about what the rules are saying. I'm talking to my students.
Doon naman sa aspeto ng prosecution, kung ipipresenta pa nila itong si Colonel Dante Lachica na parang ang gusto ng mga senador ay gustong marinig itong si Lachica kasi siya yung itinuturo nitong si Gina Acosta and even itong si Ortonio. Narito ang paliwanag ni Congressman Joel Chua kung bakit malamang ay hindi na nila ipresenta itong si Colonel Lachica. And nakausap natin kanina si Attorney Lorna Kapunan, and the decision of the prosecution panel is hindi na nila kailangan itong si Colonel Lachica. Narito ang pahayag ni Congressman Chua.
Yun yung nakakatakot Hindi mo alam kung ano yung nasa isip nila di ba? At the end of the day, hostile pa rin siya. Nasa kabila pa rin siya. So hindi mo alam kung ano yung, kung magsasabi ba talaga ng totoo o hindi. Nakita na natin yung naging statement nila Acosta Masyadong evasive, masyadong parang may script silang ginagawa rin.
And I want to bring in si Attorney Reggie Tongol about several matters. Unang-una na sir, good morning.
Magandang umaga sa inyo.
Aspeto ng sub judice. You mentioned yesterday, dapat kahapon, but hindi na tuloy, no? But today na talaga, yung ruling. When we say ruling, ano ba to? May papagalitan ba or slap on the wrist lang?
Well, unang-una, kailangan kasi linawin. Ano ba yung sakop nung sub judice na yun under Rule 18? What are considered talking about the merits? So, isa yan sa kakalaruhin ng ating presiding officer. Pangalawa, sino ba yung mga covered na yun? Pangatlo, yung mga penalties. In case lumabag ka ng Rule 18, di ba? Maraming haka-haka na maraming nagtatanong sa atin anong i-a-apply. So, kakalaruhin na yan ni presiding officer. At yung panghuli dyan, syempre yung mga nangyari in the past few days, no, kailangan yung magkaroon ng ruling on the proper decorum of parties, yung sa mga pagbabansag ng mga terminolohiya na hindi pwede o characterization, yung kunwari sinasabi mo na scam or magnanakaw, yun kasi kahit na yun ang sinasabi ng prosecution, no, na calling a spade, however in a court trial, in a strict court trial, you cannot call a spade until you have proven the spade is actually a spade.
Okay.
So kailangan munang magkaroon ng nexus na ganon. At yung burden of proof na yun na nasa House Prosecution Panel, that's why those kinds of words have been stricken out and considered impertinent by the impeachment court.
I think that's a good point for you to turn over you to Pia kasi yan yung mukhang laying down the ground.
Yes.
Parang ground rules muna tayo.
Correct.
Pia.
Alright, good morning Attorney Tongol. Maraming salamat sa pagsama ulit sa amin ngayong umaga. Pero balikan ko lang muna, Joseph, yung nabanggit mo kanina. So hihingan rin natin ng komento ang depensa doon sa naging pahayag na yan ni Congressman Joel Chua. Pero going back to yung pinag-uusapan ninyo ni Attorney Tongol, Attorney, sabi niya, you cannot call a spade until you prove that it is a spade. Of course, that is in court. Pero outside the court, may pagmamonitor din ba? Kasi technically, yung impeachment court, the prosecution spokesperson and the defense spokesperson, pwede rin naman nilang sabihin kung anong gusto nilang sabihin because it's outside of court. Pero ito rin ba ay minomonitor pa rin dapat?
tama ka dyan, Pia, no? Dahil kasama sa aming obligasyon bilang mga abogado, sa aming Code of Professional Responsibility and Accountability, yung Canon 2, Section 19, nakalagay dyan that as a lawyer, you cannot try your case in court. Ibig sabihin, bawal ang trial by publicity. Kahit na ito ay sinasabi natin na sui generis case, no, at saka medyo political case din to, hindi lamang purely legal, still by having those two rules, Canon 2, Section 19, at saka yung Rule 18 na inilagay yon ng Senado nung mga panahon pa ng era of impeachment, by having those two rules, kailangan i-apply yon. And tama ka na minomonitor ng impeachment court yung mga sinasabi ng ating mga parties, pati ng mga counsel sa labas ng korte. At yung nabanggit na yun ni Presiding Officer, baka mamaya may pagbanggit ng mga ilang mga statements na yan doon sa kanyang ruling.
So kumbaga, duly warned na po sila even before lumabas yung sub judice ruling ni Presiding Officer Chis Escudero. Attorney Tonggol, kahapon po nagpahayag ng concerns si Majority Floor Leader Mig Zubiri tungkol sa calendar ng Senado. Kailan ba natin maaasahan ang final decision tungkol sa magiging takbo ng trial, ng schedule ng impeachment trial? Although sinabi po ni Presiding Officer Chis Escudero that he's fairly confident na bago matapos ang taon ay matatapos rin yung paglilitis.
Yes, as I was saying, no, there are 102 witnesses na nakasalang para sa prosecution at saka sa depensa. At sa 102 witnesses na yon, 90 days yon tatalakayin ng korte or 7.5 months. Hindi pa dyan kasama yung mga delays, etc. So it can go until mga March, no? Pero ang expectation ng presiding officer is katulad ng mga nangyari before sa previous impeachment trials, that there will be witnesses that will be dropped because they are just corroborating witnesses. At dahil doon sa kanyang presumption at expectation na gano'n, ay Desyembre ang kanyang ini-expect na katapusan ng impeachment trial na nalalatagdan ng depensa rin yung kanilang panig. So kasi syempre kailangan tapusin din ng ating Senado yung kanilang legislative matters. Kaya dun sa schedule na yan, malalaman natin kapag naglabas na ng schedule kung kailan yung mga budget deliberations ang Committee of Finance ng Senado, at doon ipaplat ng ating Senate President at ng Presiding Officer ano yung mga araw na dapat sa hapon, dapat sa umaga. So maaaring magkaroon tayo ng mix na schedule at meron din sigurong possibility para ma-meet lamang yung expectation natin na Desyembre matapos, na magdagdag ng mga ilang araw aside from just 3 days, baka gawing 4 na araw o 5 araw pa.
Alright, Impeachment Court Spokesperson Attorney Reginald Tonggol, maraming salamat po sa inyong panahon, at syempre maraming salamat din sa ating kasamang si Joseph Moro. At sa punto ito, balikan po natin ang ating diskusyon kasama si Professor Paulo Tamase, Associate Dean ng UP College of Law. Professor, muli, good morning.
Good morning ulit.
Narinig niyo po yung sinabi ni Attorney Liguta na sabi niya he will try to explain, if given a chance, yung kanyang naging aksyon noong August 12 na nag-post siya habang ongoing yung trial na misleading questions are not allowed. Sabi niya, well, he's a teacher. He's a professor, kaya parang bahagi daw ito ng kanyang pagtuturo na mag-post sa social media.
Well, with the full disclosure na si Attorney Ligutan is our colleague sa UP, I think to that extent, bilang isang guro, minsan may tendency talaga to also teach at every opportunity you can. But I think, as with any of the prosecution lawyers, any of the defense lawyers, for this trial, they are prosecutors, they are defense lawyers. And I think sa kahalagahan nitong trial na ito, mas importante na maalala nila na yun yung role na ginagampanan nila ngayon, not yung side roles nila as teacher or whatnot. That said, maraming punto itong trial na ito na parang nagiging tungkol doon sa mga abogado. Yung nakukuha nila na mga nasasabat nila na points, no, or yung mga sound bites na naibibigay nila, yung lagi na lang towards the end of a trial date may nagsasagutan yung dalawang sides, no, kung ano-anong admin issues yung meron sila. On the part of the prosecution especially, hindi yun yung resulta na gustuhin nila dapat. Kasi the longer this trial drags on, or the longer or the likelier na yung trial ay nagiging tungkol doon sa mga abogado, mas mahirap for the public to focus on the real issue here, which is yung accountability ng Vice President. So it doesn't really help them, especially in the long run, if ang naaalala natin ay kung anong snappy TikTok phrase yung nasabi ni Lawyer A or ni Lawyer B, instead of kung ano yung ebidensya na nailabas ng araw na iyon.
Isa rin dun sa nabanggit ni Joseph sa kanyang report yung pahayag, or nakita rin natin yung pahayag ni Congressman Joel Chua na mukhang wala na talaga silang balak na ipatawag bilang testigo si Colonel Lechica dahil nga sabi nila hostile witness, hindi nila alam kung anong sasabihin. So I suppose aabangan natin kung yung depensa naman ang gagawa nito kasi may posibilidad na sila rin ang gagawa nito.
Yes, and I think really yung burden falls with them. If malinaw yung prosecution evidence at paulit-ulit na may issue, yung liquidation ng pondo, yung pagpapaliwanag kung tama yung spending doon, nagiging burden ngayon ng depensa. So kung si Colonel Lechica yung makapagpapakita kung saan talaga napunta yung pera, na hindi ito nabulsa, na naibigay talaga siya sa informant, then parang it suggests na may dahilan yung depensa to call him.
Sergeant of Arms is directed to make a proclamation.
All persons are commanded to keep silent under pain of penalty while the impeachment court is in session for the trial of Vice President Sara Duterte.
The impeachment trial of Vice President Sara Duterte is hereby called to order. We should be led in prayer by Senator Judge Mark Villar.
Let us put ourselves in the presence of God. Heavenly Father, we come before you today, seeking your guidance and wisdom. Align our hearts with yours and our plans with your purpose. Grant us the wisdom to discern absolute truth from partisan noise. We ask for that generous wisdom, Lord, so we can make decisions that reflect your love and justice. Clear our minds so that we can make fair and righteous rulings in this impeachment trial. May we always lean on your understanding and not our own. Provide us with the courage to rule with strict impartiality, ensuring fairness to both the accused and the people we serve. May our decisions honor the Constitution, uphold the rule of law, and preserve the integrity of our nation. Guide us in humility, compassion, and integrity as we serve, knowing that we are accountable to you above all. In Jesus' name we pray. Amen.
Amen. The clerk of court will now call the roll.
Roll call of members. Senator Judge Aquino. Senator Judge Cayetano Alan. Senator Judge Cayetano Pia. Senator Judge De La Rosa. Senator Judge Ejercito. Senator Judge Estrada. Senator Judge Go. Senator Judge Ontiveros. Senator Judge Lacson. Senator Judge Lapid. Senator Judge Legarda. Senator Judge Marcoleta. Senator Judge Marcos. Senator Judge Padilla. Senator Judge Pangilinan. Senator Judge Soto III. Senator Judge Tulfo Erwin. Senator Judge Tulfo Rafi. Senator Judge Villanueva. Senator Judge Villar Camille. Senator Judge Villar Mark. Senator Judge Zubiri. The presiding officer, Senator Judge Escudero. The Senate President, Senator Judge Gatchalian.
With 17 senator judges present, the chair declares the presence of a quorum. In accordance with the rules of procedure on impeachment trials, the chair now recognizes the duly elected presiding officer to preside over the proceedings of the impeachment court.
Thank you, Mr. Senate President. If there are no objections, we shall dispense with the reading of the August 25, 2026 Journal of the Senate Sittings on Impeachment Court and shall consider the same as approved. The clerk of court will please call the case before the impeachment court. Kindly turn on the mic of the clerk of court.
Case number 004-2026 in the matter of impeachment trial of Vice President Sara Duterte.
Appearances of for the parties.
Same appearance for the prosecution, Your Honor. We are ready.
Good morning, Honorable Chua. For the respondent.
Same appearance for the respondent accused. Good morning, Your Honors.
Good morning, Attorney Poa. As discussed yesterday by the presiding officer, we shall begin with a brief reply of Attorney Ligutan before the court's ruling with respect to the points raised by the lead counsel for the respondent and some other matters that pertain similarly to that topic, and then proceed with the cross-examination of Attorney Christine and the redirect and or recross, if any.
Your Honor.
Yes, Honorable Chua.
I will now turn over to Attorney Ligutan for his brief reply.
Attorney Ligutan is recognized
Your Honor.
for his hopefully brief reply. Yes, Attorney Boa.
Just before we give Attorney Ligutan his time, Your Honor, just wanted to make a quick manifestation. It was just brought to our attention yesterday that after the proceedings that we had yesterday, that an interview was given wherein I think what was discussed yesterday about the word scam, etc., was repeated during an interview. Now, while it may have been stated in a matter that's sort of a matter-of-factly, we do hope that this will be included in the ruling of the Honorable Presiding Officer.
It
at
is
least for
included,
guidance, Your
actually,
Honor.
Attorney Boa.
Thank you, Your Honor.
Yes, Attorney Ligutan.
Hello. Is this working? Hello.
You are recognized, sir. You may proceed when you're ready with respect
so
to
much.
your, shall
It's
I call
brief.
it, counter manifestation.
It is brief, Your Honor.
Thank you, Attorney Ligutan. You may proceed.
A teacher, a lawyer, a rule on cross-examination, a Facebook post. How did we get here? Last August 12, before trial was adjourned, it was a Wednesday. Out of the blue, the defense made a manifestation, or should I say, a big issue of my Facebook post earlier that morning. My post reads, a principle all lawyers and law students know by heart. Misleading questions are not allowed, even on cross-examination. Period. The defense surmised it is a reaction to that viral exchange between the opposing counsel that morning. A lawyer for the defense said, in effect, that misleading questions are allowed. We all heard it. It immediately caused an uproar on social media, especially in the legal community, where it is a well-entrenched rule that misleading questions are not allowed, even on cross-examination. It is a truism as irrefutable as the sun rising in the east and setting in the west. It is a principle all lawyers and law students should know by heart. But why post it on Facebook? Your Honors, why not? Yes, I am a lawyer. But more than just a lawyer, first and foremost, I am a teacher. Isa po akong guro. Usa ko kang maestro, and I'm proud to be one. I have been a lawyer for almost 16 years, but I have been a teacher, an educator for almost 20. At alam ng ating mga magigiting na guro sa buong kapuluan na ang pagtuturo ay likas sa ating mga guro. Ang pagtuturo, ang pagtatama ng mali, ay walang pinipiling lugar at walang pinipiling panahon. That's why I made that post. I was concerned that the statement made in open court that misleading questions are allowed will go unchecked. My teacher's instinct kicked in. I wanted the students I left in Cebu, especially in the University of San Jose Recoleto School of Law, where I have been teaching for the past 15 years, and recently in the University of Cebu School of Law, and in Diliman, my alma mater, the University of the Philippines College of Law, and all law students out there, I want them to know that a teacher had heard that wrong statement in open court, and he is correcting that mistake on Facebook, as I have been doing the past years. To the defense, I shall not name names. I will not put you on the spot. But the post is not about you. It's not personal. It is about the law that we all adhere to. It is about what we teach the public who are watching our trial. Correcting a mistake is never wrong. Doing it while a hearing is ongoing online does not make it not right. Ang pagtatama ng mali ay kailanman hindi ipinagbabawal kahit sa loob ng impeachment court ito. Now the defense said they found it troubling or in bad taste for a prosecution lawyer like me to, quote, do this, unquote, in the middle of a courtroom hearing. But do what? Correct a wrong? On the contrary, Your Honors, what is more troubling is for the defense not to admit their mistake and instead call out a lawyer, a teacher who just stated what is correct in his own time and in his own Facebook account. What is troubling is if we turn a correction of a mistake by one side into a shield from fair criticism for the other. Now the defense is asking this court to act on my post. It is elevating it to a serious courtroom violation. But what did I violate? I did not discuss the merits of the case. I did not discuss the strength or the weakness of the oral arguments or evidence of either side. I only stated, without mentioning any name, using the most neutral of font color and background, black and gray, without adding any emoticon, without splicing anything. What the rules of procedure simply provide, that misleading questions are not allowed, even on cross-examination. Your Honors, we in the prosecution also have rights. I, for one, did not surrender my freedom to teach and to enlighten when I decided to participate in this trial. Patuloy po ako magiging guro kahit sa loob ng impeachment court na ito. Lastly, Your Honors, the defense mentioned humility, that I should have been humble enough not to post that now viral statement. Your Honors, being a provinciano from Leyte, Samar, and Cebu, and coming from a middle-income family born without a famous family name, who had to compete for his spot in this capital, I know a thing or two about humility. The defense cannot lecture me on humility. If there's somebody who needs to be reminded about humility, it's them, the defense. It is the opposite of humility. It is pride, not to admit a mistake, or worse, call out someone who simply corrected that mistake. Good morning.
That does not fall under my definition of brief, counsel, but we will take it nevertheless. For the record, before the chair makes its ruling on these matters, the TSN says, Attorney Kapunan, leading, and then she corrected herself, misleading questions are not allowed on cross. Attorney Ferrer, she said they are allowed. Now, the TSN cannot possibly cover the overlapping voices, if at all. So most likely what happened, although we will check the video, would be Attorney Ferrer commenting on the earlier statement that was corrected later on by Attorney Kapunan and changed leading to misleading. Perhaps Attorney Ferrer was referring to leading questions and not misleading questions. But having said that, nevertheless, the court will include that as part of its ruling, with one caveat, Attorney Ligutan. While you do not remove your hat as a teacher wherever you go, the same is true with this representation. I had my fair share of teaching as well. Under the rules of the Senate, unfortunately, you have to unbundle it. You have to decouple it. Under the rules of the Senate, if you are counsel for the parties, you cannot comment on the merits outside of a fair and true report of what happened. In this case, based on the TSN, I am not sure of the accuracy, given that the statements made were pertain to both leading and misleading questions. Number two, it still does not take away, your being a teacher, does not take away your responsibility under the CIPRA to a fellow lawyer who you are jousting with or arguing with or competing against this impeachment court. The remarks of the good gentleman, the Attorney Ligutan, the counsel for the panel of prosecutors, is noted and it will be entered into records. Thank you, sir. Chair will now make its ruling with the permission of the body from the rostrum, because it's difficult to read while sitting down a long ruling. You may sit down, Attorney Chua, for a bit. This will take some time. With the permission of the Senator Judges, the Chair wishes to address certain matters as it is necessary to protect the integrity of this trial. It has come to the Chair's attention over time that public statements attributed to persons covered by the rules on impeachment, whether made in interviews or in social media, appear to concern the evidence, the credibility of witnesses, and issues pending before this court, which may fall within the prohibition under Rule 18 of this court. Although the immediate matter arose from statements and conduct involving respective counsel last August 12, it raises broader concerns affecting the impartiality, decorum, and integrity of the impeachment court. Before imposing or enforcing standards of restraint upon the parties and their own counsel, the court must first look inward and put its own house in order. The Chair shall therefore resolve these matters in three parts. First, the duties of impartiality and decorum incumbent upon senator judges. Second, the scope, coverage, and prospective enforcement of Rule 18. Third, the specific guidelines governing compliance with Rule 18. First, senator judges' impartiality, decorum, and the internal remedy. The Chair begins where institutional discipline must always begin, with the court itself. The restraint, impartiality, and decorum demanded of the parties and their counsel must first be exemplified by those who sit in judgment. As senator judges, let us keep in mind our oath, quote, to do impartial justice according to the Constitution and the laws of the Philippines, close quotations. And the requirement under Rule 3 of the Rules of Impeachment to observe political neutrality therein defined as, quote, the exercise of a public's official duty without unfair discrimination and regardless of party affiliation or preference. The chair likewise cites the relevant provisions of the 2025 Code of Judicial Conduct and Accountability, or CIPRA, on impartiality and the sub judice rule. Canon 3, Section 10 provides, quote, "During the pendency of a case, a judge shall not knowingly make any comment in and out of court that could reasonably be expected or perceived to affect its outcome, impair the fairness of the process, or diminish the public's confidence in the court's impartiality." Canon 4, Section 24 provides, quote, "A judge shall not engage or use any form of expression which tends to violate or has the effect of violating the sub judice principle, provoke or inflame divisive and contentious issues of public concern, or project an image not compatible with the dignity of their position." Taken as a whole, these principles remind us of our duty to preserve the impartiality of this court and the fairness of these proceedings. As the court said in People v. Court of Appeals, GR number 118882, this court has repeatedly and consistently demanded, quote, "the cold neutrality of an impartial judge as the indispensable imperative of due process. Judicial proceedings are not orchestrated plays in which the parties are supposed to make motions and reach the denouncement according to a prepared script. There is no writer to foreordain the ending." Close quotation. Also in Berso versus Rabe, AM number RT 21010, "A judge must not only be impartial, but must also appear to be impartial, as an added assurance to the parties that his decision will be just. Litigants are entitled to no less than that. For avoidance of doubt, this shall not prevent senator judges from examining the evidence where the examination belongs during the proceedings and on the record. The Supreme Court in People v. Gambor, GR 152183, said, "The trial judge is accorded a reasonable leeway in putting such questions to witnesses as may be essential to elicit relevant facts, to make the record speak the truth. A judge may examine or cross-examine a witness. He may propound questions to test the credibility of the witness and to extract the truth. He may seek to draw out relevant and material testimony, though that testimony may tend to support or rebut the position taken by one or the other party. It cannot be taken against him if the clarificatory questions he propounds happen to reveal certain truths which tend to destroy the theory of one party." Taken together, Rule 17 and the Gambor case confirm that a searching question is not partial merely because the answer may aid one side or weaken the other. The prosecution and the respondent's counsel must be prepared to answer such questions. The inquiry must remain relevant, material, fair, and directed toward clarification of truth. It must not devolve into a speech, harassment, partisan advocacy, or an announcement of a conclusion already reached. The line is clear. Senator judges may test the evidence here under oath and on the record, exercising the cold neutrality of an impartial judge. When constituted as an impeachment court, the Senate does not cast aside the discipline of parliamentary practice. Except where the specific rules on impeachment or the adjudicative nature of these proceedings require otherwise. The rules of the Senate establish parliamentary precedents and courtesies of the chamber continue to bind every member sitting as senator judge under Rule 34, Sections 93 and 94 of the Rules of the Senate. Deem acts or language that offend a senator or any public institution or third party to be unparliamentary and prohibit the use of offensive and improper language against another senator or public institution or third party. Henceforth, I hope senator judges shall refrain from unparliamentary remarks, personal attacks, imputations of improper motive, and other language incompatible with the dignity of these proceedings and of parliamentary courtesy to other people. The chair will at all times extend to his fellow senator judges the courtesy befitting equals and reasonable latitude that serious deliberation requires. Differences in judgments and vigor in debate are to be expected and shall, as far as practicable, be met with patience, flexibility, and respect. Should circumstance so require, however, the chair will not hesitate to enforce the rules of this impeachment court, the rules of the Senate, particularly sections 95 and 96, in this chamber, firmness need not be unkind, nor courtesy come at the expense of duty. Both serve the same end, the fair and honorable administration of justice. Further, where a senator judge is alleged to have violated the impeachment oath, Rule 3, Rule 18, or any other applicable rule of the Senate, an available institutional remedy within the Senate is the filing or referral of an ethics complaint to the Senate Committee on Ethics and Privileges in accordance with the internal rules of the Senate. Under Rule 10, Section 1316 of the Rules of the Senate, the Committee on Ethics has jurisdiction over all matters relating to the conduct, rights, privileges, safety, dignity, integrity, and reputation of the Senate and its members. Any disciplinary action remains for the Senate to determine under Article 6, Section 16.3 of the Constitution and applicable rules. This shall not be a proper subject matter to be taken up within this impeachment court so as not to divert the attention from the impeachment trial against the respondent in this case. Accordingly, the chair reminds all senator judges, first, to observe the impartiality and political neutrality required by their oath and the rules. Second, to observe the parliamentary rules, precedents, and courtesies of the Senate and refrain from unparliamentary, offensive, or improper remarks. Third, to exercise their authority under Rule 17 to question witnesses, prosecutors, and counsels for the respondent and the prosecutor during the proceedings on the record instead of through commentaries in social media. Second ruling, Rule 18, scope, coverage, and prospective enforcement. Note on the statement, prospective enforcement. Having addressed the conduct expected of senator judges, the chair now turns to Rule 18 and the persons expressly covered by it. The chair makes this ruling not only in response to the manifestation and motion made by counsel for the respondent, Attorney Sheila Sison, on August 12, and after due consideration of Attorney Ligutan's explanation, but also on the basis of the chair's independent findings of seeming violations of Rule 18. These incidents come after the chair's earlier advice to both panels to designate the respective spokespersons so that the necessary and appropriate communications may be made within the limits prescribed by the rules. Since that advice has not been fully observed, the chair now finds it necessary to restate and strictly enforce those restrictions. Article 18 of the Rules on Impeachment provides, the presiding officer, the members of the Senate, shall refrain from making any comments and disclosures in public pertaining to the merits of a pending impeachment trial. The same shall likewise apply to the prosecutors, the person impeached, and their respective counsel and witnesses. This rule exists to balance the public's right to information on matters of public concern with the need to protect the integrity of the proceedings from public prejudgment. The rules of court apply only suppletorily to these proceedings. When the rules on impeachment expressly and specifically govern a matter, they control. Since Rule 18 directly governs public comments and disclosures pertaining to the merits of the pending impeachment trial, it is for this court, in the exercise of its authority and sound discretion, to determine whether a particular statement violates that rule. Henceforth, with respect to prior statements or conduct covered by Rule 18, the court shall extend grace, exercise liberality, and wipe the slate clean, tabula rasa, so to speak. From this point forward, however, Rule 18 shall be strictly enforced and be given full force and effect. Accordingly, the chair hereby strictly enjoins all persons covered by Rule 18. You know who you are, and based on the records, we know who you are. From making public statements or otherwise discussing, sharing, or endorsing comments pertaining to the merits of this pending impeachment trial, and from engaging in trial by publicity, as they directly threaten the independence of the court, degrade the dignity of the tribunal, and risk turning it into a circus, and weaponize the media to substitute public outrage or actual evidence. We are in receipt of the appearances of the parties. So, ang covered po ng Rule 18 would be all those who appeared, both from the panel of prosecutors and the counsel for the panel of prosecutors. Chair earlier reminded the parties, designate a specific spokesperson. Wala pong problema kung hindi naman siya kasama sa panel. Walang problema kung hindi siya kasama sa counsel for the panel of prosecutors. The spokespersons are free to say whatever they want to say, but not, and there are limitations insofar as the panel of prosecutors and the counsel for the panel of prosecutors is concerned. Clearly, up to today, the spokesperson of both parties are still part of the counsel for the parties, some with more violations than others. So without enumerating the counsels where this rule applies, I think you know who you are, given the entries of appearance you've already made. These restrictions apply with particular force not only to counsel for the parties, but also to us, senator judges, and all other persons whose public statements are governed by Rule 18. Rule 18 makes specific mention of the respondent. It does not make mention of the complainants in this case, given the public nature of this case. So outside of the senator judges, outside of the counsels for the parties, particularly mentioned would be the respondent herself, as well as the witnesses called. Third ruling, guidelines for compliance with Rule 18. To ensure a common standard, the chair now states the guidelines governing compliance with Rule 18. That line is crossed when a public comment by any person covered by Rule 18 falls within the phrase, quote, pertaining to the merits. In this regard, jurisprudence has consistently distinguished matters going into the merits of a case from those which are merely procedural, incidental, or collateral. In De Leon versus Deliana, GR 21-2277, as a technical legal term, merits has been defined in law dictionaries as a matter of substance in law as distinguished from matter of form, and as the real or substantial grounds of action or defense, in contradistinction to some technical or collateral matter raised in the course of a suit. In Badoy versus Magdoza Malagar, AM number 220916 SC, comments on the merits of the case may refer to the credibility of witnesses, the character of the accused, the soundness of alibis offered, the relevance of the evidence presented, and generally any other comment bearing on the guilt or innocence of the accused. Pursuant to the en banc case of INRE published threats hurled by Attorney De Vera, AM number 011203 SC, number 1, no party shall make public comments, statements, insinuations, or rhetorical questions that, number 1, prejudge the issue to predict the outcome of the trial. Number 2, question pending rulings. Number 3, substitute media pressure for evidence. Number 4, promote distrust and undermine public confidence in the court by creating the impression that the court cannot be trusted to resolve the case impartially and violate the right of the parties to have their case tried fairly by an independent tribunal uninfluenced by public clamor and other extraneous influences. For purposes of this trial, a statement pertains to the merits when viewed in the full context. It evaluates in its full context. It evaluates a disputed fact, the credibility of a witness, the relevance or probative value, weight, or sufficiency of a particular evidence, assessment as to the legal viability of an article of impeachment, or a substantive defense advocate's a particular disposition of the charges or announces or forecasts the ultimate vote. Conversely, this court recognizes the qualified privilege of a fair and true report regarding these proceedings as affirmed in the Supreme Court in ABS-CBN versus Ampatuan GR number 227004. Based on the jurisprudential standard derived from Article 35 of the Revised Penal Code, a fair and true report means a neutral, objective, and accurate recounting of the proceedings made in good faith without any comments or remarks. For the guidance of all the parties concerned, the Chair now issues the procedural guidelines for violations of Rule 18. The Impeachment Court will exercise its powers summarily under Rule 5, adhering strictly to the due process parameters set by the Supreme Court. First, a 24-hour show cause order. No oral accusation or press pronouncement shall precede the formal charge. Any party cited for a particular violation will be issued a written show cause order, either motu proprio or upon motion by either party, and will be given exactly 24 hours to submit a verified written answer. Pursuant to the Supreme Court's en banc doctrine in Zaldivar versus Sandigan Bayan, GR number 79690-707, due process in disciplinary proceedings against lawyers and parties does not require a trial-type formal hearing. The presiding officer will rule summarily based solely on the submitted pleadings upon the lapse of the 24-hour period, subject to appeal or reconsideration by any member of the court. Now, the burden of proof. Pursuant to Stratcom Corp. versus Etong, GR number 190980, and Webb versus Gatula, GR number 194469, any punitive sanction requires this court to find that, quote, a person's act must be done willfully or for an illegitimate or improper purpose. Thus, the good faith or lack thereof of the person being cited in contempt should be considered. Hence, the contemptor is presumed innocent, and the burden of proving that the contemptor is guilty of contempt lies with the movant. For violations of Rule 18, the court shall follow a two-strike rule. Violations will be met with a strict graduated penalty system. First offense, public reprimand and admonition. The penalty is a severe reprimand and stern admonition in open court, placed permanently on the record as a final warning. Second offense, a monetary fine. The penalty, pursuant to the prescribed ceiling under Rule 71, Section 7 of the court will impose a maximum statutory fine of 30,000 per violation, pesos that is. Furthermore, exercising the court's inherent case management powers under Rule 4, 5, 6, and 8, to preserve the orderly proceedings, the offending lawyer or party may also be subjected to a defined prospective restriction on speaking, objecting, or examining witnesses on the floor. Each subsequent violation of Rule 18 shall be punished the same way as a second offense, third, fourth, so on, with a fine of 30,000 pesos. In all cases wherein a member of the bar is concerned, independently, pursuant to the case of Inre Almacen, the certified incident record will be transmitted and formal referral will be made to the Office of the Bar Confidant, the Integrated Bar of the Philippines, and/or the Supreme Court for possible disciplinary sanction regarding the person's license to practice. The court also reminds respective counsels of the parties that CIPRA Canon 2, Section 19 prohibits lawyers to comment or publicize opinion pertaining to a pending proceeding in a manner that may cause prejudgment, sway public perception, influence the tribunal, or create a widespread perception of guilt or innocence. CIPRA likewise requires professional responsibility on the use of social media and prohibits the dissemination of false or unverified claims or disinformation. Rule 18 does not, by its terms, cover outside observers or spokespersons who are not counsels of record. Such persons, however, remain subject, when applicable, to the rules on indirect contempt, and if they are members of the bar, to the CIPRA. Counsel of record must litigate their respective causes before the court, not in the court of public opinion, through interviews, social media posts, or publicly generated, authorized, encouraged, or disseminated through surrogates. Counsel cannot have their cake and eat it too. They cannot invoke the authority of this court while simultaneously seeking to influence the proceedings through extrajudicial publicity. In fact, the chair has in its hands certain statements to cite as examples, without naming names, but you know who you are, who mentioned these quotes. Quote, hindi naman pinag-uusapan dito yung kontrata, pinag-uusapan dito yung banta. Yung banta, nakita nyo sa video, may nagbanta talaga at si Vice President yun, hindi ba? If this was stated by a spokesperson or any third-party observer, it would not have been a problem. But this was stated by a counsel of record. Actually, more specifically, one of the counsels for the private prosecutors. Quote, the country witnessed what I have been saying all along. The complaint is not supported by evidence. An impeachment proceeding should be grounded on credible evidence, not speculation, manufactured narratives, or unsupported allegations. The rule of law depends on facts, not fiction. Quote, Meron ba talagang kinausap na mamamatay tao? Meron ba talagang mamamatay tao? Napakaliwanag na ho sa sagot dyan. Meron. Ano ho ang prueba natin? Yung tinatawag na admission against interest ng Vice President. Again, to reiterate, if this was stated by any other party or person, not a member of the panel of prosecutors, not counsel for prosecutors, not the counsel for respondents, it would have been perfectly okay. But since this was stated by one of those covered by Rule 18, it is covered by Rule 18. Quote, since na-establish na namin yung hinahanap namin doon sa talagang testigo lamang, 3 testigo lamang, finorgo na namin yung ibang mga testigo, na-establish na namin ang gusto namin i-establish sa Article 4. Quote, itong mga bank records don't lie. Hindi na ito pwedeng maspin. Yan at sabihin gawa-gawa lang ng prosecution ng gobyerno. Itong mga usapin na ang explained wealth ng Vice President. Quote, it is clear that the Vice President had a direct hand on this. She signed off to it. No, not just the use, but the way it was liquidated. Quote, yun pong binabanggit ni Attorney Capona na scam. Yun pa rin ho yun. Pagtingin ho namin na inilantad ngayong araw po na ito, yung pagiging scam, iskandalo nitong confidential fund misuse. Quote, malinaw din na sinasabi niya na hindi kailangan sabihin pa na ginamit ito para sa personal na paggamit ng Vice President, itong confidential funds na ito. Dahil sabi nga niya, nakalagay na yan doon sa joint circular. Quote, siguro naman, it's plain for everybody to see yung conclusion, no? Yung conclusion na tama ba yung pinagamitan ng confidential fund? Hanggang kailan ba yung pagpipikit mata natin sa isang bagay na napakaklaro naman? Quote, to be fair, let's wait for their defense if they have any or their evidence. But so far as we are concerned, our position, you violated the public trust. Fraudulent liquidation, so you have violated the law. You already betrayed the people's trust. Quote, sa totoo lang po, yung testimonya ni Ms. Acosta na nagsasabing si Pangalawang Pangulo Duterte mismo ang nagbigay ng utos na ibigay ang 125 kay Colonel Lachica. Sapat na ho yun doon sa pagpapakita ng maling paggamit ng confidential fund. Quote, to us, it's a scam that was masterminded by the Vice President. Again, these are statements that may be said by any third party, but certainly not by any of the counsel for the parties. I would like to give credit where credit is due as well. There are some counsel for the parties who have been very circumspect with their statements. And you also know who you are. After hearing these examples, no person covered by Rule 18 may reasonably claim uncertainty as to where the line is drawn. The statements read into the record are illustrative, not exhaustive. They are cited not to punish past conduct, but to give clear and fair warning of the standard that shall govern henceforth. As the Chair stated in my opening statement, the discretion entrusted to this court will be exercised with a steady hand, liberal where justice permits, but exacting where fairness, due process, and the integrity of these proceedings demand. Consistent with that commitment, the court will strictly enforce the restraint required of counsel outside the courtroom, while ensuring that within the courtroom, counsel are afforded reasonable latitude to present their arguments, challenge rulings through proper channels, and advocate their respective causes fully and fairly. This discretion does not require counsel to remain silent within the impeachment court. The Supreme Court ruled in ABS-CBN Corporation v. Ampatuan, as earlier cited, that the court recognizes that lawyers may criticize the courts and their decisions, subject to the responsibilities they bear as officers of the court. Such criticism, however, must be legitimate, made in good faith, and directed toward the proper administration of justice. Rule 18 closes the avenue of litigating the merits through interviews, social media, and the court of public opinion. It does not close the courtroom to legitimate advocacy. If counsel believes that the ruling is erroneous, that a proceeding has become unfair, or that conduct affecting the trial requires correction, the proper course is to bring the matter before the court where it may be heard, answered, and resolved on the record. Rule 18 demands restraint beyond these walls. It does not command silence within them. This court will not close the door to trial by publicity. Rather, this court will close the door to trial by publicity, but it will keep the courtroom open to the disciplined advocacy where evidence is tested, error is corrected, and justice is done. Within these chambers, counsel shall be afforded reasonable latitude to present their theory of the case and vigorously test the evidence. Emotions may run high and frustrations may arise in the course of adversarial proceedings, but neither excuses a departure from the restraint and decorum expected of officers of the court. The case of Navarrete versus Court of Appeals, GR number 124245, mirrors the exact situation that has transpired before the court. Quote, with respect to the words swindlers, plunderers, stupid, and bastards, uttered by private respondent in the course of her testimony, we are inclined to disagree that such language is too ignominious and degrading for a lawyer to say to a fellow lawyer in the courtroom. In Baltao versus Falsis III, AC number 14443, the court said, while a lawyer is entitled to present his case with vigor and courage, such enthusiasm does not justify the use of offensive, abusive language. Language abounds with countless possibilities for one to be emphatic but respectful, convincing but not derogatory, illuminating but not offensive. The latitude afforded to counsel is not a license to substitute inflammatory, intemperate, or undignified characterizations for proof. Consistent with the chair's earlier ruling, the term scam, mastermind, modus operandi, as used during the past proceedings, stands stricken from the record. Counsel remain free to advance the factual and legal theories underlying their positions, but they must do so through evidence, reasoned argument, and court-appropriate language, not through expressions that prejudge disputed facts, attribute wrongdoing not yet established, cast offensive personalities upon others, or needlessly inflame the proceedings. Language uttered in the presence of the court that amounts to disrespect, offensive personalities, or misbehavior that obstructs or interrupts the proceedings may, when the applicable threshold is met, be dealt with as direct contempt under the rules on impeachment, with Rule 71, Section 1 of the rules applying suppletorily. Whether or not such language rises to the level of direct contempt, counsel remain independently bound by the CIPRA to observe courtesy and civility and the use of dignified language in all their professional dealings, even as adversaries. This brings the chair to the relevant provisions of the CIPRA independently of Rule 18, Canon 2 of the CIPRA requires every lawyer at all times to observe respect and courtesy in personal and professional dealings. Canon 2, Section 2 further requires lawyers to act with courtesy, civility, fairness, and candor towards fellow members of the bar. These duties govern how counsel treat one another both in and outside the courtroom. Canon 2, Section 4 likewise requires dignified language in all personal and professional dealings and prohibits abusive, intemperate, offensive, or otherwise improper language, whether oral or written, and whether made through traditional, electronic, mass, or social media. For the avoidance of doubt, Rule 18 applies only to the persons expressly covered therein: the presiding officer, the senator judges, the prosecutors, the person impeached, and their respective counsel and witnesses. With respect to counsel, Rule 18 applies specifically to those who have formally entered their appearance before the impeachment court. Separately, when a spokesperson is a member of the bar but has not entered his or her appearance, the relevant provisions on indirect contempt under Rule 71, Revised Rules of Court, and when warranted, the CIPRA shall nonetheless apply to said person. In any case, this shall be without prejudice to any recourse to Rule 71, Revised Rules of Court, with respect to any person who may commit indirect contempt against the impeachment court not covered by Rule 18. Accordingly, the chair hereby declares, number 1, directing all persons covered by Rule 18 to refrain from making, sharing, endorsing, or otherwise amplifying any public statement concerning the merits of the pending trial. Counsel for both parties are further directed to observe the applicable provisions of CIPRA. Number 2, reiterates the chair's suggestion that each party consider appointing a spokesperson who is not a member of their legal team, or if they are, for it to be clear to them that these rules shall apply to them, given that they are counsel for the parties strictly. If the parties elect to retain their current spokespersons, the Rule 18 shall be strictly applied as to them. The court further advises respective counsel that the violation of this order may carry consequences separate from contempt. Where the same conduct appears to violate CIPRA, the chair may direct the clerk to transmit the certified copy of the pertinent order, transcript, and records to the Supreme Court or the Office of the Bar Confidant for whatever action the Supreme Court may deem proper. Such transmittal is a referral, not a finding or penalty of professional discipline. Disciplinary jurisdiction over members of the bar still remain with the Supreme Court. Further, for avoidance of, again, doubt, a referral through the Office of the Bar Confidant shall not rest on an alleged violation of Rule 18 standing alone. Such referral may concern other conduct outside of Rule 18 unbecoming of a member of the bar. The chair then issues this final warning: on any willful disobedience of this order, it shall be dealt with accordingly henceforth. The ruling prescribes the standards governing future conduct and does not by itself adjudge any identified person guilty of contempt or liable for a professional violation. The chair closes with separate reminders to the prosecution, counsel for the respondent, and senator judges. To the prosecution, the primary duty of a public prosecutor is not to convict, but to see to it that justice is done. This duty is expressly stated in Canon 2, Section 31 of CIPRA, and echoed in Attorney Francisco versus Attorney Zuniga Lagman, AC 13035. The prosecution's object must therefore be the just resolution of the case, not victory at all costs. This obligation governs not only the evidence and arguments presented before the court, but also counsel's conduct outside of it. To the respondent and her counsel, the corresponding duty of defense counsel is not to secure an acquittal at all costs. In People of the Philippines versus XXX, GR number 245926, the Supreme Court reminded counsel for the accused of their fiduciary duty to provide competent, efficient, conscientious, and diligent representation. Under the same reason, counsel for respondent must faithfully protect their client's constitutional and procedural rights, rigorously test the prosecution's evidence, and hold the prosecution to the burden of proof governing these proceedings, while remaining within the bounds of the law, ethics, and the lawful orders of this court. To my fellow senator judges, including this representation, the chair adopts the reminder in Webb versus De Leon, GR numbers 1234 and 1245. Quote, more than convicting the guilty and acquitting the innocent, the business of this court is to assure fulfillment of the promise that justice shall be done and is done, and that the only way for this court to obtain an acquittal, from the bar of public opinion. That obligation rests upon every senator judge to decide solely upon the record, under the Constitution and under our rules, and in a manner worthy of the confidence of the people to whom this court is ultimately accountable. Thank you, and we may proceed with the trial at hand. Sorry, ma'am.
Your Honor.
Before recognizing the Honorable Chua, Chair would like to instruct the Clerk of Court through the OSA to kindly situate Mr. Ortonio to the witness stand. Yes, Honorable Chua.
Your Honor, may I now turn over to the counsel for the prosecution, Attorney May Divina Gracia.
Attorney May is recognized, and also, before recognizing Attorney Christine.
We will just ask for Attorney Christine Ferrer to be recognized, Your Honor.
Yes, Attorney Christine and Attorney May then. Ginoong Ortonio, kayo po ay patuloy na tetestigo sa ilalim ng nauna niyong panunumpa po Kung saan nanumpa kayo magsasabi ng katotohanan at pawang katotohanan lamang. Naunawaan po niyan?
Yes po, Your Honor.
We may proceed now with cross. Attorney Christine, you ready?
Your Honor, if I may be recognized.
Yes, Attorney May.
Your Honor, before the defense counsel proceeds with their cross-examination, the prosecution respectfully moves that the defense be directed to conduct its cross-examination in a non-leading question form, Your Honor. Yesterday, Your Honor, this honorable court declared Mr. Ortonio a hostile witness pursuant to Rule 132, Section 13 of the Rules of Court. And in so ruling, effectively, this honorable court also declared that the interest of this witness is aligned with the respondent. Now, Your Honor, the permission to conduct the permission to propound leading questions on cross-examination under Rule 132, Section 10A of the Rules of Court rests solely on the presumption that the interest of the witness to be cross-examined is hostile or is adverse to the cross-examiner, making it difficult for the cross-examiner to put into the mouth of the witness words that he expects to be elicited. Now, that presumption, Your Honor, has already been overcome by the declaration of this honorable court. So what we expect, Your Honor, is merely cross-examination in form but not in substance. Because in substance, Your Honor, the cross-examination would effectively be like the respondent herself cross-examining, the respondent cross-examining or direct examining, conducting a direct examination of her very own Assistant Chief of Staff. Last Monday, Your Honor, we witnessed how the defense, under the guise of cross-examination, supplying testimonies to the witness, Ms. Gina Acosta, and merely expecting her to supply yes to each and every question, Your Honor. And that is the very evil sought to be prevented by the rule against leading questions on direct examination. Your Honor, I understand before I'm lectured on the contents of the rules of court, I'm very much aware of what the rules of court provide. But I'm also very much aware, Your Honor, that under the rules of this honorable court, the rules of court is merely suppletory in application. And in fact, the presiding officer is granted leeway to rule on every matter of evidence.
Comment, Attorney Christine.
Yes, Your Honor. Rule 132 of the Rules of Court does not convert a hostile witness into as our own witness, Your Honor. So, therefore, we are not obliged to ask direct examination questions, Your Honor. Thank you.
If I may, Your Honor.
Short reply, and so replying, Attorney May, kindly cite a legal basis outside of the Rules of Court, since you said it's not in the Rules of Court.
Your Honor, I'm citing the very own rules of this honorable court, saying that the rules of court is merely suppletory in application, and at the end of the day, it will be the presiding officer who will be deciding on matters of evidence. And early in the proceedings, Your Honor, if I remember correctly, 2 senator judges encouraged this honorable court to look beyond the wordings of the law and consider the intent for its application.
That it, Attorney May?
Yes, Your Honor.
Chair will make a ruling. Rules of court, although it has merely supplementary application to these rules, nevertheless do apply. And the rules of court state specifically that leading questions may be asked on cross-examination without any exception nor any limitation. And as held in the Bolos case, there is no need to interpret the rules in case where there is no doubt, and the rule is quite specifically clear. Number 2, we already have a precedent, at least with respect to the previous witness declared as a hostile witness in the person of Gina Acosta, where the court allowed counsel for the respondent to ask leading questions. You shall be accorded the same privilege, Attorney May, on the part of the prosecution, should the respondent rather present a hostile witness during the presentation of their evidence in chief. the court shall apply the rule equally. So ordered.
Thank you, Your Honor.
You may proceed, Attorney Attorney Christine.
Yes, Your Honor.
When you're ready.
Yes, Your Honor. Before I start with my cross-examination, just to put the record straight, Your Honor, when I said they are allowed, I was referring to leading questions, Your Honor, because the journal dated August 12, 2019 would show that I was indeed asking a leading question before Attorney Kapunan objected, Your Honor. So if we take a look at it, with all due respect, the objection was even improper at that time, Your Honor. So, but I want that issue to be closed.
That was similarly pointed out by the presiding officer, counsel.
Thank you, Your Honor.
Sorry, Your Honor, before I proceed, may my colleague be recognized, Your Honor? Attorney Kapunan.
Of course. Attorney
Mga kapuso, magpapatuloy po ang ating live streaming. Samantala, susunod na po agad sa GTV ang Balitang Hal.
I'd like to commend the presiding justice. Very clear. The ruling on is very clear, and we will take it with strict compliance, Your Honor.
Thank you, counsel.
I'd like to manifest, though, that, again, the statement of counsel is misleading because it was very clear. It was very clear, and the transcripts will show that the immediate phrase which led to my remark was not about leading, it was about misleading, Your Honor. If I heard it, if the whole legal profession heard it, if this courtroom heard it, if the outside audience heard it, then it must be, it is what it is. She had said misleading is allowed, and I responded to that, and I'd like that to be on record, Your Honor. Let us not mislead again this honorable court. Thank you.
Your Honor,
Without the chair already made a ruling earlier regarding this matter brought about by the lead counsel, in lieu of that, the chair will simply furnish the parties with a copy of the TSN, wherein, I will quote again for the record, for the last time, and then we proceed with cross. It's already 11. Attorney Kapunan, leading, misleading questions are not allowed on cross. Attorney Ferrer, they are allowed. This is what the transcript says, and it has no reference to Attorney Ferrer stating specifically that misleading questions are allowed. And perhaps the confusion arose with respect to the TSN, again, not being able to capture the perhaps overlapping statements made by both counsels, and we should leave it at that already, counsels, and move on.
thank you, Your Honor.
So, when you're ready, no more manifestations, Attorney Christine?
None, Your Honor. We will
Proceed to cross.
Yes, proceed to cross.
Attorney May, you shall be the counsel for the prosecution?
Yes, Your Honor.
Okay, you may proceed, ma'am, when you're ready.
Good morning, Mr. Ortonio.
Good morning, Ma'am Maing Buntag.
Earlier, you said or you confirmed that no PFP or the no PFP was attached to the August 2022 letter request of the OVP to the DBM. Do you remember that?
Yes, ma'am. That's correct, ma'am.
Okay. And the reason for this was because at that time, it is not being required by the joint circular to attach the PFP to that letter.
Based on my understanding, ma'am, attaching the PFP is not required to the letter request, ma'am.
Thank you. Nonetheless, when the DBM asked for documents in response to that request, you complied and submitted documents, correct?
Yes, that's correct, ma'am.
And you submitted those documents through your letter dated September 9, 2022.
Yes, through our transmittal letter to the DBM.
Thank you. And the DBM, in fact, accepted your subsequent transmittal.
Yes, that's correct, ma'am.
And the DBM did not say that those documents which you transmitted on September 9, 2022 were not compliant with the joint circular or with the law.
We did not receive any comment, ma'am, regarding the submitted PFP.
And the DBM, in fact, did not reject your submission.
No, ma'am, we did not receive any comment from the DBM.
And you will confirm also that the DBM even recommended the approval of your request to the Office of the President after your submission of those documents, correct?
Yes, ma'am, that's correct, ma'am.
And your request for additional budget was actually approved by the Office of the President.
That's correct, ma'am.
And in the process of approving your request for additional budget, no issue whatsoever was raised by either the DBM or the Office of the President regarding the documents that you submitted.
We did not receive any comment regarding the submissions that we've made.
Thank you. You were also asked yesterday regarding the good governance program that was mentioned in the PFP for the fourth quarter of 2022. Do you recall that?
Yes, ma'am.
And as someone who supervises the Administrative and Financial Management Office of the OVP, you confirmed that the confidential funds for the fourth quarter of 2022 was requested to ensure the safe implementation of the OVP's good governance program.
That's correct, ma'am.
And the confidential funds were not used to fund the good governance program in itself, but the implementation thereof.
Yes, that's correct, ma'am.
Now we go to the 2023 PFP, which I assume you also recall. The 2023 PFP indicated that the phrase socio-economic program delivery instead of good governance program. Do you recall that?
Yes, ma'am.
And the socio-economic program delivery is a program of the OVP for the 2023?
Yes, yun po yung parang encompassing program title for all the projects of the OVP.
For the year 2023?
For the year 2023.
Again, the confidential funds for the year 2023 were not used to fund the socio-economic program itself.
This time, Your Honor, I will have to object.
Not yet done, Your Honor, with the
Not
question.
Yet?
Yes.
Kindly finish your question, Counsel.
Yes, Your Honor. The confidential funds for the year 2023 were not used to fund the socio-economic program itself, but the safe implementation thereof.
Yes,
Your Honor, I will have to
Counsel, for the prosecution,
would like to...
before the witness answers, the answer of the witness is stricken off. Yes.
Yes, Your Honor. The question, this witness, Your Honor, based on his answers yesterday, is incompetent to testify on that. Why do I say that, Your Honor? First, this witness admitted yesterday that it was the Vice President herself who requested the confidential funds. And second, Your Honor, he himself explained that he had no participation whatsoever in the disbursement of said confidential funds. So this witness, Your Honor, by his own admission, is incompetent to testify where the confidential funds were spent or what the confidential funds was spent on or were spent on.
Quick reply, Your Honor.
Yes,
yesterday, yes, the witness also testified that he is the Administrative and Financial Management Officer. Your Honor, he is the supervising officer of the Administrative and Financial Management Office of the OVP, and that all budgets, as a general rule, are being approved by him, Your Honor. And he, in fact, participated in the request for the confidential funds in the year 2022, Your Honor.
Your Honor, if I may just make a very quick rebuttal.
Before the chair makes a ruling, yes.
Your Honor, we've heard it straight from the horse's mouth. The statement of this witness yesterday was that was the general rule. Since that is merely the general rule, there are exceptions. And he also mentioned, Your Honor, that confidential funds is not among those funds that went through him.
Your Honor, quick reply.
We've dealt this. Too many exchanges already, counsels. If the witness knows, he may respond. And as you very well know, Attorney May, sometimes a hostile witness may give a different answer on cross, which is a proper subject matter for redirect, if ever, when your time comes. Witness may answer. Yes, Mr. Ortonio, you may respond to the question.
Thank you, Your Honor. The way I understand the question is that the confidential funds was not used for any of the regular programs of the OVP under the socio-economic delivery programs for the 2023. So with that, sir, I can say yes, the confidential funds were not used for the purpose of the implementation of the socio-economic programs of the OVP in itself.
And you know that information by virtue of your position, not only as the Assistant Chief of Staff, but also as the administrative but also as the supervising officer of the Administrative and Financial Management Office of the OVP.
Yes, ma'am, that's correct, ma'am.
Thank you. The socio-economic program can be found in the 2023 General Appropriations Act.
Yes,
you
ma'am.
confirm that?
Yes, ma'am, that's correct, ma'am.
Okay, and it's a line item, in fact, under the 2023 GAA.
Yes, correct, ma'am.
As the Assistant Chief of Staff of the OVP, were you made aware of the reason why the Good Governance Program was changed to Socio-Economic Program Delivery in the 2023 PFP, if you know?
Based on my recollection, ma'am, there was a change in the term, in the program title from Good Governance to Socio-Economic Program in 2023 so that it encompasses, parang mako-cover nung title ng program yung all of the projects of the OVP because because all the programs of the OVP addresses yung socio-economic concerns that the office would want to address.
Thank you. Let's go to the AOMs and the notice of suspension. You testified that as the Assistant Chief of Staff, you drafted and signed the replies to the AOMs received by the Office of the Vice President for the fourth quarter of 2022, as well as the first to third quarters of 2023. Do you confirm that?
Yes, that's correct, ma'am.
And you also signed the OVP's response and supplemental response to the notice of suspension dated December 13, 2023, relative to the fourth quarter relative to the confidential funds for the fourth quarter of 2022. Do you confirm
Yes,
that?
that's correct, ma'am. I'm one of the signatories.
And because of that, you have studied all of the AOMs as well as the notice of suspension.
Yes, that's correct, ma'am.
The AOMs sought clarification on the liquidation documents of the OVP, correct?
Yes.
The AOMs and the notice of suspension did not contain the phrase, if you recall, did not contain the phrase misuse of funds, if you can recall.
Based on my recollection, ma'am, I cannot recall.
Your Honor, best evidence, original documents rule, Your Honor. Your Honor, and I know the, Your Honor,
Counsels, we can move on because before your objection, witness already said that he cannot recall, so move on, Attorney Christine.
Thank you, Your Honor. Okay, and in those AOMs, can you recall if there was any finding of misuse of funds?
Already asked and answered, Your Honor.
I'm asking about findings, Your Honor.
Witness may answer. She's asking about findings, Counsel.
Based on my understanding, ma'am, no misuse, ma'am, although there were certain clarifications that were made.
Thank you. And the notice of suspension also does not contain any finding or findings on the misuse of funds.
None that I can recall, just some clarifications, ma'am.
Thank you. And the AOMs and the notice of suspension were not final findings of the COA-ICFAO when it comes to the confidential funds of the OVP. Do you confirm that?
Yes, ma'am. That's my understanding, ma'am, na once we receive the AOMs, we are given the opportunity to send our comments.
Thank you. In fact, if you know, there is a pending motion for reconsideration before the Commission proper relative to the notice of disallowance covering the confidential funds for the fourth quarter of 2022, if you know.
Objection, Your Honor.
Before you
That is-
answer, Attorney May?
Your Honor, that's no longer covered by the direct examination. The rule for the cross-examination of hostile witnesses under Rule 132, Section 13 is different, Your Honor. What can be covered on cross-examination of a hostile witness are only those matters that were covered on direct examination. At no point was a mention of petition for review ever made during direct examination.
The court will give counsel sufficient leeway on cross. The court will also like to find out about this petition for review, which was discussed with the witness, Gina Acosta. Witness may answer?
Sorry again, ma'am, the question, ma'am.
Yes, I'll repeat my question. If you know, there is a pending AR on the note, there is a pending motion for reconsideration of the notice of disallowance covering the confidential funds for the fourth quarter of 2022.
Yes, ma'am.
Misleading, Your Honor. Your Honor, move to strike, Your Honor, because I wasn't given enough opportunity, Your Honor.
Would
Enough
the
time.
witness kindly wait just for a few seconds before answering? Yes, what is the ground of the objection, counsel?
It's misleading, Your Honor, because a petition for review, it was not on, sorry, it was not, it was not.
I'd rather repeat my question, Your Honor.
Kindly repeat,
If I
Attorney
can.
Christine.
Yes, thank you. In fact, okay, if you know, there is a pending motion for reconsideration of the notice of disallowance covering the confidential funds for the fourth quarter of 2022 before the commission proper of COA.
Your Honor, again, this
Counsel?
witness will be incompetent to testify on it, Your Honor. The participation of this witness in the filing of the petition for review has not yet been established. It wasn't even established yet, Your Honor, that this witness is even aware of the contents of the petition for review.
Your Honor, the court already...
If he knows, Mr. Ortonio, if you know.
I am aware, Your Honor, but as to the specifics on the reply to the or the contents of the MR, I'm not very much aware of the contents.
Thank you. As to the first to third quarters of 2023, a notice of disallowance was issued by the COA dated March 31, 2026, if you know.
Yes, that's correct, ma'am.
In fact, you are the person who received the notice on April 8, 2026 on behalf of the Vice President.
Again, Your Honor, with all due respect, that's already going beyond what was discussed on direct examination, which is prescribed under Section 13, Rule 132, Your Honor. At no point did we discuss the notice of disallowance for the last three AOMs. The discussion during direct examination were limited to the notice of suspension, up to only the notice of suspension.
The chair will note will convert the objection of counsel to a continuing objection with respect to the line of questioning of Attorney Christine on this witness. But the court will allow it, but notes the continuing objection of counsel with respect to these notices of disallowance that were issued.
Thank you,
Mr.
Your Honor.
Ortonio, please answer.
Yeah. Ma'am, can you repeat the question, ma'am?
Okay, I will repeat. A notice of disallowance was issued by the COA on dated March 31, 2026, relative to the first to third quarters of 2023.
Yes, ma'am.
And you are the person who received the notice of disallowance on April 8, 2026, on behalf of the Vice President.
Yes, ma'am. I received the document on behalf of the Vice President as the Assistant Chief of Staff.
Okay, thank you. Under the COA rules, if you know, since you are the one who also responded to the AOMs, under the COA rules of procedure, The OVP has 6 months from its receipt of the ND or the notice of disallowance to file a petition for review with the Commission proper of the COA.
Objection, Your Honor. This witness will be incompetent. Unlike the joint circular, Your Honor, which he specifically mentioned in his replies, Your Honor, there was no mention whatsoever of the COA rules in any of his replies.
If he knows, Your Honor.
Your Honor.
Attorney Christine, move on to, we get your point. You can move on to your
Okay,
next
Your
point.
Honor. I will continue. Now, your involvement when it comes to the OVP confidential funds were, kindly confirm each item. Number 1, processing the request for the confidential funds for the fourth quarter of 2022.
Misleading, Your Honor. There was no statement to that effect during the direct examination.
Your Honor, she asked for the functions, Your Honor. She even presented the documents, Your Honor, pertaining to the confidential funds of 2022, Your Honor,
If I may, Your
which
Honor.
the witness also processed. Thank
Yes,
you.
Attorney May?
If I know, there was no, again, that's misleading, Your Honor, because I never asked about the participation of this witness in that request. In fact, he himself explained, Your Honor, during direct examination, that the request was purely the Vice President's. He had no participation whatsoever in the request. He is only aware that a request was made because of that letter that he was confronted with. That's why throughout the direct examination, his answers would be limited to what is contained in the documents.
Well, if he knows counsel, and again, this would be a ripe subject matter for your redirect if he all of a sudden regains, if all of a sudden he remembers, it is a proper subject matter of redirect. Witness may answer.
Your Honor, yes, I will repeat my question. Your involvement when it comes to the OVP confidential funds were, number 1, processing the request for the confidential funds for the fourth quarter of 2022 as evidenced by your letter dated September 9, 2022 to the DBM.
Ma'am, just a quick clarification, ma'am. When you say processing, ma'am, in terms of
Handling the request.
yes, ma'am. Through my office, ma'am, we transmitted the request to the DBM.
Okay. Signing of vouchers.
That's correct, ma'am. Signing of vouchers.
Signing of checks.
Yes.
Signing of responses to the AOMs and the notice of disallowance.
Yes, ma'am.
And acting as liaison when it comes to the submission of the liquidation documents to the ICFAO.
Yes, ma'am.
Okay, thank you. You were not involved in the drafting of the quarterly liquidation reports of the confidential funds, correct?
No, ma'am.
That work belongs to Ms. Gina Acosta, right?
As of my understanding, ma'am, yes, ma'am.
You were not involved in the disbursement of confidential funds, is that right?
No, ma'am.
And also the recording of confidential expenses.
No, ma'am.
The recording of confidential expenses is being done by Ms. Gina Acosta.
As of my understanding, ma'am, yes, she is.
And you were not also involved in the confidential operations of the OVP.
No, ma'am.
And you have not met any of the confidential informants of the OVP.
No, ma'am.
Neither did Ms. Gina Acosta meet any of them, if you know.
That I would have no not personal knowledge, ma'am.
Okay, thank you. As far as you know, the confidential informants only liaise with Colonel La Chica, if you know.
That is of my understanding, ma'am.
And the reason being is that the information as to the identity of the informants is classified and sensitive under the joint circular, specifically item 3.28.
Objection, Your Honor. This witness has already repeatedly testified that he had no participation in the disbursement of the confidential funds, Your Honor. And yet, defense counsel, with all due respect to her, keeps on propounding questions related to the disbursement.
And this answer, counsel, will always be in the negative because he has been consistent in regard to not having any participation with the disbursement. I think that has been established, Attorney Christine, that he has no participation in the disbursement.
Actually, Your Honor, my question was not about the disbursement, Your Honor. If I can repeat it, Your
Kindly
Honor.
repeat the question,
Yes, thank
Attorney
you.
Christine.
You answered earlier that as far as you know, the confidential informants only liaise with Colonel La Chica. That was your answer earlier. And the reason being, okay, if you know, is that the information as to the identity of the informants is classified and sensitive under the JC. Can I just finish my question, Your Honor?
Finish the question, Counsel.
Yes. And I will repeat, Your Honor. The reason being is that the information as to the identity of the informants is sensitive under the joint circular.
Your Honor, I raised the same objection, Your Honor. This witness already testified that he has no participation in the disbursement and implementation of the confidential funds. Now, defense counsel is asking the reason why the informants did not directly.
Your Honor, please.
Chair will make a ruling. Chair will sustain the objection, but not on that ground, but on the ground it is misleading because the witness did not say that it is of a sensitive nature, but that, if I remember correctly, it was confidential. That was the statement made by Attorney La Chica to him. Na
Yes,
hindi niya sasabihin because it was confidential.
Yes, Your Honor. We will no longer push the question. Thank you.
Move on to your next point, Attorney Christine.
I'm already done, Your Honor. Thank you.
Are you ready for your redirect, Counsel?
Your Honor, may I just have 10 minutes, Your Honor, to organize my redirect, Your Honor, given the number of questions that were propounded on cross-examination.
With the permission of the Senator judges, so as to save on time, while we're giving Attorney May some time, you will have the similar amount of time, Attorney Christine, if you so desire for your recross. I will, in the meantime, allow Senator judges to interject in the interregnum to save on the court's time. I can see the hand of Senator Soto. Anika, can you, after Senator Soto, can you list the rest? Chair recognizes Senator Judge Soto for his interjection. You may proceed, sir. You have 2 minutes.
Thank you, Mr. Presiding Officer. It's actually just one question to Mr. Ortonio. And this is out of my curiosity. Earlier, you confirmed that all admin and finance matters dumadaan sa'yo.
That's correct po, Your Honor.
Also, you said that you were the head of HR in Davao, LGU.
That's correct po, Your Honor.
Correct. In this regard, I'm sure you would know, what is the employment status of Colonel La Chica in the office of the Vice President?
Colonel La Chica po is the group commander of the VP-SPG, and he is not an employee of the OVP, but he has an order coming from the AFP designating him as the group commander for the Vice Presidential Security and Protection Group.
Therefore, designation.
There is an
he is not employed. He does not have any employment status in the office of the Vice President.
Yes po, Your Honor.
That's all I wanted to know, Mr. President. Thank you.
Point well taken, Senator Judge Soto. Next to interject is Senator Erwin Tulfo. You may proceed, sir. You have 2 minutes.
Thank you, Mr. Presiding Officer. Ginoong Testigo, nabasa niyo po ba na mabuti at naintindihan ang nilalaman ng Joint Memorandum Circular, sir?
Good morning, sir. Yes, Your Honor, I was able to read it, and based on my understanding, I was able to understand the contents of the JMC.
Nung kayo po ay pinadalahan na ng Notice of Disallowance ng COA, nabasa niyo rin po ba kung bakit kayo po pinadalahan ng Notice of Disallowance? Kailangan niyo pong sagutin yung kanilang AOM.
Yes po, for the 2022 and 2022.
So naintindihan po ninyo na sinasabi doon ng COA na while confidential funds allow for the payment of rewards to civilian information, yung COA po has ruled that this cannot be structured as broad distribution of medicines, food, grocery packs, or household goods. And that kung ito po ay reward, dapat po specific, targeted financial payouts lamang po at hindi po pwedeng ibili ng mga gamot o ng mga upuan bilang reward. Naintindihan niyo po ba yun?
Sir, based on my understanding, sir, that is the initial observation coming from the COA, and we were able to provide comment on that on our replies.
Tama. Pero alam niyo po ba ng Office of the Vice President is a civilian office? Ibig sabihin, hindi po sila military, therefore, hindi po sila maaaring mag-possess ng formal national security or law enforcement mandate. Sabi po ng COA guidelines, sir, again, specifically, the operational intelligence gathering is the domain of military, police, and specialized enforcement bodies. Hindi po kasama ang VP, PSPG po roon. Did you know that?
Sir, based on my understanding, sir, sa pagkakaintindi ko po sa JMC is that the confidential funds is allowed for civilian agencies, sir, and in coordination with the different law enforcing agencies. Yun po yung pagkakaintindi ko po.
Yun po ang pagkakaintindi ho ninyo. Pero iba po yung sinasabi po ng COA sa inyo. Kaya po kayo may notice of disallowance. Kaya po sinasabi ng COA at ini-issue po sa inyo formal notice of disallowance na 73.3 million ng OVP December 2020 to confidential spending. Yun po ang dahilan na major reason for disallowance was the 24.93 million pesos spent on medicines and 34.857 million spent on various goods were improperly categorized under the guise of intelligence rewards. Alam niyo po ba yun? Kaya pinadalhan po kayo ng COA, sir.
Sir, based on what I can recall po, sir, on the notice of disallowance that was sent to our office, what they required, sir, was that the submission of an intelligence report to support the payment of those rewards. So yun po yung pagkakaintindi ko regarding sa letter.
So nakita po ninyo na may problem, sir. May problem. Kaya kayo pinagpapaliwanag.
There is an issue po, sir, that we needed
There's
to
an
comply.
issue. Okay. Panghuli na lamang, Mr. Presiding Officer, one last question. So, sino po
You may
mga
proceed.
nag-imbento at saan galing yung mga alias po na yun? Is that Colonel La Chica o sa grupo ninyo, sila Chippy McDonald, sila Pusa, Aso, etc., may sila Pagong? Who invented those?
Sir, I do not know, sir. Number one, sir, I cannot answer, sir, if invented, sir. But as to the AR, sir, I cannot provide information, sir, because I do not have any participation in the implementation of the confidential activities.
Thank you, Mr. Witness. Presiding Officer, thank you, sir.
Thank you very much, Senator Judge Erwin Tulfo. Senator Judge Pangilinan is recognized. You have 2 minutes, sir. You may proceed when you're ready.
Maraming salamat. Magandang umaga, Ginoong Ortonio.
Good morning, sir.
Yes. Pwede nyo bang ipaliwanag yung naging proseso, no? Dahil base sa testimonya ni Acosta, ni Gina Acosta at sa inyo, yung testimonya nyo, from December 2022 to September 2023, a total of 122 million pesos in cash was distributed to perhaps hundreds of informants after doing surveillance work, was given rewards, and they purchased medicines. Tama po?
Based on the information that was shared to me by the security officer,
That's
sir.
correct. Yun yung nangyari.
Based on the information, sir.
Bakit gamot? Would you know?
Sir, I would not know, sir, but although based on the information that was shared to me by the security officer, those were parang yun po yung representation or yun daw po yung inilapit ng mga informants or agents that they needed at the time.
Bilang reward?
Yes, as a
Pero
form
pera
of-
ang binigay, sabi ninyo, no?
Yes, sir.
Pero
Based-
hindi nyo alam kung talagang gamot ang binili.
I would
Dahil-
have no idea, sir, on the implementation, sir.
Dahil walang resibo. Acknowledgement receipt meron.
acknowledgement receipt, sir.
You were head of the BAC, no? Bids and Awards.
Bids and Awards
So
Committee,
familiar
sir.
ka, pagka regular purchases, dapat may bidding ang medicines.
Correct, sir.
Di ba?
Yes, sir.
So, kung yun ang pinaliwanag sa'yo, sa loob ng 9 na buwan, hindi mo ba tinanong o hindi mo ba sinita na dapat pagka medicines, dapat bidding? Kasi ako ang head ng Bids and Awards. Alam ko yan eh.
Sir, I was only made aware of the concern regarding the medicines and food supplies, sir, when the when we received the AOM, which was around October of 2023, sir. So that was parang almost 9 months after the 2022 na implementation for the confidential funds.
Okay. So, hindi mo alam kung bakit gamot, no? Sinabi lang sa'yo, no? Pero bilang in charge ng financial services, yun na nga, hindi mo rin talaga alam kung yung 122 million ay gamot ang ay binili.
For that purpose, sir, I would have no personal knowledge, sir.
At sa usapin naman ng supplies, sabi, purchase of supplies. Anong supplies yun? Would you know?
I do not know of, I'm not familiar, sir, kung ano po yung mga supplies na ni-request.
So hindi mo rin
po, sir.
alam na yung 112 million pesos worth of goods. Anong goods yun?
Again, sir, I would have no personal knowledge, sir, on the specifics of the supplies, sir.
You know, you have 2 master's degrees. You're a graduate of Ateneo. Would you consider this usual?
As far as sa pagkaka...
I mean, now that you know, di ba sabi nga nila, hindsight, 2020. Vision is always 2020 in hindsight. So ganitong para sa surveillance, binigyan ng gamot na 122 million, yung mga informant, sila na lang daw ang bibili ng gamot. Is this usual? In terms of using government funds? And you being a BAC head?
Based on my understanding po, sir, at saka sa pagkakaintindi ko po, sir, it went through the the process that is allowable by law. So
it's usual for you? It's usual? That's just my question. Do you find this usual? And you say yes or no. So you find this process na medicines ang binibigay bilang reward sa mga informant, pero hindi medicines, pera, sila bibili ng medicines, 122 million in a period of 9 months, for you that's usual?
Kung sa pagkakaintindi ko po, sir, and based po sa understanding ko po sa JMC, sir, I would say so, sir.
Okay. No further questions at this time, Mr. President.
Thank you. With the permission of the next in line is Senator Judge Tulfo, but with your permission, Honorable Tulfo, thereafter, Senator Villanueva, the Senate President, Senator Rivera, Senator Lacson. The 10 minutes of Attorney May is up. Attorney May, can you now proceed with your redirect? Again, without prejudice, to Attorney Christine asking for a similar time for her recross, should she require it?
Good morning.
Attorney May, you may proceed when you're ready.
Good morning, Mr. Ortonio.
Good morning, ma'am.
Okay. Kanina, on cross-examination, sinabi mo na sa pagkakaalam mo, hindi required na i-attach ang PFP sa request for confidential funds. Tama ba?
Yes po.
Okay. Now, may we confront you with Section 3.24 of the Joint Circular 2015-01. Can you kindly read it for
may
the
approach
record?
and show the witness the JC 2015-01, the relevant provision thereof.
Can you kindly read for the record what 3.24 of the Joint Circular states?
3.24 Physical and Financial Plan refers to the plan approved by the head of office in the case of NGAs and LGUs and by the Board of Directors in the case of GOCCs, supporting the supporting the request for funds for CE and IE containing the estimated amount per project, activity, and program.
Nabasa niyo po ba yan bago kayo sumagot kanina? Familiar po kayo sa provision na yan?
I have to be honest, ma'am, na I cannot remember this one, ma'am.
Okay. Ngayon, hindi rin ikaw ang nagpadala or nag-prepare ng October 22, 2022 letter. Tama ba?
Sorry, ma'am.
Hindi rin ikaw ang nagpadala ng August 22, 2022 letter. Tama ba?
It is through our
Yes.
usual na routing process, ma'am.
And also, sabi mo kahapon, it was the decision of the Vice President to request the confidential funds. Tama ba?
Yes, as the head of agency, ma'am, I would understand that she has the authority to request for the said funds, ma'am.
And siya rin yung nag-sign off dun sa August 22, 2022 letter. Tama ba?
Yes, ma'am.
Siya yung pumirma. Tama ba?
Yes, ma'am.
Okay. So hindi mo alam kung paano ininterpret ng Vice Presidente yung provision na iyong binasa. Tama ba? You cannot say with certainty how the Vice President interpreted that provision.
Before you answer, Mr. Ortonio, yes, Attorney Christine?
Witness is incompetent to read the state of mind of the Vice President.
That's
Your Honor.
precisely the point, Your Honor. That's precisely what I'm asking the witness to confirm, that he cannot say with certainty the frame of mind of the Vice President if she was also thinking that the PFP is not required for the request.
Applying the rules equally, if he knows, witness may answer.
Thank you, Your Honor.
Again, ma'am, for the question ulit, ma'am.
So hindi mo rin masasabi, you cannot say with certainty na ganyan din ang interpretasyon ng Vice Presidente dun sa provision na binasa mo nang ipinadala ang sulat to the DBM dated August 22, 2022. Tama ba?
I cannot, ma'am.
But you are sure, you can confirm that the Vice President is a lawyer. Tama ba?
Yes, ma'am, she is a lawyer.
Sinabi mo rin kanina na yung confidential funds, to your knowledge, hindi lang to ginastos sa regular programs ng good governance. Tama ba?
Ma'am, what I meant, ma'am, is that...
Sorry, Mr. Tony, let me just clarify. Sinabi mo kanina na to your knowledge, yung confidential funds were not spent on the regular programs under the good governance program. Tama ba?
That's correct, ma'am.
Yan din yung sinabi mo para sa socio-economic delivery programs. Ang sabi mo, yung confidential funds hindi ginamit sa regular programs ng socio-economic delivery programs ng OVP. Tama ba?
That's correct, ma'am.
Pero you will confirm na yung sa PFP hindi naka-indicate na the confidential funds will be used not for the regular programs of the good governance program of the OVP. Tama ba? Walang qualification dun sa PFP. Tama ba? Ang nakalagay lang doon, good governance program.
Yes, ma'am. Based on the document that I saw, ma'am, it only indicated the program titles.
Okay. Tama. So, hindi naka-indicate doon na gagamitin ang confidential funds para sa programa other than the regular programs under the good governance program. Tama ba?
Yes, ma'am.
The same is true for the 2023 PFP. Ang nakalagay lamang doon, socio-economic delivery. Walang qualification. Tama ba?
Based on the document that was presented, ma'am.
Hindi rin sinabi na the confidential funds for 2023 ay gagamitin for programs other than the regular programs of the socio-economic delivery programs of the OVP. Tama ba?
Sorry, ma'am. Can you repeat the question, ma'am?
Hindi rin sinabi sa PFP for 2023 the confidential funds of the OVP will be used for programs other than the regular programs under the socio-economic delivery program of the OVP.
Based on the document, ma'am, it does not specifically indicate.
Okay. And you would confirm that the seeming confusion would have been avoided had the Office of the Vice President only indicated the specific programs under both the good governance programs and the socio-economic delivery programs in the PFP. Tama
Objection.
ba?
Objection.
What is the ground?
Speculative, Your Honor.
Your Honor, again, a question does not...
The witness is smart enough. Mr. Ortonio, you may answer if you know.
Can you repeat the question, ma'am?
The confusion would have been avoided or would have been averted. Iwasan sana ito kung yung OVP nilagay doon sa dalawang PFP for 2022 and 2023 yung specific each and every program that will be funded with the confidential funds for both years.
But her question says, so the confusion should have been avoided, Your Honor. The question is misleading.
Because, Your Honor, there was an inconsistency, Your Honor. Earlier...
She is interpreting and making conclusions out of the answer of the witness, Your Honor.
Attorney May, kindly reform. Yes, the witness did not say that he was...
Okay.
Reform, you can get to the same point. Throw another way.
Okay. So, Mr. Ortonio, kung nilagay yung each and every program that will be funded, stinate doon sa dalawang PFP, yung particular programs na paggagamitan ng confidential funds, wala sanang question kung saan ito ginamit. Tama ba?
Objection, Your Honor. Same objection, Your Honor. Actually misleading kasi wala sanang questions. He did not say that there were questions on
Then
the
I will
confidential.
drop the sana, Your Honor.
Mr. Ortonio, if I may, counsels, Mr. Ortonio, bakit hindi nilagay doon sa PAP yung particular ng good governance at socio-economic program at hindi ito bahagi doon sa original o regular na budget ng OVP? Sa pagkakaalam mo.
Thank you, Your Honor. On the question, sir, on kung bakit hindi nilagay, sir, I would have no personal knowledge, sir, on why. Since the document was prepared by our special disbursing officer.
Sa paggawa ng sagot sa OEM, sa palagay mo ba kung nilagay niya yon, hindi na masasama sa OEM, sa AOM yon?
Based on my understanding, sir, it could have helped, sir, to clarify.
Okay. Your witness, counsel?
Okay. Mr. Ortonio, yesterday and today, paulit-ulit mong sinasabi na wala kang participation sa disbursement and implementation of the confidential funds. Tama ba?
Yes, ma'am.
So, hindi mo rin alam kung talagang saan ginamit yung confidential funds, kung anong programa dinisburse ito. Tama ba?
Objection. Objection, Your Honor.
What is the ground?
Not covered by the cross.
Let's give her sufficient leeway, counsel. This is one of the questions in the minds of the senator judges. Just to clarify, you may answer, Mr. Ortonio.
No, I would not have any personal knowledge.
So, hindi mo rin alam, based on your personal knowledge, na yung confidential funds ay hindi ginastos sa regular programs under the good governance program. Tama ba? Kasi wala kang sabi mo, wala kang participation, wala kang personal knowledge kung saan dinisburse yung confidential funds. Tama ba?
Based on my understanding, ma'am.
Wala ka ring personal knowledge kung paano in-implement ang confidential funds. Tama ba?
Yes, ma'am.
So, hindi mo rin masasabi, based on your personal knowledge, na yung confidential funds ay ginastos sa mga programa other than the so-called regular programs of the good governance program.
Objection, Your Honor.
What is the ground, Christine?
Misleading, Your Honor. The witness did not say that the confidential funds were spent on the good governance programs of the OVP.
That was not the point, Attorney Christine. Witness may answer. If the presiding officer may, Mr. Ortonio, kung wala kang personal na kaalaman kung paano ginastos yung confidential fund, edi wala ka ring personal na kaalaman kung ginastos sa regular na programa ng OVP yung confidential fund.
I do not have any personal knowledge, sir, on how the confidential funds was implemented,
At all.
sir.
Kung saan napunta yon, wala kang alam.
No, sir.
Kung napunta man sa tama o mali, madumi o malinis, wala kang alam.
I would have no personal knowledge, sir.
Okay. Your
Earlier,
witness, counsel.
tinanong ka din, bakit nag-change yung program, the PPAs, for the 2023 PFP. When I say PPAs, I'm referring to the projects, plans, and activities. Tinanong ka kanina kung bakit yung programs, plans, and activities under the 2023 PPA naging socio-economic delivery program na dati under the 2022 PFP, ito ay good governance program. Tama ba?
Yes, ma'am. The
Yes.
way I understand the
Wait.
question, ma'am.
Wait lang. Ito yung tanong, Mr. Ortonio. Ang sabi mo kanina, nag-change ng PPA sa 2023 PFP para ma-cover ang mas marami pang programa. Tama ba?
Ma'am, I'll clarify, ma'am.
Wait,
I
Mr. Ortonio, please just answer my question with a yes or no.
answered, ma'am.
Your Honor,
Let the witness answer, Attorney May.
thank you.
I answered the question earlier, ma'am, in the context of why there was a change from good governance to socio-economic delivery in the context of what is reflected in the GAA. So that's how I answered it, ma'am.
Okay. Pero you will confirm na wala ka ring participation dun sa pag-identify, sa pag-prepare ng PFP. Meron ka bang participation?
For the PFP, ma'am, no.
Kanina tinanong ka rin tungkol sa petition for review na final ng OVP sa COA. Tama ba?
Yes, ma'am.
And you will confirm that this petition for review was denied by the COA. Tama ba?
And yes, ma'am, and
Yes.
subject for motion for reconsideration.
Ibig sabihin, nang dininay ito ng COA, yung COA, it stood pat with its earlier decision, with its earlier findings. Tama ba?
Your Honor,
If he knows, counsel.
Yes, ma'am, but then again,
Yes.
subject for the filing of motion for reconsideration.
Sinabi mo din kanina na wala kang participation sa drafting ng liquidation. Wala kang participation sa drafting ng request. Wala kang participation sa drafting ng liquidation documents. Wala kang participation sa disbursement. Wala kang participation sa recording. Kasi ang may gawa nito ay si Ginang Acosta, di ba?
Yes, ma'am,
Naalala mo
that's
yun?
correct.
You will confirm na ikaw, ang Chief of Staff, at ang Vice President, ang 3 top officers ng OVP. Tama ba?
As Assistant Chief of Staff, ma'am. Yes.
So, kayong tatlo, kayo yung top 3 officers ng OVP. Assistant Chief of Staff, and the Vice President herself. Tama ba?
Yes, ma'am.
Okay. Sinabi mo na wala kang alam tungkol din sa mga bagay na yon. At sinasabi rin ng Chief of Staff na wala rin siyang alam tungkol sa mga bagay na ito. So tama bang sabihin na among
Your
the
Honor,
three of
please.
you, si Vice President lang ang nakakaalam?
Let her finish the question. Witness will not answer the question until the objection is ruled upon by the chair. Finish your question, Attorney May.
Done, Your Honor.
Attorney Christine, what's your objection?
Misleading, Your Honor, and vague. First of all, the Chief of Staff has not yet testified with regard to the confidential funds.
Well, Attorney Christine, the court took judicial notice of the proceedings in the House of Representatives where the Chief of Staff, Attorney Lopez, testified, and I went through the TSN, and such statements were made along those lines by the Chief of Staff of the Vice President. Witness may answer.
Ma'am, can I be clarified with the question? Can you repeat the question, please?
Okay. Kanina, sinabi mo na ang top 3 officers ng OVP ay ikaw, as Assistant Chief of Staff, ang Chief of Staff, at ang Vice President herself. Tama ba?
Yes, ma'am.
Ngayon, sinabi mo na wala kang alam tungkol sa drafting ng liquidation reports. Tama ba? Wala ka ring alam sa disbursement ng ng confidential funds. Wala ka ring alam tungkol sa recording relative to the confidential funds. Tama ba?
Yes, ma'am.
Ito rin yung naging posisyon ng Chief of Staff. Wala rin siyang alam tungkol sa mga bagay na to. Ngayon, tama bang sabihin na dahil kayong tatlo, ang top 3 na officers or officials ng Office of the Vice President, si Vice President lamang ang may alam tungkol dito sa mga bagay na to?
Objection.
What's the ground, Christine?
Speculative, Your Honor.
If you know, Your Honor, again, Your Honor, we don't want to belabor this point, Your Honor, but Defense Counsel keeps bringing us back to this point, Your Honor. The question does not become speculative simply because it's couched in a what-if question, Your Honor. And besides, Your Honor, this honorable court has already ruled and has already directed the witness to
Your Honor,
answer, Your Honor.
The counsel would want the witness to speculate on the state of mind of the Vice President.
No, Your Honor. Let me answer it in 2 points, Your Honor.
Please, counsel, briefly.
Yes. It's not speculative, Your Honor, because there was already an admission that they are the top 3 officials of the OVP. Now, the answer would be based on that admission, so it's not speculative. The question would only be speculative. It's completely conjectural, Your Honor. And second, Your Honor, the only reason I repeated the answer because the witness himself requested me to repeat. But prior to me repeating the question, the Honorable Presiding Officer has already made a ruling. Your Honor, we will be squandering away time if every time I would repeat a question, the Defense Counsel would all of a sudden invoke another ground for objection.
We're about to break for lunch, so let's end it on a good note.
Yes, but
finally, Attorney Christine.
I will revise my objection, Your Honor. Incompetent.
Allow me, counsels. Base sa testimonya mo, Ginoong Ortonio, wala kang alam sa paggastos, pag-liquidate, pag-disburse ng confidential fund. Tama?
Yes, that's correct, Your Honor.
Sabi ni Gina Acosta, wala rin siyang alam. Tama? Alam mo ba yun? Na wala rin siyang alam sa paggastos ng confidential fund at kung paano ito niliquidate. Would you know that?
Based on what I have read
na testimonya niya?
Yes, sir.
Base sa pagkakaalam mo, alam ba ng Vice President kung paano ito ginastos?
The way I understand it, sir, as the head of agency, I would understand that she knows the implementation, sir.
Yes. So si Colonel Lachica, alam din siyempre.
Yes, sir. As the security officer, I would assume
sa loob ng opisina ng OVP, si VP Sara, head of agency lang ang nakakaalam, ikaw bilang Assistant Chief of Staff, yung Chief of Staff mismo, walang alam, at si Colonel Lachica na ayon sa katanungan ni Senator Judge Soto kanina lang, na hindi naman bahagi ng opisina ng OVP.
Yes, Your Honor.
Okay.
That would be all for redirect, Your Honor.
Do you have a short recross, Attorney Christine, or a long one? Do we pause for lunch, or do you want to finish your cross before lunch? We don't have to call lunch at 12 o'clock. We can do it at 12 past 12.
After lunch, Your Honor.
You prefer after lunch?
Thank you. Yes, Your Honor.
Then, since it's only 11:57, we have time for one more, Senator Judge. If you want to avail of it. Yes, I see Senator Judge Tulfo, the next one to interject, raising his hand. The sequence would be Senator Judge Rafi Tulfo, Senator Judge Villanueva, the Senate President, Senator Judge Ontiveros, Senator Judge Lacson, Senator Judge Padilla, and I just saw Senator Judge Bam. So we have time for one or two more Senator Judges before breaking for lunch. Senator Judge Rafi, you are recognized, sir. You may proceed. You have 2 minutes, sir.
Thank you, Mr. Presiding Officer. Kayo po ay nag-reply sa AOM from COA for the check number 244027 dated 20 December 2022. Ano po yung proseso na ginagawa nyo once kayo po ay nakatanggap ng AOM or disallowance?
Good morning, Your Honor. When we receive AOMs within the office, once we receive it, we inform the of course, the Chief of Staff, and of course also the head of agency of the AOM. We send them a copy for their information.
Do you investigate?
Once meron na pong instruction to kung sino po yung magko-conduct ng review, then that's the time po that we conduct a necessary review for
Do you ask
the reply.
questions?
Yes, sir, to the concerned na mga
To the concerned.
concerned na mga divisions.
What questions do you ask, for example?
Usually, sir, we ask point per point on what is
Point per point, okay.
point per point what is indicated in the AOM, so
Yes.
that we can also address the concerns point by point.
Very good. Now, isa sa mga AOM ay observation ng COA, kulang sa mga dokumento. Halimbawa, itong sinabi rito, 170,000, at marami to by the millions. 170,000 for the payment of reward, open and closed medicines. Did you not ask, ano ba talaga to? Anong klaseng medicine ang binili? Kasi ang pagkakalam ko, meron kayong pera from confidential funds, binigay nyo dun sa informant para siya nang bumili ng medisina.
Yes, sir. Yun
Did
po
you
yung-
ask kung anong medisina binili para sa medisina bibili nung informant, yung pera?
When the time na nag-consult po ako with the security officer, sir, I did not ask anymore on the specifics, but I asked on paano po yung naging process nila in terms of noong pag-release ng funds for the informants or for the agents.
Sir, you are a very highly educated person from prestigious schools. Come on, it doesn't make sense. It defies logic. Tatanungin mo dapat, to protect Sara, kasi very close ka kay Sara, teka muna, anong klaseng mga medisina binili? Nasaan yung reseta? Kasi mali mo, baka namin hindi binili ng medisina, baka binili ng drugs, whatever, baka may nagbulsa ng pera. Dapat, yun kasi yung kailangan ng, COA, di ba? Resibo.
At the time po, sir, when I consulted with the security officer, sir, I was not able to ask anymore on
Why
the
not?
details, sir.
It's part of your job. In fact, pumirma ka doon sa pag-reply mo sa AOM.
I asked, sir,
So
kung ano
pumirma
yung
ka
process.
nakapikit. Yes, sir.
No, sir, hindi naman po na nakapikit, sir, because nagtanong naman po ako sa security officer namin, sir, on how it was released or implemented on the ground. So, kung ano po yung nabigay na information, sir, yun po yung nailagay ko sa pag-draft po ng reply to the AOM.
Hindi mo rin tinanong bakit pare-pareho yung signature sa different names ayon sa NBI, forensic, tapos pare-pareho yung handwriting sa different names, parang isang tao lang nag-fill up, meron pa nga walang signature at nag-receive ng by the hundreds of thousands each.
Sir,
you didn't ask? Bakit mo tinanong, hindi mo tinanong, bakit pusa, bakit ito si Pagong, pinagtatawanan tayo ng tao, etc. Why? Did you not ask?
Sir, at the time, sir, hindi ko po nakita yung mga acknowledgement receipts, sir. I was only made aware of the acknowledgement receipt, sir, when it was already shown during the HOR na mga hearings, sir.
Hindi kasi pag nagtanong ng attachment, then di ba sabi mo you ask questions point by point, you investigate, then kinuha mo sana yung mga dokumento and then pinakita sa iyo and then nagtanong ka point by point like you said. And then you are a very educated person, you should have asked a lot of questions to satisfy dun sa request ng COA.
Sir, I
Kasi
did not-
tulad yan, pusa, Pagong. Imposible hindi mo nakita yan. Tapos pare-pare yung pirma sa isang same handwritings para sa napakaraming pangalan at saka iisang pirma sa napakaraming pangalan according to the NBA forensic. You didn't ask?
Sir, at that time po, sir, I did not see the acknowledgement receipts.
Come
po,
on, sir. Like I said, napakatalino mong tao sa credentials mo. Dating professor, Ateneo, UP, di ba? And then, now, parang, sorry sir, parang nagmaang-maangang ka. Again, is it blind loyalty? Thank you po. Thank you, Mr. Presiding Officer.
Are you going for lunch or the rostrum, Attorney? Senator Judge Joel. Okay. I thought you were headed towards lunch already. Senator Judge Villanueva, as the last Senator Judge to interject before we break for lunch. You have 2 minutes, sir. You may proceed.
Thank you. Mr. Witness, sinita po kayo ng COA dun sa pag-approve nyo ng disbursement voucher, no? Yung 125 million. At ang explanation nyo, delegated po sa inyo pag more than 1 million. Is that correct?
Yes po, sir. There is an office order, sir.
Ano yung extent of your authority? Ministerial approval or may responsibility din kayo na determine if this is lawful, properly supported, and authorized expenditure bago kayo pumirma?
There is also a level of checking, sir, if documentary attachments have been complied, sir, prior to the affixing my signature, sir.
Like?
Kung sa mga disbursement vouchers, sir, dapat merong mga supporting documents on the reasons for the request po, sir.
Like?
One of which, sir, say for example, there is an activity design, sir, which indicates kung ano yung mga activities to be done and the expenses for those activities.
Okay, nung winidraw po yung salapi, 125 million, sabi po ni Ms. Acosta, you accompanied her. Alam niyo po na after nung winidraw yung salapi, diretso po pinlace ito sa custody ni Colonel Lachica. Alam niyo po yan?
At the time, sir, I did not know, sir, kung ano yung arrangement nila ni Ms. Gina Acosta, sir. I just accompanied her to the bank, sir, as per her request.
So you have no knowledge?
I have no knowledge po, sir.
You're the disbursement officer. You don't have any knowledge, so wala ding written authority, no? Anyway, dun po sa testimony ni Ms. Acosta, sabi po niya, si Colonel Lachica was not bonded, yet the confidential funds were released to him because he was supposedly na siya yung mag-implement ng activities on the ground. As Assistant Chief of Staff, as disbursement voucher signatory, officially approving the DVs. Aware po ba kayo dito sa ganitong arrangement?
I had no personal knowledge po, sir, on that arrangement, sir.
Kasi kung ganun, parang sinasabi nyo na parang ministerial duty lang po yung sa inyo. Although kanina sabi nyo hindi po. Kasi why would you allow that, no? Then next question, Asek, kayo po mismo yung pumipirma dun sa November 30, 2023 OVP response to COA stating that all transactions involving the 125 million pesos were valid, proper, and regular, and explaining that the 40 million medical and food aid was given to persons conducting nationwide surveillance operations. Bago po ninyo ginawa, may factual representation po ba kayo sa COA? Ano po yung inyong ginawa, yung personal po ninyo na verify bago niyo po ito ginawa?
Sorry, sir. The question again, sir. Just to be clarified lang, sir.
Ulitin ko po yung question. Nung nag-respond po kayo dun sa COA that all transactions involving the 125 million were valid, proper, and regular, in-explain nyo din po yung 40 million medical and food aid was given to persons conducting nationwide surveillance operations. Bago po ninyo ito ginawa, yung factual representation po na iyon sa Commission on Audit, ano po yung inyong personal na ginawa to verify all of this?
I consulted po yung our security officer on how the implementation was done on the field, sir. And what was relayed to me, sir, yun po yung nilagay ko sa draft for the reply,
Ano
sir.
po yung hiningi nyo?
Information, sir, on how it was implemented, sir. So I asked if I can remember it right, sir, because it was quite a long time ago, sir. I asked kung paano yung manner of release of the funds on the ground, sir, and especially yung sa medical and food aid, sir. And what was relayed to me, sir, was that the funds were released to the informants or the agents through cash, and then based on their representation that they would need these funds for the purchase of medicines and supplies.
Binanggit niyo po dun sa AOM na lumabas na notice of suspension, wala pong nakalagay na misuse of funds. Right? So, ano po yung ginawa po ninyo after po lumabas ito? Despite the fact na wala ho kasi yung nakalagay na misuse of funds, pero nakalagay po doon yung lacking of documentary records to support yung ginawa po ninyo. Ano po yung inyong ginawa para makorek? From example, from AOM to before ma-issue yung notice of suspension, before ma-issue yung notice of disallowance. Ano po yung inyong ginawa to suffice yung hinahanap po ng Commission on Audit?
Based doon po sa mga points that were raised in the AOM, we provided answers for
But you
those.
also, before you answer, Presiding Officer, you agree na yung binanggit niyo po, no, there's no such word misuse of funds doon sa mga AOM, NS,
Yes, sir.
ND?
Yes, sir.
Okay, sige po.
So we provided the documents that were required of us, sir, in support on the issues or concerns raised by the Commission on Audit.
And apparently, hindi po sila pumayag at hindi sila nag-agree because kulang pa rin po yung documents.
Based po sa NS, sir, ND, sir, meron pa pong mga hinihingi ang COA, sir. And that's why, as a response to the ND, sir, we also supply those information.
Yeah. Salamat po, salamat po. Gusto ko lang sabihin that indeed yung confidentiality may limit what can be disclosed to the public, but it cannot erase yung accountability within the government. Salamat po, Mr. Witness.
Thank you, Senator Judge Villanueva. We shall declare and call a recess so that everybody can have lunch. Mr. Ortonio, you are excused from the witness stand. Kindly have lunch, and we expect you back. We expect everyone back at 1 p.m.
Your Honor, please.
Yes, Senator, the Honorable Luistro.
Your Honor, may we just know if Colonel Boransing is already in the premises, because we understand that the prosecution will be presenting him immediately after the recross of Mr. Ortonio.
He is not yet in the building, and we will address that when we reconvene. There's nothing we can do about it anyway at this point in time. We will
Thank you,
inform
Your
you of the circumstances before we resume at 1 p.m. We are on recess until 1 p.m. Kindly have a hearty lunch.
Mga kapuso, magbabalik po from the lunch break ang mga senator judge nitong day 19 ng impeachment trial. Mamaya pong 1:00 ng hapon at may ilang senator judges na po na nakapagtanong. At mamaya po aabangan rin natin ang re-cross examination ng depensa kay OVP Assistant Secretary at Assistant Chief of Staff Lemuel Ortonio. Samantala, meron pong pahayag ang nasasakdal na si Vice President Sara Duterte kaugnay sa takbo ng impeachment trial. Ang sabi po niya, patunayan ng ebidensya at hindi ng pangiinsulto o anyay political theatrics ang reklamo laban sa kanya. Sa pahayag na inilabas ngayong umaga, sinabi rin ng Vice Presidente na dapat ay kumpiyansa sa kanilang impeachment complaints ang prosecutors at miyembro ng Kongreso. Hindi raw sila dapat nangingisda para sa ebidensya o pilit gawing totoo ang isang anyay wild story of alleged wrongdoing. Ang malakas daw na kaso, hindi dapat nilalagyan ng anyay theatrics. Pinuna niya ang ilang salitang ginamit sa trial. Kabilang dyan ang pagtawag daw ng isang senador sa isang witness na stupid. Ang pagbansag daw sa kanya ng isang abogado bilang mastermind na isang scam. At ang pagtawag daw sa kanya ng isang witness bilang isang brat. Hindi raw ito nakakapagpatunay ng kaso o nakakalikha ng ebidensya. Ang mga insulto raw ganito ay nagpapakita lang ng kung waring kumpiyansa sa harap ng mahinang presentasyon. At sa punto ito, balikan po natin ang ating talakayan dito sa studio. Kasama pa rin siyempre si Professor Paulo Tamase ng UP College of Law. Well, Professor, Baka pwede nating umpisahan dun sa naging pahayag, yung bagong labas na pahayag ni Vice President Sara Duterte. Hindi pa naman ito sakop ng ruling ni Presiding Officer Cheese Escudero, which he issued right before or at the beginning of today's impeachment trial.
Well, I think yung instruction naman was prospective yung application ni nung ruling ni Senator Cheese. But siguro the way that I think about itong issues with the Vice President making these statements, or actually many of the cast of characters sa impeachment making public statements is, kaya mo ba ikahon yung dagat? Minsan yung feeling niya na given the very political character of the case, posible ba talaga na patigilin sa pananalita yung mga politiko na involved, whether as witnesses or the respondent herself. But in any case, I think yung objective ni Senate Presiding Officer Escudero is to restore some order and civility doon sa proseso, to ensure na yung ebidensya yung mananaig, and na hindi yung parties ay naghahanap ng kakampi basically outside. So importante nga yung directive nga this morning na sa prosecution and sa depensa na pag-isipan na nila na maghanap ng separate na spokesperson rather than yung mga abogado na nagtatry din ng kaso.
Hindi kasi ito yung unang beses na sinabi ito ni Presiding Officer Cheese Escudero, di ba?
Yes, sa bilang ko, pangatlong beses na ito. The first time where he said it explicitly, the second time nung August 12, I think, nung pinaalala niya kina Atty. Ligutan, and the third time yun, categorical suggestion siya na maybe it's time na ihiwalay yung function ng pananalita pag-explain sa publiko doon sa function of litigating the case, no? Yung pag-presenta mismo ng ebidensya, pag-question ng mga testigo sa loob ng Senado.
Pero para lang malinaw, suggestion pa lang ito ni Presiding Officer Cheese Escudero kasi nasa prosecution pa rin at depensa kung gusto ba nila itong gawin or hindi. Although, ang sinasabi niya kasi is, mas mahirap lang yung magiging trabaho ng spokesperson kung siya ay nasa panel kasi nga pwede siyang magamitan ng subjudice rule.
Yes, exactly. Hindi naman siya yung magtatalaga mismo nung spokesperson ng bawat panig. But I think on the part of the prosecution and the defense, mahalaga din na i-take to heart nila, isipin nila talaga yung suggestion na iyon. Unang-una, makapag-focus yung mga abogado doon sa trial na lang mismo. May iwasan yung perception na parang ginagamit itong pagkakataon nito for airtime and yung personal na exposure ng mga abogado. At the same time, maiiwasan din yung nakikita na natin na development kung saan minsan nagkakaroon na ng contradictions doon sa sinasabi ng mga spokespersons kung marami sila versus doon sa mga sinasabi mismo ng abogado or their fellow spokespersons. So, mas malinaw sa publiko kung iisang tao or kakaunti lamang sa labas ng prosecution or defense team yung kakausap sa publiko.
So mamaya, Professor, pag-usapan rin natin kung ano yung naging laman ng redirect, or rather the redirect and the cross-examination kay ASEC Ortonio. Mga kapuso, ipagpapatuloy po ang paglilitis mamayang 1:00 ng hapon at tuloy-tuloy lang po ang live stream sa YouTube at Facebook ng GMA News. Kaya wag po kayong bibitiw. Magbabalik pa rin po sa GTV ang GMA News Special Coverage, The Vice President on Trial. Mga kapuso, tuloy-tuloy po ang live stream ng GMA News Special Coverage, the Vice President on trial. At sa ngayon, naka-lunch break pa ang Day 19 ng impeachment trial. Gagawin po mamaya ang re-cross-examination ng depensa kay OVP Assistant Secretary at Assistant Chief of Staff Lemuel Ortonio. At kuha po tayo ng update sa Senado mula kay Ian Cruz. Ian?
Yes, Pia, naka-lunch break pa rin nga ang impeachment court at ngayong day 19 ang pinakamalaki so far na nangyari ay yung paglalabas ng ruling ni Presiding Officer Cheese Escudero patungkol nga sa subjudice rule. Inisa-isa pa, Pia, itong si Escudero, yung mga quotes na talagang nagpapakita daw na nagkaroon ng paglagpas doon nga sa subjudice rule ang mga senator judge, maging yung magkabilang panig mula yan sa prosecution at depensa. Sabi ni Escudero, kilala naman daw ng mga personalidad na ito kung sino yung mga nagsabi ng nasabing mga pananalita. Ang Escudero sa ngayon ay nasa clean slate muna sila. Ibig sabihin ay wala munang mapaparusahan, pero mula sa araw na ito ay talagang maghihigpit na ang impeachment court sa pagpapatupad ng subjudice rule. Ang paalala niya, dapat ay lahat ng public statement ay hindi tatalakay sa merito o nilalaman ng bagay na nakabinbin sa trial. At Pia, inulit din Escudero yung panawagan niya sa magkabilang panig sa prosecution at depensa na kumuha sila ng spokesperson na hindi miyembro ng defense o prosecution panel dahil kung ang spokesman nila ay miyembro nito ay saklaw pa rin siya ng subjudice rule. At sa mga susunod na paglabag ay magkakaroon na nga daw ng mga parusa, pagbibigay ng 24 na oras na palugit para masagot ng isang lumabag na personalidad yung show cause order sa kanya na pwedeng magmula sa hukuman o maging sa magkabilang panig ng prosecution o depensa. Pero kung reprimand o admonition lamang ang first offense, sa second offense ay magkakaroon na ng monetary fine o pagbabayari ng 30,000 pesos at madaragdagan niya ng panibagong 30,000 pesos sa mga susunod pa na offense. Ang Escudero, hindi naman matatapos dito sa impeachment court yung paglabag sa subjudice rule sapagkat maaari nilang ipasa yung record sa Supreme Court maging sa Office of the Bar Confidant dahil aniya ang hindi pagsunod sa subjudice rule ay maaring ang ma-refer patungkol sa pagiging unbecoming ng isang miyembro ng bar ang lumabag nito. At ang paalala nga ni Escudero sa prosecution, hindi primary duty nila ang mag-convict kung hindi matiyak na justice is done. Sa respondent at depensa naman, hindi lamang i-secure acquittal at all costs, kailangan daw mai-represent ang akusado ng competent, efficient at diligent. May paalala rin si Escudero sa mga kapwa niya, senator judge at maging sa sarili niya na mag-decide sa impeachment batay sa record, sa ilalim ng Constitution at rules at sa paraang karapat-dapat sa kumpiyansa ng mamamayan kung saan nga may pananagutan ang hukuman. Naging maiksi lamang, Pia, yung naging cross-examination nitong si Attorney Christine Ferrer kay ASEC Lemuel Ortonio ng OVP at kabilang nga sa mga tinalakay niya dyan na wala naman talagang umanong nakasaad doon sa joint circular na nire-require sila na magkaroon ng physical o yung kanilang pinaplano para sa paggamit ng confidential funds. Pero doon sa redirect nitong si Attorney ni May Divina Gracia ay pinaalala niya kay Ortonio na may nakasaad doon sa joint circular na kailangan na meron nga silang talagang konkretong plano doon sa kanilang paggagamitan ng confidential funds. At ilan sa mga senator judges ang nagkaroon na rin ng intervention at kabilang nga sa mga nagtanong kay Ortonio bago ang break ay si Senator Judge Rafi Tulfo na talagang kinwestiyon niya, Pia, kung bakit hindi napansin nitong sina Ortonio yung mga kakaibang mga pangalan doon sa mga acknowledgement receipt na bagay na sinasabi naman ni Ortonio na syempre hindi niya alam sapagkat naging recipient lamang sila ng mga dokumento mula sa nag-implement nito na security officer. Ang sabi ni Tulfo, tila nga daw nagmamaang-maangan lamang itong si Ortonio. So magbabalik ang impeachment court 1:00 ng hapon na mamaya at patuloy tayong mag-aantabay sa iba pang mga kaganapan dito sa Senado. So yan muna ang latest mula rito. Balik sa iyo, Pia.
Iyan, kanina bago nag-lunch break, ang impeachment court, tinanong ni Representative Jervil Luistro mula sa prosecution panel kung nariyan na ba ang susunod na testigo mula sa AFP na si Ginoong Boransing. At ang sabi ni Senator or Presiding Officer Chis Escudero ay wala pa daw siya sa premises. Pero ibig ba sabihin niyan, Iyan, may impormasyon ba kayo kung siya ba ay kaya pang humabol ngayong hapon dito sa Senado kung sakasakali na diretso na at ipagpapatuloy na ang direct examination ng susunod na testigo?
Well, Pia, ang understanding natin ay aware naman itong dalawang active at retired na sundalo patungkol nga doon sa pagpapatawag sa kanila bilang witness ng prosecution. At Pia, mayroon pa namang panahon sapagkat naka-break pa ngayon ang impeachment court. Babalik sila ng 1:00 and hindi pa naman din tapos yung ginagawang proceeding. Magre-recross pa si Attorney Christine Ferrer and magkakaroon pa siyempre ng interjection at intervention ang marami pang mga senador. So kung talagang hahaba pa yan, Pia, baka nga hindi pa matawag itong Army officer sapagkat alam natin kapag talagang nagtanong ang mga senador marami sa kanila at minsan kung ilang round pa yung nangyayaring tanungan at mahaba talaga ang proseso din na to dahil kada senador ay may 2 minuto sa bawat mga tanong nila. Kada round pa lang yan, Pia.
Alright, so depende rin kasi nga yung hindi naman siya isang round lamang pwede pang umulit at humaba yung rounds or madagdagan yung bilang ng round ng bawat senator sa kanilang interjection. Iyan.
Yes, Pia. So ganun nga ang nangyayari. Pagkatapos ng unang round, meron pang second, minsan meron pang third round and depende rin. Kasi ang inoorasan lang naman is yung tanong nitong mga senador pero hindi kasama dyan yung pagsagot ng testigo o ng witness. Kaya kapag pinagsama-sama mo yung mga oras na yan, baka humaba ng humaba at baka nga, Pia, baka pagka ganun kasi at dikit na rin sa oras at may session pa rin naman ang mga senador ngayong araw na to. So baka hindi na nila gawin na pasalangin pa at magsimula na lamang sila sa susunod na linggo na dahil wala namang session sila sa Monday dahil holiday. So maaring sa Martes na yan, Pia, kung talagang may kakaunting panahon na lamang matapos nga yung intervention at interjection ng mga senador. Pero kung mahaba pa yung oras, baka kung may isang oras pa yan o higit pa, maaaring isa lang kung nakarating na nga dito sa impeachment court itong army officer na pinahaharap ng prosecution, Pia.
Iyan, may nakuha na ba tayong reaksyon mula sa either defense or prosecution tungkol sa naging ruling ni Presiding Officer Chis Escudero na nagpapaalala nga sa kanila, gaya ng sinabi mo kanina na kapag sila ay nasa loob ng korte, kailangan may decorum at syempre kapag nasa labas, baka kailangan mag-ingat, lalo pang mag-ingat. Hindi baka, kailangan talagang lalo pang mag-ingat sa kanilang pananalita.
Pia, alam mo, nung bago ako nag-report dito sa ating programa, marami tayong kasamahan na nag-attempt talaga na kakausapin sila, hinga ng pahayag. Pero sa pagkakataong ito, dati-dati, Pia, talagang bago sila kumain, bago pumasok sa mga huddle room, nakakapag-interview pa. Pero sa pagkakataong ito, tila ayaw muna nilang magsalita nung magkabilang panig sa puntong ito. Matapos nga ang ilabas ni Presiding Officer Chis Escudero yung kanyang ruling patungkol sa sub judice rule, Pia.
Alright, Ian, maraming salamat. Abangan namin ng iba pang update mula sa iyo mamaya. Si Ian Cruz po, nag-uulat live mula sa Senado. At kasama pa rin natin po ngayon si UP College of Law Associate Dean Professor Paulo Tamase. Professor, magandang tanghali na po. Kanina magandang umaga. Magandang tanghali na po.
Magandang tanghali ulit.
Prof, mukhang nag-iingat na yung mga counsel from the defense, pati na sa prosecution. At gaya ng sinabi ni Ian, hindi na sila basta-basta nagpapa-interview ngayon.
Yes, well, di ba usually kapag lunch break sa impeachment, may press conferences yung lalo na yung prosecution, hindi ko alam kung ginagawa nila ngayon yun. But I guess kailangan nila ng oras para mag-adjust doon sa ruling ni Senator Escudero. Siguro another point would be, hindi din naman kasi ganoon ka-substantive. Yung examination this morning, natapos yung ruling ni Senator Cheese, I think around mga alas 11. No? And there was only 1 hour of questioning for redirect and a very brief 1 hour of questioning for a cross-examination by the defense, tapos a very brief redirect, tapos may mga pailang-ilang tanong yung mga senator judges. So, on that, parang hindi rin tayo sure kung matagal pa yung re-cross-examination. My guess is hindi ganoon katagal, if at all.
Pagbalik nila from their lunch break.
Yes, pagbalik nila from their lunch break.
Alright. Well, as we're speaking, may information tayo na meron ding press conference ang prosecution right now. So, mamaya kukuha tayo ng update kung anong sinabi nila at the press conference para malaman natin how the message of Presiding Officer Cheese Escudero has been received by both sides. No? Pero, Professor, balikan natin yung naging talakayan. I mean, yung nilalaman ng direct and the redirect and the cross-examination. Kasi isa dun sa mga natanong kay ASEC Ortonio, well, si Senator Tito Soto ang nagtanong nito sa kanyang interjection. Sabi niya, tinatanong niya kung employee ba ng Office of the Vice President si Colonel Lachica. Kasi nga parang siya yung itinuturo ni SDO Acosta na tumanggap ng pera, nag-handle ng pera, siya yung nag-disburse ng pera. So, bakit kailangan malaman yon at ano ba yung patakaran sa pagbigay or pag-disburse ng pera sa isang tao na hindi naman contractual employee or listed employee ng isang ahensya ng gobyerno?
Mahalaga siya kasi malinaw sa joint circular kung sino yung pwedeng humawak ng pera at tumanggap ng pera on behalf of the agency. So kaya nga mayroong special disbursing officer, yung OVP, dahil ayon sa joint circular, yun yung responsable for handling yung cash, no? Yung cash advances in particular. And dahil doon, or further to that, kailangan din natin i-consider na yung mga special disbursing officers, yung mga fiduciary officers sa gobyerno, required sila maghain ng bond, yung fidelity bond na nabanggit kahapon, upang in case may mawala doon sa pondo for whatever reason, maibabalik sa gobyerno yung pera na nawala or nawaldas. So problematic yung pag-hire ng isang opisyal na wala sa plantilla ng ahensya, I think for 2 reasons. Una ay labag yun sa joint circular. No? And pangalawa, clearly hindi accountable yung opisyal na iyon para sa pondo. So it raises all sorts of questions na in the first place, bakit nga ba pumayag na siya, si Colonel Lachica, yung magbahagi ng confidential funds? And pangalawa, kung sa labas siya ng organisasyon, sino yung nagpapanagot sa kanya? So, sino yung nagiging ultimately accountable na opisyal? Kasi nakikita natin na testimony the last 2 days, yung isang end seems to suggest na si VP Sara ay in control of the entire disbursement of the confidential funds. But on the other hand, mayroon ding parang line of answers yung witnesses na nagtuturuan na itong person, ito yung responsable, etc. So parang kulang ng pananagutan within the agency itself. And if galing nga talaga sa labas ng ahensya, na I think nakuha natin yung diretsong sagot today from yung questioning ni Senator Soto, then mukhang puntos yun for the prosecution.
Kasi nga, hindi naman siya listed employee.
Hindi siya listed employee. Labas siya, therefore, doon sa pwedeng humawak ng confidential funds sa joint circular. Ibig sabihin din nun, hindi siya nakapagkuha nung, or nakapag-file ng fidelity bond na required. And siguro yung fourth possible factual reason for it is, kung part siya ng ibang organisasyon, in this case, yung military, ano yung confidential operations pa na naiiwan doon sa Office of the Vice President? So napakadaming red flags na lumalabas dahil lang dun sa fact na iyon.
So kahit sabihin mo na government employee pa rin siya or government official by virtue of the fact na siya ay nasa AFP, hindi ibig sabihin nun na pera ng ibang ahensya ay pwede mong hawakan.
Pwede niyang hawakan. Hindi ibig sabihin nun na pwede niyang hawakan. So sa gobyerno, hindi po lahat ng public officer ay pwede humawak ng pera ng gobyerno. Hindi rin lahat ay may kakayahan or may legal authority to hold it. So particular yung mga regulation, yung mga batas kung sino yung hahawak. And yung intent usually ng mga pagkadisenyo nitong mga sistema na ito ay iba yung tao na nagdedesisyon sa paglabas ng pera sa tao na actually naglalabas ng pera doon sa tao na gumagastos ng pera. So kaya ganoon, to ensure na mayroong paper trail, to ensure na may checks. Kasi kung ipagsasama mo yung kapangyarihan na yun sa isang individual, mabilis nga talaga yung proseso, pero madali din maabuso. So yung pag-breakdown ng checks within the Office of the Vice President, respectfully, yung parang pag-disregard doon sa checks ng circular, that itself, no, maraming questions na pwedeng lumabas mula doon. Kabilang na dito, yung mukhang pagkuha nga ng isang tao na magdi-disburse ng confidential funds na hindi naman siya bahagi ng organization.
Inumpisahan ni Attorney Ferrer yung kanyang cross-examination sa pagtatanong na alam mo ba na, tinanong niya si Asik Ortonio na alam mo ba na kailangan may physical and financial plan na nakaakibat dun sa request ng DBM. Tapos sabi niya, wala naman talagang naka-attach dahil hindi naman ito hiningi. Later on na lang daw hiningi, tapos nung hiningi, binigay naman daw nila. Professor, pwede niyo ba ipaliwanag sa amin paano nga ba talaga ang proseso ng paghingi ng pera? At saka, di ba ito, kaya sila nag-request kasi noong 2022, hindi pa siya kasama sa budget ng OVP.
Yes.
Yung succeeding years kasi naisama na nila sa budget eh. Pero for 2022, kailangan pang humingi.
Yes. Kung tama ho yung alala ko, no, sa joint circular, yung paghingi ng confidential funds, kasama dapat dun yung PFP, kasama dun yung programa. Otherwise, hindi makikita nung mag-evaluate kung dapat bigyan ng pondo. Now, of course, kung binigyan ng approving authority ng pondo, that is itself questionable. Pero the fact is, yung last few weeks of testimonies, pinapakita lang kasi kung gaano kalalaki and honestly, frequent, kung gaano kadalas yung violations ng joint circular. So, babalik tayo dun sa sinabi ng prosecution kahapon na parang, nauuna yung cash bago yung pagpapaliwanag, yung plans were executed to fit the confidential funds. So, imbes na hinihingi yung pondo para sumuporta yung or suportahan yung programa na surveillance operation ng OVP, yung kwento ng prosecution, yung version ng prosecution ay gumagawa ng plano upang mabigyan lang ng rason yung earlier na pag-disburse na ng confidential funds. So, baliktad yung proseso nangyayari. Base dun sa sagot today, this morning, mukhang kino-confirm nun na ganoon nga talaga yung nangyayari. Nauna yung pag-request sa pondo bago dun sa pagpapaliwanag or dun sa kung bakit sila humihingi ng pondo in the first place.
Professor, bakit ipinunto ni Senator Erwin Tulfo kanina sa kanyang interjection that the OVP is a civilian office? Bakit mahalagang ilabas yan na it is a civilian office?
Yes. So mahalaga yun dahil sa saligang batas natin, mayroong separation between the military and civilian. In particular, in relation to law enforcement. So, babalik tayo dun sa purpose ng confidential funds. Ang purpose ng confidential funds ay hindi national security. No? Intelligence funds ang tawag dun. Yung confidential funds ay pagtulong sa surveillance further to law enforcement, law implementation. Ibig sabihin nun, trabaho yun ng civilian na arm ng gobyerno. National security, trabaho siya ng militar. No? Pero yung trabaho ng pag-i-implement ng batas, kabilang na doon yung surveillance or pagmomonitor, pagbabantay kung mayroon bang krimen na nangyayari in relation to the function of the office, trabaho yun ng civilian. So kung binibigay yung confidential funds sa isang miyembro ng military, red flag na naman siya. No? Bakit yung military yung nag-i-implement ng batas? So problematic na now, hindi bonded yung officer, hindi authorized yung officer, sa labas siya ng organization, and to that point by Senator Tulfo, militar yung nagpapatakbo ng confidential funds. So ganoon yung mga tipo ng insights na kukuha natin from at least the questioning this morning.
Iba pa to dun sa mga programang pinag-uusapan sa DepEd kasi ito particular sa OVP. Yung DepEd kasi ang sinasabi nila meron pa silang parang to prevent recruitment of terrorist groups within the schools kaya sila humingi ng confidential funds. So iba pa yon.
Yes, iba pa yon. And on that point, no, kung preventing recruitment of terrorist groups, mayroon naman kasing Anti-Terror Act. No? Bahagi doon, may functions yung police, may function yung militar. But internal security kasi generally is really a function of the police. So, hindi natin alam kung yun yung justification nung DepEd, this VP Sara as DepEd Secretary for having military also mukhang be the equivalent of Colonel Chica for the Department of Education. But that's something that we have to wait for yung testimony. Hindi din kasi natin alam kung matutuloy yung presentation ngayong hapon.
Si Senator Kiko Pangilinan naman ang tinatanong niya kay ASIC Ortonio, hindi ba dapat may bidding para sa gamot? Dahil nga yun yung isa sa mga points of contention na ginamit yung payment for reward, supposedly ginamit siya for the purchase of medicines na wala ring mga official receipts. So parang tinatanong ni Senator Kiko Pangilinan, bakit hindi ito dumaan sa bidding? Pero let's say it was used nga for medicine for informants. Ang medicine for a confidential operation, sa bidding pa rin dapat dumadaan yun, kahit na sabihin mo it's a confidential operation.
So, kailangan magkaroon tayo ng clear delineation kung ano yung procurement na papasok doon sa normal na government processes, doon sa procurement na papasok sa confidential fund, or yung pagbili ng gamit na pasok sa confidential fund. Generally, pagdating sa normal, regular government processes, kailangan dumaan sa public bidding yan. May exceptions, depende sa amount, depende sa value. But in general, kung ganito kalalaki yung gamot, and I think base doon sa acknowledgement receipts, kung tatanggapin lang natin yun, sa dami ng gamot na binili, parang pasok doon sa procurement threshold. Kung wala naman doon, kung hindi pasok doon sa purpose na iyon, and let's say for confidential operations talaga siya. Honestly, hindi ko makita kung paano magiging relevant so far yung gamot sa confidential operations. Then technically, pwede siyang via the confidential funds. But as I think the COA auditors were emphasizing nung testimony nila, yung paggamit niya for a confidential operation doesn't necessarily excuse it from certain documentary requirements. Like, kung hindi ka man lang magbid, magbigay ka man lang ng resibo. Kung bumili ka ng gamot from suppliers na kaya mag-provide ng resibo, kasi hindi naman siguro confidential kung saan binili yung gamot. No? So I think yun yung punto nung questioning na yun. But in any event, yung underlying suggestion kasi, and I think makikita mo naman siya from the statements of the prosecution outside, as well as the type of questions that are being asked, yung nagiging suggestion kasi dyan is yung confidential funds and yung supposed na gamit para sa medical expenses ay huwad. No? Hindi sila compliant sa joint circular, but excuse lang ito. And precisely, natatali doon yung other irregularities. The fact, for example, na yung cash disbursements ang lalaki, tas sabay-sabay lumalabas. The fact na hindi alam nung ni witness today, yung specifics doon sa operation ni Gina Acosta, hindi rin niya alam, pero apparently alam ni Colonel Chica. So parang may malaking gap doon sa kwento na kung paano ginastos yung pondo. And yun yung suggested, or yun yung suggestions, I think, in those types of questions. The moment na nagtatanong yung senators or nagtatanong yung prosecution tungkol dito sa ba't hindi ka sumunod dun sa procurement, ba't hindi ka sumunod sa ganitong proseso, yung suggestion is, bakit parang lumaktaw ka? No? And therefore, mayroon bang irregularity doon sa paglaktaw na iyon? Mayroon bang natatago doon sa paglaktaw na iyon?
Alright, balikan naman natin, Professor Tomase, yung ruling ni Presiding Officer Cheese Escudero kasi ang daming nilalaman ng kanyang ruling. Tas very important to note na yung ruling niya, ang cover dito, hindi lang the prosecutors, hindi lang the defense counsel, pati respondent and the senator judges.
Yes.
So, ano po yung tingin yung pinakamahalagang bahagi ng ruling na ito that you think will compel everybody to follow yung proper behavior and decorum?
Well, I think una sa lahat, no, parang seryoso yung presiding officer about trying to reassert order, impartiality, decorum in the process. Alam natin na seryoso siya kasi nagsimula siya sa senator judges. Diba? Yung pag-request na parang iwasan yung unparliamentary remarks ng mga senador, yung pag-apply niya actually, and ito questionable to in that sense, yung pag-apply niya ng judicial standard na cold neutrality for the senators, yung request niya na kung magtatanong yung senators doon sa clarificatory questions, magtanong sila para mahanap yung katotohanan, hindi para gumawa ng political points. It shows yung seriousness niya with regard to it, with regard to the impartiality question. I think yung nakafocus lahat so far, however, is yung direction to the lawyers. And yung lawyers, both for the defense and the prosecution, pinaalalahanan sila today and in I think threatening language kasi nagsasite na ng ethical rules and yun yung pinakatakot lahat ng yung mga abogado pag na-investigate ka for ethics. Mayroong paalala na may malinaw na rule sa Senate impeachment rules laban sa pagsasalita on the merits. Ayon kay Senator Cheese, yung merits include credibility ng witnesses, character of the accused, soundness of the alibis, relevance of the evidence presented, or any comment bearing on the guilt or innocence of the respondent. Ang dami nun. No? Parang ang lawak ng saklaw na iyon. And additional na paalala na para maiwasan ito, kumuha kayo ng spokespersons na labas doon sa prosecuting team, yung mga hindi nag-file nung tinatawag natin na entry of appearance. So siguro 2 points. Una, respectfully, I think masyadong leaning towards a judicial standard yung ruling ni Senator Cheese because most of the authorities' justification na sinasabi niya ay rules na nag-a-apply sa mga abogado sa korte, jurisprudence or yung mga past decisions ng Korte Suprema, at mga strict criminal legal contexts, yung mga kaso na nabanggit niya. Hindi yun further or hindi yun napapalapit doon sa criticism ng mga akademiko na sana yung proseso mas bukas sa publiko, mas madali maunawaan. I think if normal Filipino na nanonood ng hearing kanina, madami doon sa parts sa sinasabi na ruling ni Senator Cheese, magfa-fly lang over their heads yun. Kasi hindi naman nakapag-train to understand jurisprudence or hindi malinaw kung bakit ganoon yung standard na dapat sobrang ingat mo pagdating sa korte. And therefore, yung worry lang on my part from the academic standpoint is baka bumalik na naman tayo dun sa hyper-legalized or legalistic na proseso ng impeachment. Hopefully, hindi naman. That said, may practical value na mabuti yung kanina and that is to restore some control and restore some order dun sa proseso. So, nandyan yung sa senator judges na napaalala sila, but honestly, pinakamahalaga siya dun sa mga abogado. The last few weeks, yung main na complaint or I guess academic criticism dun sa both prosecution and defense teams is many times, para bang sila yung nagiging bida dito sa usapin na ito. Or parang masyado silang enjoy humarap sa media, no? Or enjoy na magkwento sa media kung ano yung kaso. And yung usual na explanation for it is either yung sinabi ni Attorney Liguta na magturo tayo ng publiko or teacher. Yung other na reason usually is kasi dapat ma-communicate sa publiko kung bakit mahalaga yung kaso na ito. But kaya gawin yun ng spokespersons na labas doon sa prosecution team at na-highlight kung ano yung issues na malapit sa publiko instead of yung parang ginagamit na airtime yung kaso. So, insofar as nakakatakot yung ruling ni Senator Cheese earlier, yung hope siguro is magkaroon din ng sense yung mga lawyers na hindi sila yung bida sa kwento na ito. Na hindi sila yung pinag-uusapan natin. But as with any lawyer, yung trabaho talaga nila ay protektahan yung kliyente nila. On the part of the defense, protektahan si VP Sara. On the part of the prosecution, protektahan yung mga nag-usig nung kaso na ito.
Parang yung paalala rin kanina ni Presiding Officer Cheese Escudero, sabi niya, to the prosecution, this is not victory at all costs, and to the respondent, it is not acquittal at all costs. So, ibig sabihin, may mga alituntuning dapat sinusunod pa rin. At sabi niya, really the core of this is all for the senator judges, prosecution, and defense is to ensure that justice is served, diba? That justice is done and that the due process is properly followed. Meron siyang nabanggit na two-strike rule na gagamitin ng impeachment court. Una, sabi niya, first offense, public reprimand or admonition, meaning pagsasabihan sila sa loob ng impeachment court. Second offense, may kaakibat na itong multa, monetary fine of 30,000 pesos. Yung two-strike rule ba, ganito rin ba ang ginagawa nila sa regular court? May mga first offense, second offense din po ba doon?
Sa regular court, wala. Diretso yan.
Diretso na sa multa?
Yes. Sa regular court, bibigyan ka lang ng pagkakataon na magpaliwanag, tapos magdedesisyon na yung huwes kung paano parurusahan yung contempt. So may suggested schedule yan of magkano yung fine. Yung Supreme Court itself does it quite often. So minsan, yun yung ginagamit na guide. But yung other important thing na nabanggit ni Senator Cheese doon sa mekanismo na inanunsyo niya, no, ay yung fact na written ang show cause and walang oral na usapin over it. Siguro isa din siyang pamamaraan ng Senado na iwasan na yung nakikita natin na trend the last few weeks na every time patapos yung trial, may away yung abogado na whether maliit or malaki, parang yun yung kumukuha ng atensyon ng publiko. And tumatagal yung hearing and yung trial. So, mukhang official yung proseso, written show cause, ibig sabihin, susulat yung presiding officer mismo doon sa concerned. Mayroon siyang 24 hours para sumagot ng pasulat din. So, wala na tayong makikita nung parang, I think, 10-15-minute manifestation or explanation ni Attorney Virgil kanina. Pero at the same time, nire-remind ni Senator Cheese na yung burden of proof ay dun sa panig na nag-aakusa na nagkaroon ng violation. So I think reasonable naman yung patakaran na iyon. I think ang mas troubling, if any, is yun nga, na parang sobrang stricto ng rules na para bang korte na talaga yung tingin ng Senado sa sarili niya.
May binabanggit kasi si Presiding Officer Cheese Escudero, we use Rule 18. Rule 18. Yung Rule 18 is particular, specific to the impeachment court. Sa Senate rules yon. Specific
rule siya on ano yung hindi pwede sabihin ng mga abogado and other characters sa impeachment in the public. Kaya yung criticism kanina na masyadong judicialized itong ruling ni Senator Cheese, with all due respect, nanggagaling yun dun sa fact na madami dun sa mga patakaran na inilabas niya, wala actually sa Rule 18. Nandun siya sa mga patakaran na nag-a-apply sa regular courts.
Okay.
Or sa mga abogado in regular courts, in regular administrative proceedings. So, although dapat din natin kilalanin na I think maganda din naman yung ginawa ni Senator Cheese kahit papaano kasi may moral reminder din siya na importante yung trabaho ng lahat ng panig dito. And I think more than yung fear of the penalty, mas yung sense of duty na iyon yung kailangan maipaalala, hindi lang dun sa lawyers involved, but yung senator judges mismo.
Kanina, binanggit pa ni Senator Escudero or Presiding Officer Escudero yung mga quotes, no? Yung mga quotable quotes na parang in reference to, ito yung mga dapat iwasan. Pero sabi niya, hindi niya papangalanan, hindi niya sasabihin kung sino ang nagbanggit nun because you know who you are. Tingin niyo ba dapat sinabi na lang niya para binanggit na lang niya para talagang best behavior na lahat?
Look, I think yung ruling ni Senator Cheese, Solomonic din kasi siya. Alam niya na kung magpaparusa siya under Rule 18, madaming matatamaan masyado and baka maging distraction siya itself. So rather than maubos na naman yung oras ng publiko doon sa pag-focus na napapinalize si attorney ganito or napagalitan na si attorney ganyan, binato na lang niya yung ruling niya. Sinasabi niya na alam niyo natatrack namin lahat ng sinasabi niyo sa labas, so mag-ingat kayo. But warning na in the future, hindi na kami ganito kalinyan. Hindi na kami or papatulan na namin to next time. So I think deterrence yung goal and not so much parang payback dun sa mga nasabi na statements.
Yung paggamit niya or pag-cite ni Presiding Officer Cheese Escudero sa CIPRA, ano po ba yung CIPRA?
Yung CIPRA is yung Code of Professional Responsibility and Accountability. So pag narinig yan ng mga abogado, parang taas kagad yung tenga niya. Kasi ano siya, yun yung kung may parusa yung Korte Suprema for our conduct, usually CIPRA yung ibabato sa amin na yung ginawa mo ay unethical dahil labag ito doon sa Code of Professional Responsibility and Accountability ng mga abogado. Meron pang separate yan for judges, yung Code of Judicial Conduct, pero hindi ko narinig kanina na sinight ni Senator Escudero yon. Now, yung CIPRA, again, warning yan usually to lawyers kasi paalala siya na, you know, mataas yung media mileage nyo for now. Siguro natutuwa kayo sa spotlight. Pero meron kayong ethical obligations under the CIPRA, hindi lang to your client, but also to the court, yung impeachment court here in this case, but as well as to the public and to your opposing counsel. So yung pagpapaalala na gayon, I think request din siya or parang pakiusap siya on the part of the Senate President na hindi naman siguro, at least based doon sa tone nung order niya kanina, no? Ang intindi ko is, hindi naman sa hinahabol na yung mga abogado ngayon isa-isa. But reminder lang na kung kailangan namin kayo habulin para lang i-enforce itong ethical codes na ito, gagawin namin yun.
So kumbaga, kahit nandito kayo sa impeachment court, it's not a regular court, it's sui generis, your actions here can still have an impact on your career, diba? Your work outside of this impeachment court.
Yes, and tama naman yun kasi yung CIPRA ay nag-a-apply sa mga abogado whether or not nasa korte sila. So kahit nasa labas sila, how they deal with fellow lawyers or the public, na ko-cover sila nun. May academic criticism na masyadong broad yung SIPRA or masyadong mina-micromanage niyan yung buhay ng mga abogado. But the fact is, the Senate or Senator Escudero at least considers na binding yan, especially on the lawyers for both the prosecution and the defense na nasa public spotlight ngayon.
Gano'n na ba katagal ang SIPRA? Kasing tagal na ba ito ng 1987 Constitution or mas bago-bago naman?
Well, yung Code of Ethics for Lawyers, matagal na yan, even before the 1987 Constitution. Noong 1990, 1991, nagkaroon ng Code of Professional Responsibility. And then recently, inamend yan, I think, 5 years ago, nung nagkaroon ng Code of Professional Responsibility and Accountability. So, dinagdag doon yung certain obligations, rules for lawyers na nasa social media, paano sila dapat umasta sa social media, among other rules. And I think yun, interesting na nabanggit ni Senator Cheese yun, na yung particular reference to how lawyers should conduct themselves on social media.
Oo nga. So that means relatively new na naipasok na nila ang social media.
Yes.
Because that's the one of the more difficult things to monitor, di po
Yes,
ba?
and it's the big game changer in impeachment ngayon compared to before. To be fair to Senator Alan, nabanggit nito kahapon. No? In the sense na yung hindi katulad nung ERAP impeachment or nung Corona impeachment, kapag may senator na nag-misbehave or may lawyer na nag-misbehave, uulit lang yan siguro 1 or 2 beses sa 6 p.m. newscast, sa 10 p.m. newscast. But after nun, mahirap na hulihin. No? Baka sa dyaryo na lang maibabanggit. But sa social media age kasi, anything na recorded lives forever. So yung na-drop mo na sham or na-drop mo na scam na salita, kahit bawiin mo pa yan in theory at mawala siya dun sa record ng Senado, kung makailang beses yan na record na, rather, yun din yung ilang beses siyang mape-play pa pwede in the future. I-replay lang siya, isa-splice lang siya, kakalat siya like wildfire sa social media, kahit in theory, wala na siya sa record ng Senado. So may changes in the way we view the impeachment or how lawyers have been acting now because of the impeachment na nag-arise doon from social media. I think timely yung reminder ni Senator Escudero about lawyers in social media, even though, again, may academic criticism kasi about those rules being too broad and too punitive on lawyers.
Pero ito drafted din by lawyers? Or
Drafted by the Supreme Court. So yung
By the
Supreme
Supreme
Court
Court.
mismo yung nag-issue nitong rules na ito on social media.
So nakikita natin that this should serve also as a reminder, hindi lang for lawyers na nasa impeachment court, but I guess any practicing lawyer, di po ba?
Yes. And I think generally kasi yung rules on social media acts for lawyers, na-apply siya in the past or na-apply siya against lawyers for things they say in mga message groups or Facebook.
Even message groups. Okay.
Or social media, which kind of indicates yung sinasabi ko na medyo broad yung rule. And to a certain extent, baka broad masyado. Wala nang espasyo yung mga abogado. But in the impeachment context, maganda siya from the academic standpoint na makikita mo how social media has also changed so much of how the trial has been conducted. Focus on sound bites, yung focus on things and actions na pwedeng ma-replay repeatedly on social media, yung pagkakamayan ng mga lawyers. Like, ito ngayon, yung nakikita natin na pagpasok ng mga abogado, nakikita natin ngayon si Attorney Po and si Attorney Lorna nag-uusap. Yung mga ganyan na moments, dati hindi naman yan nafo-focus on kung nung long-form broadcast.
At eto na sa rostrum na si Presiding Officer Cheese Escudero. Mag-uumpisa na po ang magpapatuloy na ang Day 19 na impeachment trial.
Mr. Ortonio, to the witness stand. Clerk of Court, Rosa.
Thank you, sir.
You are under the same oath, Mr. Ortonio. Do you understand that, sir?
Yes, sir.
Thank you. Attorney Christine, your witness for your recross.
Yes, Your Honor. Good afternoon, Mr. Ortonio.
Good afternoon, ma'am. Ngayong hapon.
Earlier, you were asked to confirm that the PFPs for the fourth quarter of 2022 and the first to third quarters of 2023 did not reflect that the confidential funds were used for the safe implementation of the OVP's Good Governance Program for 2022 and social economic delivery for 2023. Can you
Misleading,
recall
Your
that?
Honor.
Yes,
Misleading, Your Honor. Move to strike, Your Honor.
Why is it misleading, Attorney May?
Because, Your Honor, during the redirect examination, I never mentioned safe implementation.
Reform Council, I don't recall the word safe as well. But it was somewhere along those lines, I believe.
Yes, Your Honor. But actually, that was what registered to me. But can I continue, Your Honor?
You may continue, Attorney Christine.
But, Your Honor, we move to strike the answer of the witness.
So stricken off. Reform your question, Attorney
Thank you, Your
Christine.
Honor. I'm showing you the PFPs for 2022 and 2023. Your Honor, they are exhibits
Assisting counsels may approach.
D-1-23 OVP for the PFP for the year 2022 and D-1-49 OVP for the year 2023. Okay, do you have copies of those PFPs? Okay, let's go to the 2022 PFP. Now, I'm directing you to the second column of the PFP. Okay. It says there, safe implementation. Let's go to the 2022 PFP. It says there, safe implementation of the OVP initiatives and confidence building. Do you see that?
Yes, ma'am, based on the documents presented.
And that is under the table, under the heading, expected outcome.
Yes, ma'am.
Okay. Now, let's go to the year 2023, CY 2023 PFP. Now, I'm directing you also to the second column. It says there's safe implementation of OVP initiatives and confidence building. Do you confirm that?
Yes, ma'am.
And that is under the heading expected outcome.
Yes, ma'am.
Okay. You were also asked about the supposed submission of the PFP together with your letter or the Vice President's letter to the DBM dated August 22, 2022. Earlier, you were asked. And in fact, you were asked also to refer to section or item 3.24 of the Joint Circular.
Joint Circular,
Do you
yes.
recall that? Now, do you also recall that in a letter dated September 15, 2022, the DBM requested that you submit the PFP in relation to your request for additional funding?
Yes, ma'am, that's correct, ma'am.
In fact, in compliance with such letter of the DBM, you submitted a copy of the PFP through your letter dated September 19, 2022.
Yes, ma'am, we transmitted that report, ma'am.
And as earlier mentioned, during your cross-examination, your submissions to the DBM, okay, I will rephrase, Your Honor. As earlier mentioned, okay, the DBM recommended the approval of your request for confidential funds to the Office of the President.
That's correct, ma'am.
In fact, the Office of the President approved the issuance of confidential
Objection,
funds
Your Honor.
to the OVP.
Let her finish the question, counsel. Are you
Objection,
done,
Your
Attorney
Honor.
Christine? What is the objection, counsel?
That was not covered by the redirect anymore, Your Honor.
In the discretion of the court, we will grant latitude. Counsel, overruled. Witness may answer.
Thank you, Your Honor. Earlier also, you were asked whether you knew if confidential funds were used in the regular activities of the OVP. Do you confirm that?
Yes,
Your
I
Honor.
was asked earlier.
That was misleading, Your Honor. The question earlier, first, Your Honor, we move to strike because the question is misleading. What I asked was whether or not this witness has personal knowledge, not just any kind of knowledge, Your Honor, personal knowledge.
Okay, I will rephrase my question.
Kindly
using-
rephrase to
yes,
include
Your Honor,
personal
using
knowledge.
the wordings of the counsel. You confirmed earlier that you were asked whether or not you have personal knowledge as to whether the confidential funds were used in the regular activities of the OVP.
Yes, ma'am.
As the one who drafted the AOMs and the response to the AOMs and the response to the notice of suspension, was there any findings in the AOMs? Was there any findings in the AOMs which relative to the supposed use of the confidential funds in the regular activities of the OVP?
Misleading, Your Honor.
If you can recall.
Misleading, Your Honor, because this witness could not have drafted the AOMs. The AOMs came from the Commission on
She
Audit.
corrected herself, counsel, the response to the AOM.
Yes, Your Honor.
Witness may
So I
answer.
will repeat my question, Your Honor, for clarity. Now, as the
Proceed,
one who
Attorney Christine.
drafted the responses to the AOMs as well as the notice of suspension, if you can recall, was there any findings of the COA relative to the supposed use of the confidential funds in the regular activities of the OVP?
Not covered by the redirect, Your Honor. I never touched upon the AOMs during the redirect examination.
Same ruling, counsel. You may register in the court notes a continuing objection along these lines of questioning by the counsel. Witness may answer.
Based on the documents that we have received from COA, there was no any indication or any comment that the confidential funds were used for regular programs.
Nothing further, Your Honor. Thank you.
Thank you, counsel. We now proceed to the interjections of senator judges. Before we proceed to administrative matters facing the court today, we recognize our distinguished Senate President. Next in line, Senate President Owen Gatchalian. You may proceed, sir. You have 2 minutes.
Thank you, Mr. Presiding Officer. Mr. Ortonio, nakita ko sa mga records na 6 na beses ko yung pumirma ng reply to COA. Itong 6 na letters na ito ba ay nabasa, nakita, ipinakita kay Vice President Sara?
All the replies, sir, that were drafted were also sent to our Vice President for her information, for her reference and review.
So alam niya itong mga replies to COA?
Yes, sir.
Okay. Narinig ko rin sa inyong testimony na kinausap niyo si Acosta at si Colonel Lachica.
Yes, sir.
At base sa mga information nila, yun ang inilagay mo sa letter replies niyo to COA. Tama?
Yes, sir. That's correct, Your Honor.
Paki-narrate nga sa amin, ilang beses niyo pala na-meet si Colonel Lachica?
Sir, sa mga replies po, sir, I cannot exactly remember how many times, sir. But I can say more than once or twice, sir, I was able to meet Colonel Lachica to ensure na I get the information from him, sir, and that I'll be able to draft properly the replies to the AOMs.
So mga once or twice? Or
around once or twice, sir. The exact number, sir, I cannot remember anymore, sir, because maraming beses, maraming documents po yung na-review, sir.
Pakikwento nga sa amin kung ano exactly yung kanyang sinabi sa inyo para ma-draft niyo itong reply.
For the AOMs, sir, I'll try to recall, sir, some of the issues that were raised on the AOM. So say, for example, sir, on the AOM comment regarding the use of the confidential funds for medical and food supply, sir. So tinanong ko po siya kung paano po in-implement on ground yung pagbigay ng medical and food supplies to the informants and the agents. So from there po, sir, na-mention niya, sir, na the funds were released to the informants and agents based on the representation that those funds will be used for the purchase of medical and food supplies.
Kwento mo dyan sa iyo na siya mismo ang nagbigay sa mga informants?
Sir, hindi ko na po ma-recall, sir, if he mentioned specifically if siya po yung ang distribute personally, sir, doon sa on the ground, sir, or implemented the release on ground.
Pero ang kwento niya sa iyo, cash ang ibinigay sa informants, hindi medical supplies or other supplies.
That's correct po, Your Honor.
Kwento niya ba sa iyo na mayroon ba siyang kasamang iba sa pagbibigay nitong cash? Kasi libo-libo yung acknowledgement receipts.
Hindi niya po nakwento specifically, sir. Although if I can recall, sir, based on my recollection, meron po siyang na-mention na meron po siyang mga, hindi ko alam kung ano yung term niya, sir, but meron siyang mga people who go directly on the ground, sir.
Pero kinonfirm niya na kinonfirm niya sa iyo na kinuha niya yung 500 million pesos.
500 million, sir?
Yes, in four different tranches.
For the different funds, sir. It is of my assumption, sir, na siya po yung napagbigyan ng funds, sir.
In 4 different tranches.
4 different tranches, sir.
Okay. Nasabi niyo ba sa kanya na tinanong niyo ba sa kanya na yung mga ibang acknowledgement receipts ay questionable yung mga apelido?
Sir, at that time po, sir, I was not able to see the acknowledgement receipt, sir, because in the AOM, sir, the AOM indicated that we submit the DEPs or the documentary evidence of payment, sir. So I was not able to see it, sir. So nung binigay po sa akin ni Miss Gina Acosta yung mga DEP, sir, it was already in a sealed box, sir, and then we submitted that together with our reply to COA.
Paano niya raw dinistribute yung mga pera? No, kasi 500 million to, thousands and thousands of acknowledgement receipts. Paano niya ikunento sa inyo na dinistribute niya itong mga pera? Sino itong mga informants niya? Kasi kayo gumawa ng AOM, anong reply to the AOM.
Sir.
So, I would assume na tinanong niyo yung methodology ng pagdidistribute niya.
Sir, based on my recollection lang, sir, he mentioned na, yun nga, sir, meron siyang mga people, sir, who worked on the ground. That is only the extent of the information I can recall, sir, when I had a consultation with Colonel Achica.
Yung pagpili ng informants, natanong niyo ba kung paano? At
Sir,
yung relevance ng informants dito sa inyong confidential operation?
Sir, I did not ask anymore, sir, because it was not the subject of the AOM, sir. So I was not able to check on him on that matter, sir.
Pero yung DEP, yung documentary evidence of payment, subject yan ng AOM, tama?
For submission, sir, we were required to submit the documentary evidence of
But
payment, sir.
did you, tinanong niyo ba sa kanya kung paano niya nakukuha itong DEPs?
Sir, I did not ask anymore, sir. I just requested for the copies for the DEPs, sir, so that I can already submit it, sir, doon sa COA as an attachment to the AOM reply.
Paano kung yung DEPs peke? Paano kung yung kanyang narration sa iyo ay hindi totoo? Paano
Sir,
kung ganun ang situation?
Sir, at the time, sir, because he was designated as our security officer, sir, I
Designated by
the head of office, sir,
Which is the Vice
Sara
President.
Duterte, sir. So it is of my, sa tingin ko po, sir, na maayos naman po yung pagkakatrabaho ni Colonel Achica doon sa pag-dispense niya ng duty as the security officer.
Last question, Mr. Presiding Officer. Bakit parang nagkukuha ko buo yung tiwala ninyo sa kanya at kinuha niyo lahat ng information at yun ang ginamit niyo sa inyong reply to the COA? Bakit buo yung tiwala? Hindi kayo nag-probe na mga additional questions considering na kayo ang nag-justify nito sa COA at kayo pumirma, no, dito sa COA. So bakit parang kung anong sinabi niya, yun na lang ang linagay niyo sa inyong reply?
Well, first, sir, is because he's the security officer, sir. So I believe, sir, na siya yung the best person that can provide the information. And then, second, sir, as the security officer, sir, he was designated by our head of agency, which I believe also gave the trust and confidence to him to implement the activity. So, kung ano po yung na-mention ni Colonel Chica sa akin during the time when I checked or asked for questions, yun po yung pinagbasihan ko for the drafting of the reply.
Thank you very much, Mr. Presiding Officer.
Thank you, Mr. Senate President. Senator Judge Ontiveros is recognized for her interjections. You have 2 minutes, ma'am. You may proceed when you're ready.
Salamat po, Mr. Presiding Officer. Mr. Ortonio, tama po ba na lahat ng ginagawa ng OVP tungkol sa confidential funds, so request, amounts, justifications, use at pagsagot sa mga puna ng COA, tama po ba na lahat ng ito ay dinesisyonan at inaprubahan ni VP Duterte?
Based on the mga replies, ma'am, yes, I was able to provide a copy to the head of agency, ma'am. Again, being the head of agency, ma'am, I provided her with the information.
At base doon, dinesisyonan at inaprubahan niya ang lahat ng ito?
Yes, and from that time, ma'am, we signed off on the document for submission to the Commission on Audit.
With the last touch or final sign-off being that of VP Duterte?
Yes, ma'am, being the head of agency, ma'am, we sought her approval on it, ma'am.
At sang-ayon po ba kayo na bilang yung ganong head of agency na si VP Duterte ang responsable at pinaka-responsable sa lahat ng iyan?
Well, being the head of agency, ma'am, I believe that kailangan niyang malaman lahat ng mga nangyayari. And I know, ma'am, na si Ma'am Inday really wants to know details, no, especially on implementation of the different activities that we do in the office. So it is really meron talagang involvement in terms of ensuring that things are properly implemented within the office.
And based on that knowing, batay sa kaalamang iyon, siya ang pinaka-responsable sa kabuang iyan.
Based on that, ma'am, being the head of agency, ma'am, I would say so, ma'am.
Alright. Gano'ng katagal nyo na po kilala si VP Duterte?
Siguro, ma'am, more than 10 years, ma'am. I started working together with her, ma'am, in 2008.
At saan po at so almost 20 years pala. So at saan po at paano nyo siya nakilala?
Nakilala ko po siya, ma'am, bilang Vice Mayor sa Davao City, ma'am. And then at the time, ma'am, when they were looking for several staff members for the office of the Vice Mayor, I submitted an application, ma'am.
At magkakilala rin po ba kayo ni Ms. Gina Acosta kahit bago po kayo nakipagtrabaho sa isa't isa sa OVP?
I knew of Ms. Gina Acosta, ma'am, during my employment, ma'am, with Sangguniang Panlungsod during the time ni Ma'am Inday as the Vice President, ma'am, and Vice Mayor as the Vice Mayor.
So prior sa OVP, magkakilala at magkatrabaho na po kayo?
Kilala ko po si Ms. Gina, nakikita ko po siya sa Sangguniang Panlungsod.
And then, what about po si Colonel Chica? Magkakilala na rin po ba kayo at magkatrabaho bago kayo magkatrabaho sa OVP?
I first knew of Colonel Chica, ma'am, when I was already with the Office of the Vice President, ma'am.
So would you say po na nasa circle of trust kayo ni VP Duterte? Kayo ni na Ms. Gina Acosta, Colonel Chica at kayo nga po?
Well, ma'am, I can only answer for myself, ma'am. In terms of working relationship, ma'am, I would say that I have the trust and confidence of the VP in terms of doing duties that are assigned to me.
Pero sasabihin nyo ba na walang trust at confidence si VP Duterte kay Ms. Gina Acosta?
I cannot categorically say, ma'am, but I would say, ma'am, na could be, baka meron po, considering that there are also duties and functions that are being entrusted to them.
In fact, kung mas candid pa po tayo, madali naman siguro kahit from an observation, at hindi lang observation dahil malapit yung katrabaho na may trust and confidence. What about po si Colonel La Chica? Sasabihin nyo ba na walang trust and confidence si VP Duterte sa kanya?
Considering, ma'am, that he is the group commander of the Vice Presidential Security and Protection Group, ma'am, I would say, ma'am, I would say that she may have the trust and confidence.
Again, kung mas kaya nating maging candid, of course, lalo na kung security officer ng isang public official, of course, may trust and confidence. Otherwise, hindi ipagkakaloob ang kaligtasan sa kamay niya. Lastly po, napaksa for now, paano pong, and winding up Mr. Presiding Officer, paano pong sinama kayo ni Ms. Gina Acosta dun sa pag-encash ng mga cheque? Halimbawa, kung kailangan po ni Ms. Acosta ang tagabuhat ng bag, ng cash, bakit po kayo in particular ang sinama niya?
I cannot answer, ma'am, kung bakit ako po ang naisama ni Ms. Gina Acosta. But at
Hindi
the
lang
time,
naisama, pero sabi nyo, hiniling niya sa inyo na
Yeah.
kayo yung sumama.
Yes, ma'am.
So, bakit po?
When she requested me, ma'am, to accompany her, ma'am, sinamahan ko naman po siya, ma'am, because at the time na itanong niya na magpapasama siya, I was available naman, ma'am. And because of the request, ma'am, I accompanied her going to the bank.
So, simpleng nagkataon, walang reason kung bakit kayo yung isinama niya. You were the person the warm body who happened to be available.
Again, ma'am, I cannot say kung ano yung pinaka-reason behind po ni Ms. Gina, but when she requested me that I accompany her, ma'am, I said yes, ma'am. Nung
Winding up on
nag-request
this topic, Mr. Presiding Officer, sinamahan niyo rin po ba si Ms. Gina Acosta nung iabot kay Colonel La Chica yung pera?
No, ma'am. I actually did not, I was not aware, ma'am, of the arrangement, ma'am, with Colonel La Chica, ma'am.
At huli po on this topic, Mr. Presiding
Kindly
Officer.
wind up.
Winding up, Mr. Presiding Officer. Nabanggit niyo po na alam ninyo yung joint circular on confidential and intelligence funds. Hindi niyo po ba naisip na violation ang pagbibigay ni Ms. Acosta kay Colonel La Chica ng bulto-bultong cold cash?
Ma'am, based on, because again, ma'am, I was not aware of the arrangement, ma'am, but when I was doing the replies, ma'am, to the AOM, and of course, I also checked on the JC, ma'am, the pagpili po ng mga ng person to implement the different activities of the confidential activities and to designate a security officer is indicated also in the JMC and is within the authority of the head of agency. So yun po yung pagkakaintindi ko at the time. So with that, ma'am, I saw it that it was the manner of how the funds were handled, ma'am, was following a regular process, ma'am, based on the JMC, based on my understanding.
But then again, Mr. Ortonio, in closing, yung close reading ng JMC, na sabi nyo nga familiar kayo, would show na hiwalay pa sa usapin ng implementation, yung paghawak ng pondo ay dun lamang sa isang katulad ni Ms. Gina Acosta at hindi pwedeng ipagkatiwala bilang accountable officer siya, hindi pwedeng ipasakamay sa iba.
Ang understanding ko po, ma'am, yes, the disbursement is with the special disbursing officer, but the implementation, ma'am, was done through the security officer.
Of course. Hindi po ko tinatanong yung implementation. Tinatanong ko po yung violation ng JMC na alam ninyo nung tinurn over ni Ms. Gina Acosta ang bulta-bultong cash kay Colonel La Chica. Something that I simply think should not and could not have escaped your eyes, Mr. Ortonio?
Yes, ma'am. Again, ma'am, based on for the 2022, ma'am, I could not recall that that was a concern, ma'am, in the AOMs, ma'am. Although for the 2023, ma'am, na notice for disallowance, ma'am, it is subject for reply also on our end, ma'am, and we are currently drafting also a reply for that one.
And of course, given the strict internal controls na siguro kayo yung pinaka may oversight sa opisina, even prior further communications from COA, after yung unang pagpansin nila sa last quarter 2022, edi dapat nag-exert kayo ng higit na pagbantay the next 3 quarters of 2023.
Ma'am,
Kindly wind up, Senator Judge Riza.
Yes, winding up now, Mr. President.
Your Honor, we were able to receive the audit observation memo for 2022 in October 4 of 2023. So we got the observations po, ma'am. And we already got the AOM, ma'am, and yung 3 quarters for 2023 was already implemented.
Again po, Mr. Ortonio, even prior any further communications from COA, dahil familiar kayo sa JMC, sabi nyo nga, dapat alam nyo na po yun. Dagang salamat, Mr. Ortonio.
Thank you, Senator
Maraming
Judge
salamat po,
Risa.
Mr. Presiding Officer.
Senator Judge Lacson, you may proceed with the interjections when you're ready, sir. You have 2 minutes.
Thank you, Mr. Presiding Officer. Good afternoon, Mr. Ortonio.
Good afternoon, Your Honor.
You know, even setting aside your educational background and your work experience, it is not difficult to conclude na matalino kayong tao, you're an intelligent person, and an intelligent witness, as well. So, kayo po yung Assistant Chief of Staff ng OBP.
Yes, Your Honor.
Kayo rin yung concurrently Administrative and Financial Officer.
As the Assistant Chief of Staff, sir, I oversee the Administrative and Financial Officer.
Yeah.
Yes, sir.
So, effectively, kayo yung Admin and Financial Officer.
Yes, sir. I oversee the Admin and Finance, sir.
You know, kanina kasi, upon questioning ni Attorney Christine, she kept referring to the regular programs under the Office of the Vice President. No? Natatandaan niyo yun? So it aroused my curiosity. No? Pina-pull out ko sa staff yung General Appropriations Act ng 2022 as well as 2023. So we found out, papabasa ko sa inyo para hindi ma-charge sa oras ko. No? For 2022, under the Good Governance Program, merong 621.6 million pesos. Pakibasa nyo na lang, kayo na lang.
Sorry, sir. Hindi ko makita, sir. Okay. For fiscal year 2022, sir, under Good Governance Program, General Appropriations Act, 621.6 million, sir.
Please continue.
And then Physical and Financial Plan for the Confidential and Intelligence Funds, 125 million for the 4th quarter. And then for fiscal year 2020...
No, under the same program, Good Governance Program.
Good Governance
under
Program.
Under the PFP.
Under the PFP,
okay, please
sir.
Continue.
And then for fiscal year 2023, Socio-Economic Program Delivery, 2.21 billion billion under General Appropriations Act, and then 500 million for 125 million first quarter, 125 million second quarter, 125 million third quarter, and 125 million fourth quarter.
Okay. For a total of 500 million more.
500 million.
Okay. Next slide. I-juxtapose ko naman yung... Next slide, wag na yan. I-juxtapose ko yung 2022 at saka 2023 OBP Physical and Financial Plans, Confidential Intelligence, dalawang budget years. Pakibasa yung last quarter, physical target.
Baka pwede pong ma-request na
Zoom. Pwede bang hindi charge sa time ko ako magbabasa? Okay. Letter A, number of identified areas with surveillance conducted and monitored. Letter B, percentage of activities implemented without untoward security-related incidents. Paulit-ulit po ito, no? So, sabi ko kanina, kayo naman ay mukhang matalinong tao at matalinong witness. Ano pong analysis nyo dyan?
On the...
Very simply, paano nyo i-analyze yung ganitong klaseng mga descriptions?
These are the activities that will be done, sir.
I know. Pero
Yes,
kung
sir.
i-analyze nyo, ano ibig sabihin nito? Hindi ba ito insulto sa common sense? Hindi man lang nyo binago ng konti, at least si Colonel Chica siguro ito. No? Unang-una, regular program, sana man lang, pagdating sa PFP, binago nyo yung nomenclature. Tapos, under the physical target, yung column, sana man lang, binago nyo yung activities. Copy-paste eh. Again, ulitin ko, tingin ko sa inyo, matalinong tao, matalinong witness, anong tingin nyo rito? Kung i-describe nyo in one word.
Sir, I cannot...
Ako na mag-describe. I think it's stupid. Sana man lang, binago-bago niya ng konti. Maraming salamat, Mr. Presiding Officer.
Next would be Senator Judge Padilla.
Maraming salamat po, Ginoong Tagapamahalang Hukom. Meron lang po akong tanong sa ating saksi. Opo. Ginoo, sa palagay niyo po ba karapat-dapat lamang na gumamit ng alias kapag confidential fund ang pinag-uusapan?
Sir, as someone who does not know, sir, implementations of parang mga confidential activities on the ground, sir, I cannot, hindi po ako makakasagot ng maayos, sir, kung pwede po ba or hindi. But based on information that I got, sir, when I consolidated the answers for the AOM, sir, hindi naman po siya na-mention sa akin po ni Colonel Chica. But I know, sir, that activities, confidential activities are considered to be sensitive. And there might be individuals or groups that need to be somehow protected, sir, because of the information that you would be getting from those people, sir. So, yun po yung tingin ko, sir. Hindi ko categorically masasabi na pwede po yung alias or hindi. But going back to the JMC also, sir, sa Joint Memorandum Circular, there is no specific provision, sir, that indicates kung paano po yung paglagay ng mga pangalan sa documentary evidence of payments.
Okay, maraming salamat po. Meron po akong tanong sa prosecution. Magandang hapon po. Napakaganda po ng inyong ngiti.
Good afternoon din po, sir.
Opo. Batid po ba ninyo ngayon, mga petsa na to, kung ano ang pinagdiriwang natin sa Pilipinas? Magmula po 19 hanggang 30.
Buwan ng wika daw po, sir.
Bukod po sa buwan ng wika,
National Heroes Day.
National Heroes Day. Ito po ay hango sa ating mga bayani. Tama po ba?
Opo.
Opo. Naniniwala po ba kayo na ang ating mga bayani ay may mga alias? Kilala niyo po ba sila Di Masalang?
I'm sorry po sa aking history teacher.
Ayan, opo.
Hindi ko na po maalala.
Ito po ang pinakamagandang panahon para maipaalala po sa inyo na ang ating mga bayani ay gumamit ng mga alias. Di Masalang, Siling Labuyo, Tikbalang, Tagailog, May Pag-asa, Buwan, Magdalo, Leon Kilat, Vibora, Lakambini, Paralitiko, Dimas, Alipato, Liwanag, Balite, at marami pa pong iba. Ano po ang kahalagahan dito, palagay po ninyo? Ang alias po, anong kahalagahan?
Well, first, Your Honor, I cannot comment because I'm not sure of the circumstances surrounding their use of alias. Under the anti-alias law, sir, inaalaw naman po yung paggamit ng alias provided kailangan po nakabanggit din, nakadisclose kung ano yung real name. So it's not completely prohibited provided they also provide the real
Opo.
the real name.
Pakisagot lang muna po yung tanong ko bago po yung explanation po ninyo. Pakisagot lang po kung narinig nyo na po yung mga alias na yan. Ngayon lang po nyo narinig.
Some of it po, Your
Ayun.
Honor, to be candid, some of it I've already heard.
Magmula po 1892 hanggang 1896, ginagamit po nila ang mga alias na yan. Nagkaroon lang po ng isang traidor, ang pangalan ay Teodoro Patiño, na nagbulgar sa Katipunan. Alam po ba niyo yun?
Yes, Your Honor. But the circumstances then were different because we were
Bakit po iba?
under...
Bakit po iba? Bakit po na iba?
May gera po nun, sir, and we were under
Wala po ba tayong
occupation.
gera sa NPA? Ang NPA po, merong mga alias. Meron pong ka-Cobra, ka-Agila, ka-Lawin, ka-Tigre, ka-Kapre, ka-Sirena, ka-Adobo, ka-Sinigang, ka-Pansit, ka-Tinola, ka-Sile, ka-Kamote, ka-Bawang, ka-Maxi, ka-Labuyo.
Strictly speaking,
Lahat po yan
sir,
ginagamit
iba po
na
yung
alias.
internal armed conflict, iba naman din po yung war.
Bakit po na iba? Pareho po itong clear and present danger sa atin. So ang gusto ko lamang pong ipaalam sa ating prosecution na napakahalaga po ng alias sa panahon ng... Kayo po, sagutin po nyo. Sa panahon ng...
Gera, sir, Your Honor.
Ang confidential po. Ang pagkilos confidential ay napakahalaga at hindi po ginagamit ang pangalan at hindi po pumipirma. At alam niyo po ba, noong September 12, 1896, anong nangyari? Nagkaroon tayo ng 13 martires. Yung mga nagtraidor ay itinuro ang mga totoong pangalan, totoong lugar, kung nasaan yung mga sumusuporta sa Katipunan.
If I may, Your
One
Honor.
last na lang po.
Kindly wind
One
up,
last,
Senator
one
Judge
last na lang
Padilla.
po.
If I may, Your Honor, just address your question earlier. With all due respect, Your Honor, the prosecution respectfully submits that whether the use of alias is allowed or not and whether it's necessary or not, to us, that is a non-issue because that was never raised
Hindi po
by
pwedeng
the...
maging non-issue sapagkat ito po ang ipinalalabas ng prosecution.
If I may,
Na
Your
may
Honor,
mga pangalan, na mga katawa-tawang pangalan. Mas nakakatawa po itong mga pangalan ng mga nangyari nung araw.
with all due
At isa
respect,
pa
Your
po,
Honor,
isa na lang
if
po. Kasi isa na lang po.
Kindly wind up,
Ito
Senator
na lang
Judge
po.
Padilla.
Kilala niyo po ba kung sino si Marcial Bonifacio?
to be candid, Your Honor, I'm not...
Sino po?
familiar.
Si Benigno
I'm sorry,
Aquino
Your Honor.
Jr. Si Ninoy. Siya mismo may alias. Maraming salamat po.
Your Honor, if I just may, Your Honor, just to set the record straight, because it was made to, with all due respect to the Senator Judge.
Mr.
It was...
Presiding Judge, allowed ba yun?
I was about to make a ruling.
Maraming
Senator
salamat
Judge
po.
Padilla. There was no question posed or poised. Attorney May. Let's proceed to the next Senator Judge who will interject. By the way, did you intentionally get rid of the platform?
Yes, Your Honor, because you were not expecting that I'd be called again, Your Honor, to make way for the Honorable Chair of the panel of
Understood.
prosecutors, Your Honor.
Understood. Senator Judge Aquino,
Thank
you're
you.
recognized for interjection. You may proceed, sir. When you're ready, you have 2 minutes.
So bago po yung 2 minutes, Mr. Presiding Officer, tama po, si Ninoy Aquino po ang kanyang alias ay Marcial Bonifacio para makauwi po siya sa Pilipinas nung nasa Boston siya. Oho. Pero wala naman ho siyang confidential funds na, wala ho siya sa mga AR na confidential funds. Lilinawin ko lang ho. Okay. Pagdating ho sa prosecution, ang posisyon ng prosecution, yung mga pangalan ay totoong tao, di ba? Correct, no? You have not really mentioned aliases in any of your... Wala. Could you respond quickly? We have talked about aliases. Is the prosecution talking about aliases?
That was never our point, Your Honor. In fact, the point of the prosecution is that that was never raised by the defense, either in their answer or in their pretrial brief, Your Honor. So to us, that should be a non-issue because even them, they never claimed that in any of their pleadings before this
thank you.
honorable court.
Okay, klaklaruin ko lang ha. Ang siyang tao lang pong nagsabi na alias po sila, si Ms. Gina Acosta, in her testimony. Kanina po, sabi niyo rin na Mr. Ortonio na hindi siya alias or hindi niyo alam. But si Ms. Gina Acosta, in her testimony, did admit that in her perspective, these are aliases. No? Just for the record po. Okay. So ito po yung mga tanong ko po. Sana po ito lang 2 minutes ko, Mr. Presiding Officer. So unang-una, Mr. Ortonio, you're very competent. Thank you for your answers. And I want you to answer just very candidly, no? Ano po yung naging personal reaction ninyo nung napag-usapan na yung possible misuse of the confidential funds at nung na-bring up na yung mga tawagin na nating katawa-tawang pangalan na parang klaro naman ay hindi naman talaga totoong tao. Ano po yung personal reaction po ninyo?
Initial reaction, sir, would be, of course, merong questions, sir, no? There would be questions. But again, sir, I go back to the presumption, sir, that there is regularity in terms of the implementation, sir.
Okay. So, may I ask, since you're in the top leadership of the OVP, nung nabibring up na to, ano yung personal reaction, kung alam nyo lang, ng Vice President, ng Chief of Staff, other leaders in your group, nung napag-usapan na posibleng nabigay yung pera sa mga kakaibang pangalan o baka hindi totoong tao, what was your reaction? What was their reaction? Would you know? Nag-meeting ba kayo? Did you call for an emergency meeting? Did you have a huddle in your office to talk about this?
Sir, because yung AOM, sir, because it was sent to my office, sir, pina-personally received sa akin, sir, on behalf of the Vice President. Of course, I provided a copy to the Chief of Staff, sir, and the Vice President. Ang naging instruction lang naman po sa akin, sir, was to respond to the AOMs and make consultations with the Special Disbursing Officer and Security Officer para masagot yung mga concerns or issues raised by COA.
Okay. Yan yung mga actions nyo, Mr. Ortonio. I'm asking about your reaction. Kinabahan ba kayo? Were you worried? Were you concerned? Was there any concern shown by the Vice President, by the Chief of Staff, by people in your office na posible itong perang ito ay hindi nagamit sa tama?
On the matter of concern, sir, I think there is a concern considering that there is already an immediate instruction, sir, to reply to the AOM.
That's the
sir.
AOM. Let's go to the bringing up of these names in Congress. Nung lumabas na yung piatos, pusa, pagong, mga ganyan, were you concerned na yung pera ng bayan posibleng hindi nagamit sa tama at ito'y pinirmahan mo at ito'y nakapangalan sa inyong opisina, for example? Were you concerned?
Ano, sir?
Honestly.
Parang immediate reaction, sir. Yes, sir. But nung as the hearings went on, sir, parang binabalikan ko yung AOM, sir. Hindi kasi po siya na-raise doon sa AOMs. So, parang nabawasan po yung concern ko, personal concerns ko with those acknowledgement receipts.
Did you call for an internal investigation after na-reveal yung mga pangalan na kakaiba? Nagpatawag ba kayo ng investigasyon sa inyong opisina?
I personally did not, sir, hindi na po ako nagpatawag.
Did your office call for an internal investigation?
On that matter, sir, I do not know, sir, if there is an instruction coming from the head of agency, sir. But personally to me, sir, none, sir.
Okay. So, ito kasi, Mr. Ortonio, no, sa aking opisina, more than 10 years ago, meron kaming nahanap na isang staff na ibang resibo yung ginamit sa liquidation. Wala pa atang 5,000 pesos to sa totoo lang. Hindi nga niya binulsa eh. No? Meron siyang dapat hotel receipt, nawala niya, gumamit siya ng hotel receipt ng ibang tao. That already elicited an internal investigation on our part. In the end, pinaalis namin yung staff na yun na kilala namin, kaibigan namin. 5,000 lang yun. So the common response we are looking for is that kapag pera to ng bayan, action ka agad at hanapin nyo talaga kung saan nagamit tong pera to. Kaya I'm really wondering what were the actions and reactions of people. So ito yung tanong ko rin, no? Mahalaga ba sa inyo, mahalaga ba sa iyo, sir, na yung perang ito ay nagamit sa tama? Na hindi ito nagamit sa mali o na bulsa lang?
Yes, sir. It is important to me, sir, because in the years na nakasama ko rin po si Vice President Sara Duterte, sir, she also would want na money is spent properly for what it is intended to be used for.
Okay, last question, Mr. Presiding Officer. During all of this time, pinatawag mo ba si Colonel La Chica o pinatawag ba siya ni Chief of Staff Lopez or ni Vice President? Would you know? Kinausap mo ba? Tinanong mo ba? Colonel, itong mga pangalang ito, sino ba talaga to? Totoo ba to? Bakit nakalagay medicine pero cash talaga yung binigay? Kasi sa totoo lang, sir, yung nakalagay doon gamot pero cash ang binigay na pambili ng gamot, cash pa rin yun. Diba? So in short, yung 500 million, parang puro cash yun. Wala man talagang supplies or tables and chairs because that presupposes na ang binili nyo yung tables and chairs or supplies. You actually gave cash na 500 million. Pinatawag nyo po ba si Colonel La Chica at tinanong, as public officers, we have to exercise the diligence of a good father of a family. No? That's in our oath. So pinatawag niyo po ba ng inyong opisina at pina-explain kung nasaan ba itong peran to?
Sir, I was only able to request na makausap si Colonel La Chica in relation only to the response to the AOM, sir.
So hindi niyo po natanong itong mga specific questions na ito dun sa mga specificong mga pangalan, mga AR, mga ganyan?
At that time, sir, when I was drafting the AOM, sir, no, sir, because I had no knowledge, sir, of the AR, sir.
Salamat, Mr. Presiding Officer.
Thank you, Senator Judge Aquino. Senator Judge Erwin Tulfo is recognized.
Thank you, Presiding Officer. Ginoong testigo. Alam niyo ba na si Colonel La Chica ay hindi po banded? And therefore, wala pong karapatan na mag-disburse ng CIF. Alam niyo po ba ito? Hindi.
I know that si Colonel La Chica po is not bonded and as far as I know po, ang special disbursing officer po is si Ms. Gina Acosta.
Pero sa pagkaalam po ninyo, pwede po siyang humawak ng ganyang kalaking pera at ayaw mo ninyong sabihin na disburse, kundi implementation na may kahit na hindi po siya banded, pwede siya mag-disburse or mag-implement ng ganong kalaking pera.
Sir, I believe, sir, with his designation as the security officer, sir, he was tasked to implement the different activities on ground.
So, hindi nyo na po question si Ginang Acosta or si Colonel La Chica dahil may instruction po sa task. Tama po ba yun? Is that to my understanding, sir?
Hindi ko na po natanong, sir, because there is already a delegation or designation for the both of them for the the different tasks that they
Saan
will
po
be
galing
doing.
yung designation, sir? Can
The
you recall my memory?
The designation po, sir, came from the head of agency, sir, the Vice President.
All right. Sir, sabi mo kanina, I don't know kung kalimutan ko, nasa break room po ako kanina. Sabi mo, wala kang alam paano ginastos ang confidential fund when nag-usap po tayo. Tama po ba yun?
Yes, sir.
You have no idea. Pero I just was wondering, bakit kayo po ang sumasagot ng Audit Observation Memorandum o AOM ng COA kung wala kayong alam sa paggasta ng confidential fund? Gayon, ang AOM po, tama po ba, correct me if I'm wrong, ay ito po ay kumikwestiyon sa mga errors, exception, or deficiencies sa audit po ng COA?
For my office po, sir, whenever we receive AOMs, for our officers sa OVP, when we receive AOM, sir, it's the chief of staff or the it's the chief of staff or the chief of staff and the assistant chief of staff, sir, who responds to AOMs on behalf of the institution.
Pero sabi niyo po, kayo po sumasagot ng AOM.
Yes, sir. That's part of the tasks that are given to us, sir, together with the chief of
But
staff.
how can you, I was just wondering kanina po, sir, how can you answer questions, queries, kung wala na pa po kayong alam? Paano niyo po masasagot ng tama? The only way to do that is you will lie.
That's why po, sir, meron pong instruction that was given to me, sir, by the head of agency, sir,
Na?
to talk with the special disbursing officer and the security officer para makuha po yung mga information from them and malatag po doon sa reply to the AOMs.
So your reply was only based on what they said, what they told you.
That's correct, sir.
Ayon. Without documents, resibo, etc. None of that. Just plainly na. Ginoong Ortonio, dito po namin ginastos yung pera. Blah, blah, blah.
Yes, sir. I consulted with them, sir, for the reply, sir.
Hindi ka ba, kahit na katiting man lang na duda, sir, na medyo mali yata ang paggasta ng confidential fund ng OVP ni Colonel Chica, wala, hindi man lang sumagi sa'yo na medyo may duda ka na, something is wrong here. Wala man lang, none at all.
At that time, sir, may yung mga issues naman, sir, and when I consulted with the security officer, he was able to provide a reply naman, sir. So, although yes, initially, parang you would question, sir, no? But with the replies that I got from the security officer, sir, we were able to respond to them already to COA.
The reason why I asked you that, ginong witness, was that nandiyan po kayo, syempre po yung tiwala ng VP po sa inyo. Di mo lang ninyo naisip na, teka mali ito, baka sumabit si VP Sara, sumabit ang OVP. Baka hindi naman talaga nagastos ni Colonel Chica, baka ay hindi talaga napupunta sa kungkan. Hindi ho lang ninyo naisip. Or didn't you tell the Vice President, ma'am, ano ho kaya? Pwede bang tanungin ninyo ito or pwede ba silipin? Nada daw, hindi mo lang nakausap si VP. Hinayaan nyo lang hinayaan na tumuloy-tuloy for several months, several quarters yung ganitong klaseng expenditure. Nobody informed the Vice President.
Sir, hindi naman po na hinayaan, sir, because all the replies naman po, sir, are also given to the Vice President for her review and final approval before it is being signed and to be sent to the Commission and Audit.
So, when you sign the report, sir, alam na po ni VP. Is that what you're saying? Nakita niya na po na pinambili ng ganito, ng information, ng gamot, ng mga lamesa, na alam na ng VP before you signed it.
Before I signed it, sir.
So, dumaan na sa table ni VP.
Yes, sir.
Kindly wind up,
Thank
Senator
you
Judge
po,
Irwin.
Ginong Testigo. Mr. Presiding Officer, thank you.
Thank you, Senator Judge Irwin. To avail of the first round, Senator Judge Marcos, you are recognized, ma'am. You may proceed when you're ready. You have 2 minutes.
Yes, maraming salamat, Mr. Ortonio. Medyo nalilito lang po kami dahil paiba-iba yung explanation. Nag-umpisa sa PFP. Bakit iba yung 2022 PFP kung saan maliwanag na nakasaad good government lamang. Pero nung nagsulat kayo, yung request ninyo sa DBM, noong 22 August ng 2022, ang sinabi na, dalawang bagay. Good governance plus conduct of official engagements and functional representation in international and domestic events. Bakit nagbago na siya samantalang dapat yung request talagang parehong-pareho dun sa PFP?
Ma'am, I cannot specifically answer, ma'am, on kung bakit po good governance lang po yung nailagay doon because, again, ma'am, I was not hindi po ako part ng pag-craft nung physical
nung
PFP po,
Hindi ka pa kasali noon sa PFP, ganun ba yon?
Yes, ma'am, I'm not part of the drafting of the PFP.
Pero hindi kayo nasabihan na hindi ito matching doon sa PFP, yung request na sinulat?
There was no comment, ma'am, when we submitted it to the DBM, ma'am.
Tapos, nung certification na, bale liquidation na to, nung 17 October 2023, nagbago na naman. Ang sinabi na naman, hindi good governance, hindi na conduct of official engagement, ang sabi na no untoward incident in the implementation of OVP programs. Bakit pa iba-iba yung wording maski sa certification?
Again, ma'am, for the certification, ma'am, I cannot provide information, ma'am, because it was the security officer who handled it, Your Honor.
Akala ko may supervisory and administrative power ka kasi nga assistant kayo ng Vice Presidente. Hindi ba nagre-report sa inyo yung mga security officer kahit papano? Kasi madadamay ka rin yan sa COA. Bakit pa iba-iba? From PFP to budget request to certification, hindi nagtutugma.
First, ma'am, on the matter of the different wordings, ma'am, if I can recall, Your Honor, it was never raised also in the audit observation memo, ma'am. So it is something na we did not anymore look into when we were preparing the replies. And then for the second concern, ma'am, if the security officer is reporting to me, ma'am, unfortunately, ma'am, the security officer does not report to me. I only handle overall supervision for the Administrative and Financial Services and Strategy Management Office in relation to regular funding po, ma'am.
I see. So yung security officer, kanino nagre-report?
The security officer, ma'am, directly reports to the head of agency, Vice
So kaya
President.
sa iyo, Mr. Ortonio, at saka kay Attorney Lopez, hindi na nagre-report yun?
In the performance po ni Colonel Chica as security officer, no longer, ma'am.
So masasabi mo ba na wala kang personal knowledge kung saan ginastos ni Colonel Chica dun sa confidential funds?
No, ma'am. I would have no personal knowledge, ma'am.
Okay, that will be all. Maraming salamat po.
Thank you, Your Honor.
Thank you, Senator Judge Marcos. Senator Judge Rafi Tulfo, you are recognized, sir. You may proceed when you're ready, and you have 2 minutes.
Mr. Witness, sakitin ba ang marami sa inyong mga informants? May mga malalang sakit ba sila?
Sir, that I would have no personal knowledge po, sir.
You should. Kasi ito, ang dami. 170,000, 50,000, 200,000 each informant. So para mabigyan nyo ng napakalaking halaga bawat isang informant pambili ng gamot, dapat magtataka ka. Anong gamot kayong bibili nito? Bilang isang intelihenteng tao, I know you're very intelligent, you're very smart. Did you not try to ask? O at least nagtaka? Baka may rheuma, arthritis, nagpapakimo, should have asked. At kung mga bata nga, inquisitive yung mga bata, anong gamot ang bibilhin mo? Paghingan mo ng pera ng bata, kunyari, Toy, pahingin pera, bili akong gamot. Anong gamot bibilhin mo, kuya? Bata yun ha, grade 1. Ikaw pa kaya? Why?
At the time po, sir, I did not ask anymore kay Colonel Chica, sir.
Why not?
Because, sir, I already gave I trusted what the security officer mentioned to me, sir.
But it is your responsibility to know. Kasi ikaw po ipirma doon sa AOM.
Sir, in terms of the responsibility to know, sir, I'm not sure, sir, if I'm the one who's responsible to know, sir. But the
So
task
you're
to
not
me,
sure. That means, ayoko nang gumamit ng pangsalita. It's unbelievable. It defies logic talaga, really, sir. You're not really making sense at all. Anyway, move on tayo. Yung, alam mo naman sa DOH, nagbibigay ng libreng gamot. Meron
Yes,
kayong mga medical assistance program.
yes, sir.
Oh, ba't di nila kayo humingi sa DOH? In fact, by the hundreds of millions and billions, nag-expel lang dyan sa bodega ng DOH, natatapon lang. Sayang. So dapat humingi na lang kayo sa DOH. Bigyan nyo lahat ng informant nyo ng kung anong klaseng gamot. Libre pa. Nakalibre kayo.
The wisdom behind how the confidential funds were implemented, sir, I cannot answer, sir, because Again, sir, I am not the main implementer for the said activities,
Kaya
sir.
nga, Mr. Smart Guy, nung makita mo na ang dami mga informant na binigyan ng mga hundreds of thousands each para sa gamot, you could have asked La Chica and said, La Chica, bakit di tayo pumunta sa DOH, maghingi tayo ng gamot para makalibre, makatipid tayo sa confidential funds. Libre naman sa DOH. Pag Office of the President maghingi, may budget, meron kayo allocation doon, I'm sure. In fact, sa Davao, ginagawa nyo na yun eh.
Sir, that I cannot answer, sir.
So again, it defies logic. Hindi po kapani-paniwala ang mga pinagsasabi mo. Sir, for me, it really defies logic. Sayang po yung pagkatalino mo rito. Nasira po yung pagiging isang matalino mong tao. Nakakahiya po dun sa mga eskwelahan na kung saan ka nag-aral at nag-graduate. Because ngayon, pinakita mo na nagsasalita ka na para kang, sorry sir, nagtatanga-tangahan. Salamat po sir. Pasensya na sir.
Your Honor, with all due respect, Your Honor, I personally take offense of that comment, sir. I actually just did my duty, sir. At the time, sir, I believe na yun po yung kailangan kong gawin bilang isang empleyado po, sir. And I did my work, sir, based on what was tasked of me, sir, including the limitations that I can do to the duty that I will be doing, sir.
So you're talking about limitation. Ikaw ang Deputy COS, and then malapit ka kay VP Sara, and then pirma mo ang nakasaad doon sa AOM. So karapatan mo po magtanong. Okay? Now, you're talking about taking offense. Paano naman po yung mga taong bayan? They're being offended sa paglulustay nyo ng pera. Lumilito na parang nilulustay ang pera dito eh. Pera ng taong bayan po ito ang pinag-uusapan natin. If you're taking offense, mas lalo pong offended ang napakaraming Pilipino ngayon. Kasi hindi mo pa naibibigay ang tamang sagot. Pero kung naibigay mo ng magandang sagot, logical na sagot, then mawawala po yung sama ng loob ng taong bayan sa inyo.
Sir, with all due respect, sir, I believe, sir, this matter of the confidential fund, sir, is still pending the final decision, sir. We are currently still submitting our motion for reconsideration on this one, sir. And we still have not received any final reply on this one.
What I'm talking about, sir, is yung mga sagot niyo po, it defies logic para sa isang matalinong tao. Kasi kung ako, sir, pinesenta sa akin yung mga ganong klaseng dokumento at nagtanong ako at hindi nasagot ng maayos, I will resign. Kaysa naman makulong ako. Kaysa naman maipit ako ngayon tulad nangyari sa'yo at saka mga previous witnesses. Di ba? Dalawa lang yun eh. Patuloy kang magbubulag-bulagan, pirma ka lang ng pirma dyan, nakapikit. Pero, ang consequence yan, maaari kang makulong, maaari kang makasuhan. Anything can happen. Or, mag-resign ka na lang. Kung ako, I will resign. Mapapahama ako dyan, ba't ako pipirma dyan? Bakit ako pipirma sa mga nakalagay pagong, piatos, pikit, etc., kung ano pa mga kengkoy na mga pangalan, I would not consent to that. Outright sabihin ko, pag hindi niyo ipaliwanag sa akin, I will resign. Period. Thank you po.
That was not a question, Mr. Ortonio, you need to answer. With the permission of Senator Judge Tulfo, may the chair replace the word nagtatanga-tangahan with feigning ignorance on the record? I see Senator Judge Tulfo nodding. So let the records so reflect the statement feigning ignorance in lieu of the Tagalog word mentioned earlier. Yes, Senator Judge Pangilinan is recognized. You have 2 minutes, sir. You may proceed when you're ready.
Yes, thank you. Before my time begins to run, can we have a request for the uploading of third quarter to, no? Yeah, okay. Again, good afternoon, Mr. Ortonio. This is the accomplishment report for the third quarter of 2023, July 14 to September 30. Now, it appears here wala na yung 40 million pesos worth of medicines. Correct?
That's correct, sir.
Okay. Meron siya nung last quarter, meron siya nung first quarter, meron siya nung second quarter. Pero nung third quarter, wala na. Sabi mo kanina dahil yun ang hinihingi nung mga informant. So, nung third quarter, wala nang hiningi. Ano yun? Gumaling na silang lahat?
That I cannot, again, sir, I cannot answer, sir.
Yes. At hindi ba you received the AOM on October? Sometime in October?
October 4, 2023, sir.
Ito, October 9. So doon sa October 4, when you received the AOM, nandun na yung findings na dinidisallow or pinapa-submit ang additional documents. Tama? For medicines, etc.
That's correct, sir.
Okay. So, mukhang hindi gumaling lahat nung binibigyan ng gamot. Ang nangyari, mukhang dahil nakita ninyo yung AOM at ipinagbabawal, binago ninyo. Tama po ba yun?
Sir, again, sir, I cannot answer kung binago yung accomplishment report, sir, because it's something that I personally did not prepare also,
Okay.
sir.
Now, I move on to another point. Sabi nyo, nung natanggap nyo yung AOM, you went point by point sa mga issues, tama?
Yes, sir.
Ang tanong, bakit di nyo binuksan yung sealed envelope dun sa ARs? Kasi andun lahat ng mga acknowledgement receipt. Bawal ba?
Sir, I did not open, sir, because at the time, sir, the AOM indicated that we are requested to submit the documentary evidence of payments. And
that is the acknowledgement receipts. That is what you are being required to submit.
To submit, sir.
So
Yes,
should
sir.
you not have gone through the acknowledgement receipts to check because you're being asked to submit the documentary evidence of payment and to check if the ARs are actually documentary evidence acceptable?
Sir, yun na po yung nabigay sa akin ng special disbursing officer, sir. So,
No, okay. The question is, why didn't you open the envelope?
Sir, I did not open anymore, sir, because at the time, sir, I also have a designation as
Were you instructed not to open it?
Sir, as liaison officer kasi, sir, I am not in the position, sir, to open yung sealed na
But you were
DEP, sir.
instructed to submit documentary evidence of payment. So you, in other words, you complied without going through the documentary evidence of payment? How can you now tell if it was documentary evidence of payment that you were submitting when you did not open the envelope? What were you submitting?
I personally did not open it anymore,
That's
sir.
why, but you were being required by COA to submit, to comply. So
Yes, sir.
So would you say that was substantial compliance?
Sir, yun po kasi yung na-require ng AOM, sir. So we submitted the documentary evidence
Kasi
of
ang
payment.
sitwasyon dito, dahilan mo o depensa mo na hindi mo na tiningnan o hindi mo nakita. Pero tama bang depensa yun? Na hindi mo nakita, kaya hindi mo masasagot? Kasi ganun din ang sinabi mo, wala ako doon, wala ako sa ground, I'm not in the implementation, kaya hindi ko masagot. Is that compliance with, the requirements of COA?
Sir, the duty po, sir, to ensure that the DEPs...
There was nothing to stop you from opening the envelope, right? There was nothing.
Sir, the JC, sir, indicates, sir, that there are only certain individuals who have access
You could
to
get clearance, could you?
Sir,
Of
that's
course.
what...
Of course you can.
I did not ask anymore, sir, because I parang respectfully in-acknowledge ko na kung ano yung nakalagay sa JC, sir.
In other words, you really did not go point for point as you earlier testified to. Kasi pag sinabi mo we went point for point, parang masinop yung naging trabaho ninyo. Di ba? Thorough. Point for point. Pero ang lumalabas dito ngayon, hindi nyo binuksan yung documentary evidence of payment, hindi nyo binusisi. Hindi ba? Sinabmit lang ninyo. Again, we're talking of hundreds of millions of pesos. And I'd like to think, being an intelligent Ateneo graduate, diba, that you would have exercised greater diligence as you tried to monitor, check on, supervise financial services head how government money was being spent. Yun ang tinatanong ng mga kababayan natin. Mahirap paniwalaan, I'll wrap it up here, na kayo ay gumastos ng 122 million para sa gamot na reward dahil nag-surveillance yung mga informant at nabigyan ng reward at hiningi nila gamot at hindi niyo binigyan ng gamot, binigyan niyo ng pera para sila nang bibili ng gamot. Sabi niyo usual yun.
Kindly wrap up, Senator Judge Pangilinan.
No further questions, Mr. President.
Thank you, Senator Judge Pangilinan. Finally, Senate President Gatchalian.
Thank you.
And then Senator Judge Padilla.
Thank you, Mr. Presiding Officer.
wrap it up.
Merong binabasa ko itong reply ninyo, Mr. Ortonio, to COA, dated November 30, 2023. At nakasulat dito, I'll flash it on the screen. Paki-flash na lang. Hence, the 125 million CF was fully utilized for expenses planned, implemented, and paid during the 3-month period covering October to December 2022. So, sino nagbayad ng 125 million in advance?
Sir, there was no payment in advance that was made, sir. All payments were made between the period of December 21 to December 31, sir.
But very clear kasi dito na binayaran na siya paid 3 months in advance. In fact, mayroon pa siyang months. And ito yung kadugtong ng sinabi ng ating presiding officer, obligation incurred. So, ang basa ko dito, nabayaran na siya. Kaya reimburse na lang ng 125 CF.
Sir, if I may be allowed, sir, to clarify, Your Honor, yung parang explanation from yesterday, sir. For the period of October to December 2022, sir, based on the information that was shared by the security officer, once we have already submitted yung PFP sometime in September, the security team, sir, meaning si Colonel Lachica, sir, already made coordination with informants or agents on the ground. As to the extent of the coordination that they did, sir, I am not privy to that anymore. However, when we received the SARO in December 13, 2022, which already indicates that we already have the funding for the confidential funds, that's the time that they were able to make definitive agreements with the informants on the ground. And once the payment, once the check has been encashed already, that's the time that payments were made between the period of December 21 to 31.
Mas realistic pa kasi kung in advance tapos reimburse kaysa 125 million gagastusin in 11 days. So mas realistic pa nga itong explanation ninyo kaysa doon sa 11 days na gagastusin. And we're talking about 845 acknowledgement receipts scattered all over the country. Kaya itong explanation ninyo mas realistic pa, albeit although violation ng joint circular.
So I'd like to point out lang, Your Honor, that there were no reimbursements made, sir, based on what was relayed to me, sir. There was no reimbursements
But
made.
this was
sir.
information relayed to you by Lachica.
Colonel Lachica, sir.
And itong si Colonel Lachica, kanina naririnig ko, hindi nyo alam yung direct na ginagawa niya, hindi rin alam ni Acosta. So, sino lang nakakaalam sa opisina ninyo tungkol sa confidential operations or itong paggastos, yung paggastos ng confidential operations?
For the confidential operations, sir, again, sir, I have no personal knowledge, sir. I would assume, sir, because meron po siyang designation from our head of agency, then the reportorial duties, I would presume, would be directly to the head of agency.
Which is si Vice President Sara.
Which is
So
the head
dalawang
of
tao
agency.
lang sa opisina ninyo, si Vice President Sara at si Colonel Achica lang, ang alam kung paano gastusin itong 500 million.
Sir, I would have no personal knowledge again, sir, kung sila lang pong dalawa, sir.
Kasi ikaw yung gumawa nung reply, pero galing sa Colonel Achica yung information, si Gina naman kahapon, ganun rin, di rin niya alam. So I'm trying to understand sino nakakaalam nung paggastos ng 500 million dahil hindi siya maliit na pondo eh. No, but based on your information, dalawang tao lang ang parang nakakaalam nito. No? Si Vice President at si Colonel Achica. My last question, Mr. Presiding Officer. Kanina nasabi nyo na based sa information, meron pang mga tao si Colonel Achica. Tinransfer ni Acosta yung pera, or dinisburse ni Acosta yung pera kay Colonel Achica. And si Colonel Achica, dinisburse niya ulit dito sa mga tao niya. So, double handling ang nangyari dito sa pera. So, paano natin malalaman kung talagang yung pera ay pumunta sa mga activities o tao na kailangan puntahan dahil ni yung accountable officer hindi niya na alam kung paano na-disburse yung pera doon sa mga informants. Anong kwento sa'yo ni Colonel Achica na umabot talaga dito sa mga informants?
Sir, based on what was shared to me, sir, Ms. Gina Acosta disbursed the amount to the security officer and then the security officer implemented it on the ground.
Yeah, but violation na kasi in disbursement to Colonel Achica eh. And then there's another violation na from Colonel Achica to some people who disperse the amounts. Ibig sabihin, ang daming taong humahawak ng pera bago umabot sa mga informants. So, in that sense, ang daming violation o tinakbuhan ng pera. So, thank you, Mr. Presiding Officer.
Thank you, Senate President. With the indulgence of Senator Judge Padilla, Senator Judge Camille Villar will be availing for a first round opportunity to interject. So I will recognize her first. Again, with your indulgence, Senator Judge Padilla, I see you nodding. Senator Judge Camille Villar, you may proceed when you're ready. You have 2 minutes, ma'am.
Okay, thank you, Mr. Presiding Officer. Good afternoon po, Mr. Ortonio.
Good afternoon, Your Honor. Mayong hapon.
So, mayong hapon din. I just have a few clarificatory questions for you, if you don't mind. Tama po ba kayo ang Assistant Chief of Staff ng OVP?
Yes, that's correct, Your Honor.
And kayo po ang sumagot dun sa AOM na pinadala ng COA. Kayo po yung nag-prepare ng report.
Yes, that's correct, Your Honor.
Yes, and ano yung what was the process in which that you did that? Or what were the things that you had to do? You prepared the AOM, you consulted with?
Nung na-receive po yung AOM, ma'am, I informed the Chief of Staff and the Vice President. And from there was an instruction to me to coordinate with the Special Disbursing Officer and the Security Officer, which I did also, ma'am. And then from their replies, ma'am, I drafted the response, and then I submitted the reply for final approval to the head of agency.
And of course, in your capacity as the Assistant Chief of Staff and in your own capacity, sa inyo pong palagay ay nagampanan nyo naman yung inyong role dito sa prosesong ito at nagawa nyo naman adequately yung report.
Yes, at the time, ma'am, yes, I would say so, ma'am. Because from the issues that were raised in the AOM and in the NS, marami pong mga concerns or issues na natanggal po doon sa final na natanggal doon sa notice of disallowance that we received.
Okay, and lahat yung mga requirements naman ay na-fulfill nyo naman dun sa report, right? A majority of it.
Yes, lahat po ng mga concerns that were raised, we were able to provide answers and supporting documents.
And doon naman sa, doon po sa AOM, anywhere in the AOM did it say that there was a misuse or misappropriation of the funds?
No, there was no mention po, ma'am.
Okay, and are the findings of the AOM final?
No, ma'am. It is subject for comments, ma'am. And right now, for ano po siya, ma'am, motion for reconsideration.
Okay. Yun lamang po. Maraming salamat. Daghang salamat po. Thank you.
Thank
you,
Your
Senator
Honor.
Judge
Thank you, Mr.
Camille
Ortonio.
Villar.
Thank you, Mr. Presiding Officer.
Senator Judge Padilla, you
Maraming
may
salamat
proceed
po.
with your interjection, sir. You have 2 minutes.
Maraming salamat po, Ginoong tagapamahalang hukom. Tuloy ko lang po yung ating tanungan. Opo. Pagkatapos po niyong sumagot, pwede pong pati na rin sa depensa. Meron din po akong tanong. Kanina po, nahinto tayo kay
Before
Marshal
you continue,
Bonifacio.
Senator Judge Padilla, next time, Attorney Christine, do you need a platform similar to it was Senator Attorney Lorna first asked for it, but I noticed the prosecution has one. Would you wish one to be provided for you at a future time, Attorney Christine, or the
Yes, Your Honor.
side of the respondents?
Yes, Your Honor. I would appreciate having that platform too.
Okay.
Thank you.
In the next hearing, Attorney Christine. Yes, Senator Judge Padilla, you may
Opo.
proceed.
Balikan ko po, naputol po tayo kanina. Opo. Naniniwala po ba kayo na ang confidential fund para yaan po ay makakuha tayo ng impormasyon para makasave ng buhay, para makakaroon tayo ng law and order?
If used properly, yes, Your Honor.
Okay. Opo. Kayo po, sa defense, naniniwala po ba kayo?
Yes, Your Honor.
Opo. Kung sa palagay niyo po, nung panahon na si Marshal Bonifacio ay may confidential fund at nalaman niya na merong magtatangka sa kanyang buhay, sa palagay niyo po ba buhay pa si Senator Benigno Aquino ngayon?
Well, assuming, Your Honor, that the foreign occupants were those lone threats to his life, then probably yes, Your Honor.
Salamat po. Kayo po?
Actually, Your Honor, I'm not aware really of the circumstances during that time, Your Honor. So
Okay.
I cannot really comment intelligently on that. Yes, opo. Yes, Your
Opo.
Honor.
Sige. Si Marshal Bonifacio po ang may tuturing natin na nagbigay ng daan para sa people power. Yung kanya pong pagkamatay. Opo. Siya po ay na-assassinate. Opo. Sa palagay niyo po ba, kung meron siyang confidential fund noong panahon na yun, ay nagkaroon siya ng information na merong assassination na magagawa sa kanya?
Likely, Your Honor.
Salamat po. Pangalawang tanong po. Palagay niyo po ba kung meron confidential fund si former Senator Angara, na sa ngayon ay Secretary ng DepEd, maaari po bang napigil niya ang mga shooting incident sa mga paaralan?
I cannot speculate.
Wala pong speculation. Sa tingin lang po niyo, kung meron siyang...
speculate.
Sabi niyo po kasi kanina, sumang-ayon po kayo, kung may confidential fund, maaring makapigil, makapagbigay ng kapayapaan, law and order. Sa palagay niyo po ba, kung meron siyang confidential... Ano lang naman po yun? Yes or no? Kung hindi po kayo naniniwala, hindi no?
No, Your Honor.
Okay, salamat po. Kayo po?
It can, Your Honor, if the purpose of the confidential fund is to conduct surveillance, Your Honor, on the threats.
So, kinda.
Yes.
Tama ba yung aking diction? Kinda. Salamat po. Salamat po sa inyong dalawa. Sa isang tanong na lang po sa ating saksi. Naniniwala po ba kayo na hindi pa naman talaga natapos ang investigasyon ng COA dito patungkol sa sinasabing akusasyon sa ating Vice President?
Yes, sir. Nasa stage pa po, sir, ng submission of yung decision for the motion for reconsideration. So, I would say that it's not yet final,
Hindi
sir.
po siya final. Yun lang po. Maraming salamat po sa inyo.
Thank you,
Maraming
Senator
salamat.
Judge Padilla. Senator Judge Lacson, you have 2 minutes, sir. You may proceed when you're ready.
Very
Thereafter, Senator Marcos, and then we're through.
Very quickly lang, Mr. Presiding Officer. ano na po ngayon yung status ng security classification noong inyong PFP covering the PAPs, programs, activities, projects na socio-economic at saka good governance?
Sorry,
Including, ano yung present security classification? Has it been declassified or is it still classified information?
Sir, I would have no idea po, sir.
Teka muna, terminated na po ba yung PFP? Terminated na? Tapos na?
If in terms of the activities, sir, I would assume, sir, na tapos na po siya,
Therefore, kung tapos na, declassified na.
As to the terminology, sir, unfortunately,
Declassified meaning hindi na ito classified information. You know, I'm trying to drive at this scenario, no? Kasi ang dami sa amin nagtataka talaga. Totoo ba talaga yung mga aliases? Totoo ba nakatanggap sila ng reward, ng informants money, para lang matapos na yung aming panghuhula? Baka pwedeng maipresenta all the documents relative to the PAPs, relative to the PFP, relative to the expected outcome. Para lang makapag-decision kami. Kasi sa ngayon, nanguhula kami. Saan ba napunta yung pera? Possible po ba yun? I'm also addressing that to the presiding officer. Is it possible for the court to issue subpoena ducis tecum just to settle this issue once and for all para makita natin saan ba talaga napunta yung pera so we can have informed decision at the proper time. Ngayon hula kami ng hula eh. Alam niyo, Mr. Ortonio, no? Misuse sa akin yung misuse, maski masama yung connotation legally, na misuse mo pero hindi mo binulsa, probably pwedeng patawarin siguro ng mga kababayan natin, di ba? Naawa ka doon sa mga pulis, sa mga sundalo, na misuse mo kasi hindi intended doon sa item sa GAA, pero tinulungan mo kasi marami nagkakasakit, naulanan, naarawan. Sa akin, medyo maunawaan pa ng publiko. Although, I'm not saying na hindi violation ng law kasi may technical malversation. But in the eyes of the public, pagka na-misuse, pero hindi naman ibinulsa, medyo subdued ng konti yung galit. Thank you, Mr. Presiding Officer.
To respond, as a general rule, the court should sit as a passive body, Senator Judge Lacson, and leave it up to the prosecution to subpoena documents they deem necessary to prove their case. However, the court is not without any power after both counsels have presented their respective evidences in chief to call a witness, recall a witness, call a witness that was not called by either or named by either party, and subpoena documents in connection with the subpoena ad testificandum ducis tecum may also be issued, citing as basis City of Cebu versus GACO, AMRTJ 82111, and People versus Valera, GR number 20-28-6. So at the appropriate time, Senator Lacson, the court can avail of that power.
Yeah, thank you, Mr. Presiding Officer, for the response. Kasi para hindi na tayo nanguhula lahat ito, 20 ilan tayo rito. Hindi natin alam kung talaga saan napunta yung pera. Of course, there's a presumption na nagamit na maayos. But still, there's that doubt. You cannot remove that because of the so many issues na lumabas dito sa aming trial. And we want to be satisfied. After all, we'll be deciding on the basis of evidence and kung anong tingin namin, kung ano yung tama o ano yung mali. Thank you, Mr. Presiding Officer.
We reserve that right. The court reserves that right, Senator Judge Lacson. Finally, Senator Judge Marcos for her interjection.
Yes, maraming salamat. At naintriga lang ako sa nasabi kanina, no? What's the documentary evidence of payment? Sa palagay ninyo, ano yung katibayan na nabayaran at hindi?
For the documentary evidence of payment po, we submitted the acknowledgement receipts.
Yung AR pa rin. In the context of rewards and incentives, what's the documentary evidence of payment?
Based on my understanding, ma'am, acknowledgement receipts.
AR
ma'am.
din. Wala talagang resibo, walang voucher, walang invoice. Ganun po ba?
Ang understanding ko po, ma'am, it's the acknowledgement receipts, ma'am, can suffice, ma'am.
And COA did not require OVP to submit what was inside that sealed envelope. Nasabi nga ninyo kanina, yung AR lang ang binuksan nyo, hindi na tinignan yung sealed envelope. Kasi ba hindi required ng COA yun?
Ma'am, when we submitted the initial po na comment ng COA is that we submit documentary evidence of payment to include also either ARs or official receipts. We submitted po ARs as documentary evidence of payment, and in the notice of disallowance po, there was no concern anymore in terms of the acknowledgement receipts, ma'am.
So inasmuch as yung COA did no longer ask for other documentation aside from the AR and the other documents submitted, is that the reason kung bakit hindi na niyo binuksan yung sealed envelope?
Ma'am, at the time, ma'am, when I submitted the documents, ma'am, and it was sealed, ma'am, as the role of the liaison officer, ma'am, who will transmit documents to the Commission on Audit, there is no specific na provision, ma'am, that the liaison officer needs to open it. I just need to transmit the documents to the Commission on Audit.
Thank you very much. At yun nga ang gusto ko i-clarify, hindi na kinailangan buksan yung sealed envelope dahil yun nga yung AR at yung mga dokumentong nabigay, yun na yung katibayan na nabayaran. Thank you.
Thank you, Your
Thank you,
Honor.
Senator Judge Marcos. Senator Judge Erwin Tulfo.
I know, Mr. Presiding Officer, we're in a hurry now, pero just a quick manifestation, Mr. Presiding
Yes,
Officer.
you may proceed,
Sir,
Senator Judge
may
Tulfo.
I once again encourage both counsels, the prosecution and the defense, to consider presenting the individual who appears to be the missing link in the testimonies we have heard so far. Ilang araw na po ito, Colonel La Chica, even Colonel La Chica, sa mga TV po kanina, kagabi, willing po siya mag-testify dito. Maging si Defense Secretary, sabi niya gano'n, pinaubayan na namin sa Senate, si Colonel La Chica. I understand, Mr. Presiding Officer, we cannot compel him to appear, but he has been repeatedly named by several witnesses, and it may be helpful to this court to hear directly from that individual so that gaping holes in the testimony may be clarified and the facts may be properly connected. I'm sure lahat po ng Senator judges would like to ask him, ano ba, saan mo ba dinala? Totoo bang inutusan ka ni BP? O sarili mo lang yan, binulsa mo? I have a lot of questions, Mr. Presiding Officer. That's why I am praying that one day we will be able to talk to Colonel La Chica para matapos na ho ito. Iniiwan ho natin parang hanging po yung question. Matatapos na po tayo dito sa hostile witness, babalik na tayo sa witnesses ng prosecutors. Hindi pa natin narinig si Colonel La Chica. Mr. Presiding Officer, yun lang po.
The manifestation is noted, but as earlier ruled by the presiding officer, we cannot compel either party to call a witness. However, after the presentation of the party's evidence in chief, the court may exercise its discretion to call a witness based on the Supreme Court ruling cited by the chair earlier. That time will come should Colonel La Chica not be called by either party. So ordered. Just a few questions, Mr. Ortonio. To wind up, kayo po ang nagsagot o sumagot sa lahat ng AOM, notice of suspension at notice of disallowance. Tama po?
Yes, I'm one of the signatories po.
Wala po doon sa AOM o kahit anong notice of suspension at disallowance, yung issue tungkol sa mga alias sa acknowledgement receipt, na-raise po ba yun doon?
It was not raised in any of the observations from COA, sir.
So hindi nyo kinailangan sagutin yun?
We did not answer, sir.
Did not need to answer because there was no question posed?
Yes, Your Honor.
There was no issue also raised by COA with respect to spending it for 11 days, correct?
That's correct, Your Honor.
Wala rin kayong kailangan sagutin kaugnay nun.
Yes, Your Honor.
Now, the notice of disallowance for the 3 quarters of 2023, it was disallowed dahil base sa testimonya ni Gina Acosta, binigay niya yung pera kay Colonel Lachica. Tama po ba?
That's one of the observations po, Your Honor.
It's not an observation anymore, Mr. Ortonio. It's a notice of disallowance. Already.
Yes, that's correct, Your Honor.
So, sa tingin ng COA, bawal, illegal, hindi sang-ayon sa JC 2015-1 yung pagbigay ni Gina Acosta kay Lachica.
Based on the notice of disallowance, Your Honor, it indicates na the transfer from one agency to another, sir.
Kayo po, alam niyo po ba yun na binigay ni Gina Acosta yung huling quarter ng 2022 at 3 quarter ng 2023 kay Colonel Lachica lahat?
At the time, sir, no, I did not, sir.
At the time na binigay niya o at the time na nangyari na?
At the time na nangyari lahat, sir. I would have no personal knowledge, sir.
Hindi, pero nung ginawa mo yung AOM, unang sagot sa AOM, alam mo na binigay ni Gina kay Lachica?
Yes, sir, because they were introduced as the special
So,
officer.
October mo nang nalaman na binigay lahat ni Gina Lachica, October 2023, nung sinagot mo yung unang AOM para sa huling quarter ng 2022, doon mo palang nalaman na binigay lahat ni Gina kay Lachica yung pera.
That's correct, Your Honor.
Now, is Lachica an accountable officer based on the definition of the JC?
Based on the JC, sir, he is not an accountable officer, sir. It's the SDO.
And that is the reason why his signature does not appear in any of the documents submitted by the Vice President in relation to the AOM, NS, and Notice of Disallowance. Dahil hindi naman siya empleyado ng OVP, di ba?
Yes, sir. He's not an employee, sir. Although he's designated as the security officer.
Is that allowed, designating someone as a security officer who's not an employee of the office and being given that much money to disburse?
Sir, based on my understanding, sir, on the JC, when I read it, sir, there's no specific guideline, sir, on who to designate as security officer. But there is a provision po, sir, that the head of agency may designate a security officer to implement different programs and activities.
Now, you keep on mentioning that Lachica implemented and that Acosta disbursed. Ano pong definition nyo ng implement?
Implement, sir, would be to perform the different activities on the ground, sir.
Which entails what? How will he perform the different activities on the ground? In relation to confidential funds?
Possible, sir, to coordinate with the different informants or agents, sir. Yun po yung pwede kong mabigay na information, sir.
Mr. Ortonio, sa mga salitang perform at coordinate, saan po doon yung paggastos ng confidential fund? Perform, coordinate. Yun ang definition mo na implement.
Yes, sir.
Asan doon? Ba't binigay kay Colonel Lachica yung pera at ba't siya gumastos kung perform at coordinate lang pala? Did Colonel Lachica spend the money?
I would say so, sir, that being the implementer of the different activities, sir, he spent the money for the different confidential activities.
So Colonel Lachica disbursed the money for various confidential activities?
I would say, sir, na he implemented the different activities, sir.
Mr. Ortonio, nasa spent na tayo. Binago ko lang ng konting disburse, bumalik ka na naman sa implement eh. Again, spent, disbursed. It means the same thing. Ang
Sir,
gumastos na nung pera na binigay ni Gina, si Colonel Lachica o mga tauhan niya.
Sir, based on my understanding, sir, it's Miss Gina Acosta who disbursed the fund, sir. And then si Colonel Lachica po yung implement or conduct ng mga confidential activities
Hindi
on the
nagbayad si Colonel Lachica?
Part of his duties as the implementor, sir, nagbayad siya doon sa mga...
So is it your theory that Gina disbursed to Lachica as an end user?
Yun po yung ano ko, sir. That's my understanding po, sir,
Kung
on
end
that.
user si Lachica, bakit niya binawi yung acknowledgement receipt niya nung nagbigay na siya ng mga acknowledgement receipt para sa di umano binayaran niya? Hindi ba dapat tinago niya yun? Kasi nag-disburse si Gina, tinanggap ni Lachica. Kung siya ang end user, tama lang na may acknowledgement receipt siya, ba't niya binawi? Ba't hindi tinago sa file?
Sir, in terms of binawi po yung AR, sir,
Ni Lachica?
I do not know of that, sir, because
That's what Gina said.
the AR, sir, were given to me by Miss Gina, and then that's what I submitted
Mr.
to the
Ortonio,
Commission on Audit.
The ARs of the various aliases na binanggit, yung kanina pa sinasabi, ng iba't ibang apelido, kasama yung apelido ko, yun yung sinubmit ni Colonel Lachica. Ayon kay Gina, nagbigay siya ng pera kay Colonel Lachica at bilang katibayan, nagbigay na acknowledgement receipt si Colonel Lachica. Pero nung nagbigay siya ng mga acknowledgement receipt at liquidation, binawi daw ni Colonel Lachica yung acknowledgement receipt. So wala kang kopya ng acknowledgement receipt ni Lachica?
Sir, I'm sorry, sir. Ang pagkakaalam ko, sir, is that I got the box with acknowledgement receipt, sir, from the Special Disbursing Officer. And
So
that's
you're
what
not aware of any acknowledgement receipt signed by Lachica?
No, sir.
So if Gina disbursed to him, ba't hindi mo hinanap yung acknowledgement receipt kay Lachica?
Sir, the request, sir, was for the DEPs for the implementation,
If your
sir.
theory is, dinisburse kay Lachica, in-implement ni Lachica, hindi ba kailangan may papel yung dinisbursan na tinanggap niya yung pera?
Sir, I did not request for it anymore, sir.
That's the final question, sir. So this is your story. You placed in the PAP, or you know that what they placed in the PAP, Good Governance Program, Socioeconomic Delivery Program, pero gagastusin yung confidential fund para sa informants, para tiyakin na ligtas ang ikalawang Pangulo saan man siya magpunta sa bansa, kaugnay ng trabaho niya, at ginamit itong confidential fund para bumili ng impormasyon, pera binigay para ipambili ng pagkain, ng silya, ng computer, ng gamot, kapalit ay impormasyon para matiyak ang kaligtasan ng VP at napatunayang matagumpay yon dahil walang nangyaring masama sa ating Vice Presidente hanggang ngayon. Yan po yung buod summary ng paggamit ng confidential fund ng OVP base sa inyong presentasyon.
Sir, with due respect, sir, just
You can correct me, sir.
Just one correction lang po,
Yes,
sir. It's for the to ensure that the activities of the OVP will be implemented safely and that no untoward na mga mangyayari in the performance of walang mangyayari sa mga different activities ng OVP. That's what I
Walang
understand.
mangyayaring masama sa kanya at dun sa makikilahok. That's an accepted
For the
naman,
office and the for the people who will be, say for example, attending mga events, sir.
Kaya hindi lang kay VP, pati sa mga taong makikilahok dun sa event para ligtas silang lahat doon.
Yes, Your Honor.
Yan po yung sinabi sa inyo ni Colonel Lachica na rason kung bakit siya namigay ng pera sa iba't ibang informant sa pamamagitan ng reward o pera pambili ng gamot, ng silya, ng computer, ng pagkain.
Yes, Your Honor.
That would be all, Mr. Ortonio. Senator Judge Zubiri, to avail of the first round.
Thank you very much, Mr. President. I was not going to ask any more questions. I won't be asking a question to the witness, more to address the court. Can we make, because this is a recurring theme, halos sa lahat ng mga testigo, ang sinasabi po nila at minsan mga tanong ng prosecution or defense and prosecution ay ito bang finding ng COA, hindi pa siya final. It is yet under may motion for reconsideration. Ika nga, binanggit nga kanina ng ating testigo. Can this court make representation with the COA? If possible, during the duration of this trial, so that we may be guided as judges. Can they make their finding already with finality? Who knows? They may say na wala namang nangyaring kalokohan. Itong article ay tapos na. Pag sinabi naman talaga nila ay masyadong glaring yung mga violations, then tayo bilang mga judges will also be clarified kung meron talagang misuse of funds. Kasi yung arbiter talaga nito is COA. Diba? Lahat ng misuse of funds ng government agencies, it is the COA that makes that determination. And then before it is taken up to another court, which is Sandigan Bayan, the Ombudsman. Pero sana po, Mr. Presiding Officer, this is an appeal to the COA. I know there is what you call a due process for the parties, but I think the filing for the motion for consideration was done a few months ago, or I think it was in 2000. The findings came out 2024 or 2025. Medyo matagal na. And if there was a motion for reconsideration on the part of the Vice President, maybe it will be prudent that they already come up with a decision of finality, Mr. Presiding Officer, and furnish this impeachment court because it will be very important. Kasi ang sagot palagi ng testigo, may motion for consideration pa kami. Hindi pa final po yan, Your Honors. So, for the guidance of each and every one of us here, may we appeal to the Commission on Audit, I'm sure they're listening, can they already come out with finality on this issue so that we may be guided by the arbiter, the final arbiter when it comes to issues of misuse of funds. Yun lang po, Mr. Presiding
By way of
Officer.
reply, Senator Judge Zubiri, the Commission on Audit is an independent constitutional commission, and I doubt if we would be well within our rights to compel them, similar to a mandamus, to act one way or the other on this matter. Secondly,
That's why it is a request, Mr.
I
Presiding
think the
Officer.
period
Yes.
to file an appeal under 45 or under 65 by certiorari of the ruling of the COA Commission and Bank has not yet lapsed, and the period to file a reconsideration has not yet lapsed too. It is yet to be, the respondent, I think, has until October to file a motion for reconsideration. So it's not yet in the hands of the Commission at this point in time. But having said that, thirdly,
Yes, Mr. President.
there are cases decided by the Supreme Court to the effect that a final determination of COA is not necessary for a case to be heard and tried. This does not preclude the impeachment court, if at all, from deciding based on available evidence in regard to the articles of impeachment pending before us.
Pero Mr. Presiding Officer, napakabigat na mga akusasyon na binabanggit natin dito na yung araw na ito sa Vice Presidente. Napakabigat. Does not that weigh on to the Commission, although it's an independent body, that prudence dictates that they must act with of course, following the what you call due process. Kung October, sinasabi nga natin, di nga ito matatapos ng December. So it is well within the period. I myself, as one of the judges of this impeachment court, want to see the final observation report or findings of the Commission on Audit. That is an appeal to them. As I said, we cannot compel them. They are a independent constitutional branch of government. But for example, budget season starts next week. They will come. Maybe we can ask that question to them. How long will it take before this finding comes out? Because we want to know. I cannot make that. It's very difficult sometimes to make a decision without the final decision made by the Commission on Audit. I think it would be very important, Your Honor. Just putting that on the record. Thank you.
The manifestation of Senator Judge Zubiri is noted. Proceeding now to some administrative matters. The Honorable Luistro earlier asked about the presence of Colonel Boransing. We furnished parties with a copy of his letter dated August 25, stating that he cannot make it given that he needed to coordinate with his superiors before being able to leave his post as prescribed by the standard operating procedures in the Armed Forces of the Philippines, and requests that he instead be called on September 1. I am constrained to grant that, Honorable Luistro, Attorney Sheila, given the exigencies of his position, that he is the commanding officer of Task Force Zamboanga and cannot leave simply because he received the subpoena and would need certain preparations before he can leave his post. Let the corresponding subpoena, if it has not yet been issued, be issued for Colonel Buransing, the second on September 1. Number 2, insofar as Major General Bajao retired is concerned, the address given was not received by the Armed Forces of the Philippines. He is retired. So may I instruct the prosecution to kindly coordinate with either the Philippine Veterans Affairs Office, PIVAO, or the AFP Pension and Gratuity Management Center to get an address. I'm sure he's receiving his pension from somewhere, and that would be a good place to look. The court cannot issue a subpoena properly to Major General Bajao without an address, counsel. Bahaw. In regard to the third, sitting third?
Panopio, Your Honor.
Yes, in regard to Colonel Panopio, he was subpoenaed to appear on September 1, thinking that Colonel Buransing would be here today. Therefore, there are no other witnesses to be presented by the prosecution today. So, next week we are expecting Colonel Buransing, Colonel Panopio, and hopefully we would be able to find Major General Bahaw, if you will still persist in those three witnesses, Honorable Luistro.
Your Honor, we respectfully inform the Honorable Impeachment Court that we are now dropping the presentation of Colonel Bahaw. Nevertheless, we maintain
Major General.
Major
retired.
General Bahaw, Your Honor. We maintain the position to present both Colonel Buransing and Colonel Panopio, to whom the subpoenas have been ordered to be issued for September 1, 2026, Your Honor. But in addition to that, Your Honor, and in order to maximize the schedule that is given to us by the
I was
Honorable
about to ask
Impeachment
that.
Court, for September 2, that is next Wednesday, Your Honor, we would like to respectfully move for the issuance of subpoena ad testificandum to Attorney Michael Wesley T. Poa, if the same should be necessary, as well as to Ms. Marisa B. Grande of the Philippine Statistics Authority, Your Honor. If given opportunity next week, these two shall likewise be presented on September 2, Wednesday, Your Honor.
Subject to the colatilia that should the other witness not appear, given that Attorney Poa is here and more than willing to testify as intimated earlier, then we jump to Attorney Poa. Should the other earlier two witnesses fail to appear on September 1, without need of issuing a subpoena to Attorney Poa. He is so informed in open court.
We submit to that, Your Honor.
So ordered. Other matters, yesterday afternoon, the prosecution filed a motion to set a conference for the marking of additional exhibits, particularly documents received from the Philippine Statistics Authority. The prosecution seeks to set the conference at 4 p.m. today. This is quite a simple motion, Attorney Sheila. The motion is granted. The clerk of court is directed to conduct the marking of additional exhibits at 4 o'clock this afternoon at Rector Room, and counsels are directed to send representatives to attend the conference. The presiding officer is also in receipt of a request from the respondent to be furnished with copies of the prosecution's pre-marked exhibits for Article 1, which counsel for respondent is likewise marked with the specifics. These being common exhibits, the request is hereby granted. The clerk of court is directed to furnish counsel for the respondent with copies of the requested pre-marked exhibits, with the understanding that the panel of prosecutors will be accorded the same courtesy should a similar request on the respondent's marked documents be made in the future. So ordered.
Your Honor,
Yes, Attorney Sheila?
given that opportunity given to the prosecution to mark additional documents, we would like to avail of the same opportunity. And if the situation calls for it, we will ask for an additional setting for conference to mark additional documents in preparation for our presentation, so that in the interest of time, we can take advantage of these additional settings ordered by the court.
Let it so be granted without
Thank you,
need
Your
of
Honor.
an order being issued by the court, subject to the availability of the parties and the clerk of court.
Thank you, Your Honor.
So ordered. Finally, we are in receipt of a prosecution's request for supplemental subpoena for other banks and financial institutions. I presume, Attorney Sheila, you got a copy of the subpoena?
We did, Your Honor.
The chair will simply adopt and apply its ruling last July 20, 2026 concerning the subpoena issued to certain banking institutions involving the same subject matter, and the same limitations will apply accordingly. The request for subpoena directed to the concerned banking institutions, I won't specify anymore because both parties have a copy, and financial institutions covering the respondent, her spouse, Attorney Manasseh Carpio, as well as 20 entities allowed by this court in which the spouses hold an interest, is hereby granted. It is clear that the subpoena does not include foreign currency, is limited only to peso-denominated accounts and not to foreign currency deposits, as these are excluded without the written consent of the depositor. The clerk of court is directed to cause the issuance and service of the subpoenas to the entities requested to so submit, who shall produce the required documents before the clerk of court in 7 calendar days from today, or on September 2, Wednesday, next week, 2026. So ordered.
Your Honor,
Yes, Attorney Sheila.
given the position that we had articulated on this matter of the subpoena with respect to bank records and other materials subject of that subpoena, we will just want to place it on record that we will be, or we are reserving our right to comment and to put our appropriate objections at the proper time. Thank you.
On the record, Attorney
On the
Sheila.
record, Your Honor.
Yes.
Your Honor, please.
And or seek further remedies as is available to you.
That's correct, Your Honor.
Outside of this court. Yes, Honorable Listro.
We would like to respectfully manifest to the Honorable Impeachment Court that almost simultaneously to the reading of the ruling of the Honorable Impeachment Court on the issue of sub judice rule, the respondent Vice President made a public statement
I
which
know
is...
where you're leading at, Counsel. Naunahan mo lang ako. I thought you were going to take up another matter, so let me cut you short. Yes. While the presiding officer was delivering its ruling on the applicability, limitation, and who is covered by Rule 18, a statement was issued by the impeached official, the respondent, the Vice President, which clearly is covered by what the ruling earlier given by the presiding officer issued. So, given that it was done while the ruling was being issued, prospectivity would still apply. However, the presiding officer would like to remind, through the lead counsel for the respondent, her client, to kindly observe the ruling of the presiding officer as well as the rules of the impeachment court, specifically Article or Rule 18 on the subject matter in regard to making comments on the merits of the case, because henceforth, again, given the prospectivity of the ruling, the necessary actions will be taken against her not only by the court, but also, given that she's a lawyer, via what the presiding officer earlier mentioned in relation to CIPRA and in relation to the Office of the Bar Confident. Kindly inform her, Attorney Sheila.
We take note of that reminder, Your Honor.
Thank you, Attorney
So
Sheila.
just it will form part of the record, Your Honor. May I be allowed to read that portion of the statement of
I
the
think
respondent
this is
Vice
unnecessary, Your Honor.
No need, no need. Again, I find it unacceptable, and it will be commenting on the merits, and no need to read it in the records. The court can take, in fact, judicial notice of that, should it so desire. Senator Judge Aquino.
Mr. President, for the benefit of everyone, may I be clarified again, what are the possible penalties for breaking or not following your decision po earlier. Kapag senator judge, it goes to the Committee on Ethics. Tama po, no?
Yes?
Yes. Kapag mga miyembro po ng councils, ano po yung mga posibleng penalty? Kapag respondent or complainant, ano po yung mga posibleng penalty? Kapag ibang tao po, kasama po ba sila sa saklaw ng inyong ruling kanina?
We will issue the corresponding guidelines, Senator Judge Bam, for the information of Senator Judges, so that it will be in a clear table form. But to answer your question, reprimand and admonition, followed by a fine for the second offense, and fine subsequently thereafter without prejudice to referring the matter should it violate their obligations as a member, as an officer of the court, without prejudice to referring the matter to the Supreme Court, the IBP, and or the Office of the Bar, I'm confident, if any violation may have been committed by them. But we will issue the guidelines in relation to that. Yes, Honorable Luistro, anything else?
We have no other manifestation, Your Honor.
Attorney Sheila?
We're good, Your Honor.
We promise to provide what do you call it? A platform, should it be so necessary.
Yes, Your
May
Honor.
we request, Your
appreciate
Honor,
that.
that the witness, Mr. Ortonio, be excused?
Yes, I'm sorry, Mr. Ortonio. I thought the administrative matters would not take this long. Yes, Mr. Ortonio, you are excused. Maraming salamat po sa inyong panahon, sa inyong kooperasyon at sa pagsagot po sa katanungan ng Senator Judges at ng magkabilang partido. Thank you for your time, sir. You are excused,
Thank you
sir.
very much, Your Honor. Thank you.
The trial is adjourned until 10 a.m. Still 10 a.m. on Tuesday, given that Monday is a holiday, September 1, 2026.
Thank you.
Session will be at 3:30 according to the Senate President.
At mga kapuso, dito po nagtatapos ang Day 19 ng impeachment trial laban kay Vice President Sara Duterte. At sa pagtatapos po ng pagtestigo ni ASEC Lemuel Ortonio, natapos na rin po yung redirect examination, yung cross-examination, pati na yung interjections ng mga senador. Isa po, Professor Tomase, dun sa mga naipunto ng mga senator judge sa kanilang interjection, ay yung ginamit ni Senator Judge Raffy Tulfo, yung salitang nagmamaang-maangan in reference to ASEC Ortonio saying na hindi niya alam kung bakit, kung sino yung mga nakapangalan doon sa acknowledgement receipt, tas meron mga bahagi na hindi tungkol sa liquidation na hindi na raw niya inusisa. Si Presiding Officer Cheese Escudero, pinatanggal niya yung salitang ito sa record at ginamit instead ang feigning ignorance. So, ang tanong ko, Professor Tomase, may pananagutan ba ang isang tao kapag ginawa niya ito, yung feigning ignorance?
Well, meron kasing doktrina sa criminal law na tinatawag natin willful blindness na usually na-apply ito sa Pilipinas sa tax cases. But yung mas malaking principle doon ay hindi mo pwede ipikit yung mata mo. Kung nakikita mo na may problema, for example, yung mga transactions na dumadaan sa'yo, kung nakikita mo na malinaw naman na may problema yung mga dokumento, etc. So, analogously, hindi naman kasi kriminal na kaso ito, mahirap sabihin na walang responsibilidad yung isang opisyal na alam naman niyang may suspicious na nangyayari or dapat mag-exercise siya ng greater care, no? Sa kanyang trabaho, lalo na pagdating dito sa liquidation ng mga pondo.
So, yung salita na ginamit kanina ni Senator Judge Raffy Tulfo was nagtatanga-tangahan?
Yes.
Yes, nagtatanga-tangahan. So, yun yung pinatanggal ni Presiding Officer Cheese Escudero from the record. So, ibig ba sabihin ito, Professor Tomase, na, well, we saw also na pina-strike off the record niya right away, di ba, after the interjection. So, ito ba ay yung senyales na nga na talagang from this point forward, mas stricto na ang impeachment court pagdating sa kanilang pag-implement ng mga patakaran, proper decorum?
Well, kung babalikan natin yung statement ni Senator Escudero, kinilala niya kasi nung simula na minsan yung problema ay nasa kanila, nasa senators mismo, na hindi sila makapagpigil, mayroong mga improper conduct or unparliamentary conduct. Honestly, disappointed with some of the questions kanina kasi not only were there suggestions or parang pasaring doon sa witness na respectfully mukhang hindi naman deserved, but mayroon ding distractions pa rin from the larger point, no? or parang nagiging political statement yung ibang bahagi ng questioning. So hindi natin alam kung hindi lang ba nakinig yung mga other senators during the reading of Senator Escudero's order, or if mayroon talagang pushback against them. In the meantime, I think we'll find out in the next few days kung tatalima talaga sila. Kasi unlike Rule 18 on sub judice, walang penalty for senators who break away from this. Now, just as a quick point, hindi naman nababago sa kasaysayan, sa experience natin sa impeachment, yung ganito. Maalala ng mga tao from the ERAP impeachment and Corona impeachment na si Senator Miriam mismo malakas din mag-statement minsan na maanghang. And bahagi talaga ng Senado bilang co-equal sila lahat, no? Silang 24 senators, na hindi nila pinopolis yung isa't isa as much as possible. So medyo strange dynamic siya. Makikita natin next week kung mag-evolve ito.
Alright, well sa punto ito, magpapasalamat po kami sa inyo, Professor Paolo Tamase, ang Associate Dean ng UP College of Law. At mga kapuso, yan po ang special coverage ng GMA News sa Day 19 ng impeachment trial ni Vice President Sara Duterte. Maraming salamat po sa inyong pagtitiwala. Ako po si P. Arcangel para sa The Vice President on Trial.
Good afternoon. For August 26, 2026, the Senate President Sherwin Gatchalian opened the session at exactly 10 a.m. with 17 senators present, constituting a quorum for the 19th day of the impeachment trial. For administrative matters, the presiding officer confirmed receipt of the motion to set a conference for marking of additional exhibits from the Philippine Statistics Authority, which was received on Tuesday, August 25, 2026 at 5:20 p.m. and granted the same to allow it this afternoon at 4 p.m., instructing both parties to be there. The presiding officer confirmed receipt of the letter from Lieutenant Colonel Manaros Boransing II to be excused from attendance today because he needed to ask permission to leave his post, and granted the same and issued a subpoena for him on September 1, 2026. The presiding officer also granted the motion of the House Prosecution Panel's lead prosecutor, Congressman Jervel Luistro, to drop retired Major General Adonis Bajao. The presiding officer also granted the issuance of subpoena ad testificandum to Ms. Marisa V. Grande of the PSA for September 2, 2026. As to the request for subpoena for Attorney Michael Powa, the presiding officer merely informed him in open court. The presiding officer also granted the motion of the House Prosecution Panel supplemental request for subpoena duces tecum for bank records and to be submitted on September 2, 2026. The presiding officer confirmed that pertaining to the statement posted by the respondent, the ruling prospectively applies, but instructed sternly the respondent's counsel to remind the respondent of the application of his ruling even to her. Upon inquiry of Senator Judge Ping Lacson, the presiding officer confirmed that the impeachment court has the power and discretion to call on witnesses or recall witnesses to satisfy its search for truth, citing People v. Valera and City of Cebu v. Gaco Jr. Before the start of the presentation of evidence, the respondent's counsel, Attorney Michael Powa, manifested to the court that counsel for prosecutors, Attorney May de Vinegracia, had repeated the impertinent words in an interview right before the hearing. The presiding officer noted, or right after the hearing, the presiding officer noted that the said manifestation and confirmed it will be addressed in his ruling. After hearing Attorney Ligutan's response, the presiding officer rendered his definitive ruling, which establishes strict guidelines to preserve the constitutional integrity of the trial, ensure due process, and halt extrajudicial trial by publicity. The triple ruling on court decorum and duty to comply with Rule 18. I will summarize the ruling. As to the senator judges and internal ethics remedies, before imposing rules on the trial counsels, the impeachment court first put its own house in order. The presiding officer reminded the senator judges of their solemn oath to maintain cold neutrality. However, applying People v. Guambor, the court clarified that neutrality does not mean passivity. Senator judges retain the absolute right to propound searching cross-examination style questions to extract the truth. Piercing questions that destroy one's theory of the case do not constitute bias. Furthermore, firmly establishing the Senate's institutional independence via Pobre v. Defensor Santiago, the presiding officer ruled that any allegations of ethical breaches or bias by senator judges shall be handled strictly via internal remedies through the Senate Committee on Ethics and Privileges, not through the media. Furthermore, the presiding officer laid down strict rules on in-court decorum for the tribunal itself, invoking Senate Rules Section 93 to 96. The court strictly prohibited senator judges from engaging in unparliamentary remarks, personal attacks, and imputations of improper motives during the proceedings. While extending courtesy and latitude required for vigorous debate, the presiding officer issued a firm reminder that language incompatible with the dignity of the chamber will be met with strict enforcement of parliamentary rules. As to the parties and counsels, addressing the sub judice rule under Rule 18, the presiding officer extended institutional grace, declaring tabula rasa or clean slate for all past public statements, including the statement of the respondent just this afternoon. Moving forward, a zero-tolerance policy applies. No party, counsel, or witness may publicly comment on the merits of the case, which includes predicting outcomes, assessing evidence, or evaluating witness credibility. The court issued an ultimatum to the legal panel's lead counsels, specifically noting Attorney Tolosa and POA being spokespersons and counsels at the same time, that they must either cease acting as media spokespersons or officially withdraw as counsels of record. The presiding officer reiterated that counsels must litigate their respective causes before the impeachment court, not in the court of public opinion, through interviews, social media posts, or publicly generated, authorized, encouraged, or conducted through surrogates. The official guidelines as to scope of coverage, it applies to the presiding officer, senator judges, House prosecution panel, the counsels for the House prosecution panel, the respondent, Vice President Sara Duterte, the respondent's counsels, and all witnesses. For those not covered by Rule 18 and the Code of Professional Responsibility and Accountability, or CPRA, they shall be covered by the suppletory application of Rule 71 of the Rules of Court on indirect contempt in relation to the standards laid out by the Supreme Court in ABS-CBN versus Ampatuan. As to the substantive guidelines on what constitutes prohibited comments on the merits, relying on the Supreme Court jurisprudence, the impeachment court defines commenting on the merits to include, but is not limited to, A, assessment of evidence and witness. Pursuant to the en banc doctrine in Badoy versus Magdoza Malagar, to speak on the merits comprehensively means making public statements that evaluate a disputed fact or substantive issue before a formal verdict is reached. It is strictly prohibited for any covered party to publicly discuss, attack, or defend the credibility, truthfulness, or motive of the witnesses. Number 2, to assess the character of the accused or the respondent. Number 3, evaluate the soundness of the alibis, complaints, or defenses offered. Number 4, evaluate the admissibility, relevance, weight, or sufficiency of the evidence presented. And number 5, generally, any other comment hearing on the guilt or innocence of the accused or the respondent. And what is allowed? The fair and true report exception. Conversely, the presiding officer recognized the qualified privilege of a fair and true report regarding the proceedings as affirmed by the Supreme Court en banc in ABS-CBN versus Ampatuan, based on the jurisprudential standard derived from Article 354 of the Revised Penal Code. A fair and true report means a neutral and objective and accurate recounting of the proceedings made in good faith, without any comments or remarks. Letter B, prejudging the outcome and pressuring the court. Pursuant to the en banc case of In Re, published threats hurled by Attorney De Vera, no covered person shall make public statements, insinuations, or rhetorical questions that, number 1, prejudge the issue to predict the outcome of the trial. Number 2, question pending rulings. Number 3, substitute media pressure for evidence. Number 4, promote distrust and undermine public confidence in the impeachment court by creating the impression that the impeachment court cannot be trusted to resolve cases impartially and violate the right of the parties to have their case tried fairly by an independent tribunal uninfluenced by public clamor and other extraneous influences. Letter C, the CPRA standard for lawyers. Pursuant to Canon 2, Section 19 of the CPRA, all counsels are prohibited to comment or publicize opinion pertaining to a pending proceeding in a manner that may cause prejudgment, sway public perception, influence the tribunal, or create a widespread perception of guilt or innocence. CPRA likewise requires professional responsibility in the use of social media and prohibits the dissemination of false or unverified claims or disinformation. As to the summary due process and the two-strike rule, citing Zaldivar versus Sandigambay, the impeachment court will issue a mere 24-hour show cause order for suspected violators to submit a written explanation explicitly dispensing with lengthy trial-type hearings. Crucially, under Stratcom versus Etong and Webb versus Gapdula, any punitive sanction requires the impeachment court to find that the person's act must be done willfully or for an illegitimate or improper purpose. Thus, the good faith or lack thereof of the person being cited in contempt should be considered. Therefore, the accused is presumed innocent, and the burden to prove willful bad faith rests heavily on the complainant or the movant. Violators may face a strict two-strike rule. Strike 1, severe public reprimand and stern admonition on the record. Strike 2, maximum 30,000 statutory fine and a case management floor restriction wherein the offending lawyer or party will be subjected to a defined prospective restriction on speaking, objecting, or examining witnesses on the floor. For members of the bar, based on the case of in regard to Attorney Almacen, the certified incident record will be transmitted and a formal referral will be made to the Office of the Bar Confidant, the Integrated Bar of the Philippines, and or the Supreme Court for disciplinary sanction regarding the person's license to practice. Number 4, in-court decorum, direct contempt, and stricken words. While Rule 18 governs outside media statements, the presiding officer set equally rigid boundaries for legitimate advocacy inside the courtroom, citing Navarrete versus Court of Appeals and Baltao versus Falsis III. The court warned that zealous advocacy is never a license for offensive, abusive, or intemperate language. Asserting strict courtroom control, the presiding officer ordered stricken of the record the inflammatory terms scam, mastermind, and modus operandi, previously used during the proceedings. Counsels are directed to advance their theories through reasoned arguments and evidence, not derogatory characterizations. The court issued a stern warning: disrespectful or offensive language uttered inside the chamber that obstructs the proceedings will be dealt with immediately as direct contempt under Rule 71, Section 1 of the Rules of Court, alongside separate disciplinary referrals for violations of CIPRA under Canon 2. And citing Attorney Francisco versus Attorney Zuniga Lagman for the prosecution and People versus XXX for the defense, both panels were reminded by the presiding officer that their paramount duty is the rigorous pursuit of justice and the protection of constitutional rights, not victory or acquittal at all costs. For the presentation of evidence in chief for Article 1, the continuation of the testimony of Mr. Lemuel G. Ortonio, the counsel for the House Prosecution Panel's Attorney Midi Vinagracia conducted the direct examination, and afterwards, the cross-examination was conducted by Attorney Christine Ferrer, while redirect and cross-examination were conducted by the same counsels. 12 senators rigorously interpolated the witness and counsels under 3 themes. Theme number 1, as to the blind signatory defense and the reliction of verification, Senator Judge Rafi Tulfo questioned why a highly educated official was satisfied with bare claims, failed his duty to ask questions before signing the AOM replies, and whether he even bothered to ask the concerned persons about the AOM findings. Senator Judge Kiko Pangilinan pressed the witness on why he did not go through all the acknowledgement receipts when drafting the AOM reply, asking point blank if anything physically stopped him from opening the evidence envelopes to do his job. Senator Judge Erwin Tulfo challenged the witness's competence, asking why he answered the AOM when he admittedly knew nothing about intelligence activities. If the drafted reply relied solely on Colonel Lachica's claims, and if he harbored any doubts regarding the implementation. Senate President Sherwin Gatchalian probed the witness's blind trust, asking what actions he took to verify the ARs, why he fully trusted Colonel Lachica without probing further before signing the AOM reply, and questioned the OVP's reply regarding who paid 3 months in advance. Senator Judge Joel Villanueva asked about the witness's extent of authority in signing for the Vice President and why he blindly provided his signature without demanding details about the disbursement arrangements. Theme number 2, procurement absurdities and sickly informants, quote, and fictitious aliases. Senator Judge Rafi Tulfo highlighted the absurdity of the justification, asking for details on the medicines purchased, sarcastically inquiring if the informants are usually sick, and why the massive allocations didn't make the witness curious about their health. He also asked why the witness didn't ask for the actual names behind the ARs. Senator Judge Erwin Tulfo established the civilian nature of the OVP, which does not conduct surveillance supposedly. He explicitly questioned the purchase of furniture using confidential funds, asking if the witness knew this is a direct violation of the COA-DBM Joint Circular. He also asked where the aliases came from. Senator Judge Bam Aquino focused on the institutional reaction to the anomalies. He asked about the OVPs and the respondents' reaction to the absurd aliases, whether anyone raised concerns and if an internal investigation was ever launched after receiving the AUM. Senator Judge Ping Lacson scrutinized the foundational paperwork, asking if the witness is the designated financial officer, noting the physical and financial plans or PFP contained identical copy-pasted entries, and questioned if the underlying intelligence information had already been formally declassified. Senator Judge Robin Padilla, offering a counter perspective on covert operations, defended the use of aliases by noting that historical heroes, specifically Noy Aquino using Marshal Bonifacio, legitimately utilized them for law and order purposes. As to theme number 3, upward tracing of accountability, proxies, and chain of command, Senator Judge Risa Ontiveros targeted command responsibility directly. She asked if the respondent knew of approved and had the last touch on all the replies sent to the COA. She asked about the chain of trust regarding the encashment and pressed him to confirm that the respondent is ultimately the accountable officer for the funds. Senate President Sherwin Gatchalian asked if Colonel La Chica ever confirmed receiving the 500 million, how the witness thought La Chica would implement the projects, and demanded to know who in the OVP only actually knows how the confidential funds were spent. Senator Judge Erwin Tulfo questioned the proxy's legal authority, asking if Colonel La Chica was a legally bonded official and why he was authorized to hold such massive amounts of public money. Senator Judge Tito Soto questioned the organizational structure, asking what exact official item or plantilla position Colonel La Chica held within the OVP to justify his control of the funds. While Presiding Officer Chis Escudero exposed a critical accounting inconsistency. He probed whether Colonel La Chica was legally authorized to handle the money and questioned the defense's shifting theory, asking whether La Chica claimed to be the actual end user who submitted his own AR or merely a conduit who later replaced his AR with receipts from fictitious informants. Following rulings by the presiding officer Escudero on various evidentiary motions and objections by both parties, the trial was adjourned. Pursuant to the rules of procedure on impeachment trials, the impeachment court will resume session on Tuesday, September 1, 2026 at 10 a.m. The agenda is a continuation of the representation of the House Prosecution Panel's case-in-chief for Article 1 through the start of the presentation of their 8th witness, Lieutenant Colonel Manaros Boransing II, AFP representative. Any questions?
Sir?
Yes po.
Sir, parang nabanggit din yata ni presiding kanina about La Chica na pwedeng ipatawag siya ng court kung hindi pa patawag ng both sides. Sir, yun ba kung ipatatawag siya, si presiding officer lang po ang magdidesisyon o kailangan pagbotohan kung papayag lahat ng senator judges? Paano po?
Nakalagay po sa ating Senate Rules on Impeachment na kapag mga ganyang evidentiary na mga rulings, the presiding officer can rule by himself or upon his own discretion, submit the question for the decision of the senator judges as a whole, as a collegial body. So kapag nag-rule na siya dyan at wala naman nag-apela, then yun na yung ruling ng korte. Pero on the first instance, pwede nga rin naman ibato yung tanong na yun sa ating mga senator judges para pagbotohan. Pero initially, ang preferred ni presiding officer, he makes the ruling himself.
Sir, pwede rin mag-request ang isang senator judge na presiding officer, paki-invite, paki-subpoena itong si Colonel La Chica. Pwede po yun.
Tama po kayo. Bilang a collegial body, the presiding officer is just one among equals, no? He is just presiding, pero equal po sila. So any of the senator judges can also request that the court issue a subpoena ad testificandum to Colonel La Chica at the end of the presentation of the prosecution's evidence in chief and at the end of the presentation of the defense's evidence in chief. So kahit na ipatawag po, kunwari ang isang testigo ng any of the parties, pwede pa rin within the power ng ating impeachment court na i-recall din yung witness na yon. Kung wala naman at hindi ipinatawag yung mga witnesses na yon on the first instance, pwedeng magpatawag din ng additional witnesses ang ating korte because ultimately the impeachment court wants to get into the truth of the matter.
Sir, napasadahan na naman kanina, no? But as a clarification, yung sub judice ruling covers everybody inside the courtroom, no? Senators and even the respondents. Can you just elaborate on the coverage of Vice President Duterte and the process? Kung halimbawa, paano yun? Kung may violation, allegedly, paano po yun, sir?
Katulad kanina, no, may nag-raise ng possible violation ng respondent, no, si House Lead Prosecutor Jervil Luistro. However, it was determined by the presiding officer that the posting of the said statement by the respondent was made at around 10:19 in the morning, which is at the same time that the presiding officer is just started his ruling on the matter. So dahil hindi pa po siya natatapos basahin yung ruling na yon, hindi nga pa sinasabi yung so ordered at hindi nga pa binabang yung gavel. So wala pa pong ruling at the time na 10:19. So nung pinost po yun, kasama na po siya doon sa prospective application. Meaning, wala pa siyang nilalabag at the time ng 10:19 ng umaga na yon dahil hindi pa tapos yung ruling sabihin ng ating presiding officer.
But moving forward, if there are allegations of violation by the respondents, paano po yung pag-raise na?
Yes. That's why yung lahat kasi nabigyan na ng first warning, no? Even the spokespersons and the ating mga counsels, no? Now, the respondent, binigyan na rin kanina ng first warning ng ating presiding officer through the respondent's counsel, yung respondent, na pagsabihan siya na siya ngayon ay covered nung Rule 18 ng ating Senate impeachment rules. At kung merong mag-raise ng violation after today, by any party or any person, ang first penalty, syempre bibigyan mo ng 24 hours to reply para magkaroon ng due process kung bakit mo sinabi to, bakit ganito yung ginawa mo, meron bang basehan yung complaint sa'yo. After the 24-hour submission ng written explanation, the presiding officer will summarily just issue a ruling kung may finding of violation o wala. Kung may finding of violation, i-impose nga yung first strike, which is admonition, reprimand in open court. Now, kapag hindi pa rin tumino yung isang tao at continuous violating the sub judice rule or the court imposed a proper decorum and language in the courtroom, then sa strike 2, after again 24-hour 24-hour written explanation receipt, kapag ito ang second offense na, i-impose na yung 30,000 penalty na fine on the person for every violation. And then kapag talagang third strike, fourth strike na, hindi na talaga natuto even without even with fine, then the presiding officer will issue an order to refer the matter to the Supreme Court for the disciplinary action by the Supreme Court of the person kapag siya ay covered by the CIPRA nung aming ethical duties as a lawyer.
Sir, rule of thumb lang for the public, just so they process the concept, no? Yung sub judice, paano ba yan? So dapat hindi nililitis sa labas ng court? Can you just give us a rule of thumb?
Tama po. So, meron tayo sa dalawang rule ang nag-a-apply sa aming mga abogado po, lalo pa yung mga covered persons. Kaya sinasabi ni presiding officer, kung spokesperson ka, wag ka na lang maging counsel of record. Kasi kapag spokesperson ka lang, hindi ka covered under Rule 18. Covered ka lang ng Canon 2, Section 19 ng CIPRA, if ever. So, pero kapag ikaw ay counsel of record, covered ka rin ng Rule 18 ng Senate Impeachment Rules. So, ang sub judice under Canon 2, Section 19 ng CIPRA namin, bawal kasi in any forum na maglitigate ka, sabihin yung mga merito ng kaso to cause a prejudgment, to sway public perception, para ma-obstruct or ma-impede or to influence the decision of the court or the tribunal, to impute improper motives to any of the members of the tribunal and the tribunal itself, and to create a widespread perception of guilt or innocence before a final decision. Ang ibig sabihin, kung abogado ka, litisin mo yung kaso mo sa loob ng korte, huwag sa labas ng korte. Hayaan mo yung ibang tao na hindi counsel of record ang maglitis nun sa labas ng korte. Pag ikaw ay counsel of record, you do it by evidence through the court proceedings natin.
All right, sir. Thank you.
Attorney, on the part naman po of the counsel, so does that mean na wala na po tayo makikitang post nila online na carrying words or phrases that may have to do with the impeachment proceedings po? Bawal na po ba talaga yun? Kumbaga, ano yung magiging
Alam naman po
distinction?
natin, kahit meron tayong pagbawal, ang dami po nating mga batas, di ba? Kung gustong labagin, lalabagin po. Pero at least ngayon po, ang maganda po nangyari dito, malinaw na po. Hindi na po tayo manghuhula. Ano ba ang subjudice? Ano ba yung comments on the merits? Nagbigay na ng example kanina ang ating presiding officer. So anything na nagdi-discuss ng merito ng kaso, ng ebidensya, sinasabi mo na, yung pinatunayan ng testigo na to, ganito to. At ganito ang ibig sabihin nito. Ina-analyze mo, nagkakaroon ka ng conclusion of fact, nagkakaroon ka ng conclusion of law. But that was not allowed in open court during the trial. Bawal po yung ganon, no? Pero ikaw, ginagawa mo siya sa labas ng korte. So yun po yung pinagbabawalan kasi you're both trying the case inside the court and then outside of the court as well, which is wrong because you are courting publicity for yourself and for the evidence na trying to influence the judges to go the way that you want them to go.
Attorney, so technically po ba masasabing lumabag dito sa rule yung pinost ni Attorney Ligutan?
I think walang finding na ganon because of the fact that the presiding officer didn't want to make a determination of any violation. While he said, no, kanina may mga examples siyang ibinigay na mga sinabi in the past ng ating mga counsels at parties, hindi niya ito ibig sabihin determination of any violation. Maingat siya dun sa wording na yon. There was no determination of a violation. Sinasabi niya lang, ito ang mga example. Pero dahil nga doon sa institutional grace na ibinibigay ng ating impeachment court, and by being liberal about it, katulad nung sinabi niya mula nung umpisa, hindi niya muna paparusahan yung mga parties. Hinayaan niya muna ng konting breathing room. Kaya tabula rasa na or clean slate na. Hindi niya na pininalize yung mga previously na may mga nagsabi. So as to Attorney Ligutan, wala talaga siyang determination na bawal yun or hindi.
Kumbaga may warning na po sa lahat.
Warning lang sa lahat.
Attorneys, last na lang po on my part. Pagdating naman po kaya sa senator judges, while nagpaalala na po si presiding officer, baka lang po maging question again ng mga taong nagbabantay o nanonood ng impeachment. May mga senator judge din po may binibitiwang mga comments or remarks habang nagbabato po sila ng clarificatory questions. May tanga-tangahan, pero pina-reward na po yan ni presiding officer. Yang mga yan po ba may hangganan na pagdating dito sa rule na to?
Tama po kayo. Kasama po sa ruling ng ating presiding officer kanina, yung sinasabi niyang unparliamentary language na mag-a-apply yung rules nila sa Senado on unparliamentary behavior and language. Na kapag may any senator judge na lumabag nun, that senator judge can be subjected to ethics committee na sanction. Pero kailangan may mag-raise to na party or a fellow senator judge.
So pwede pong kung sakali magkaroon ng complaint? Or paano po ba yun? Dapat manifestation? O pwedeng complaint na
Complaint po. So the councils, kapag sila ay encounter ng ganong mga intemperate language from a senator judge that may be considered as unparliamentary language or actions, then the councils themselves can raise it on the floor for the presiding officers. Possible, kung nag-agree yung presiding officer, mag-order siya to refer it to the Ethics Committee ng Senate. Kapag hindi siya nag-a-agree, then papatayin niya na yung issue on the floor, right then and there.
Pero hanggat wala naman pong, kunwari lang po, formal complaint or manifestation regarding this, only the senators themselves can police each other po.
Correct.
Additional question po doon, attorney. Is it only the councils from both parties yung pwedeng mag-raise, or can the general public also raise the concern, lalo na ethics committee naman yung magta-try sa kanila?
Tama ka po, no? Dahil ito po ay papasok na doon sa rules ng ating Senate, no? As a legislative body, any person can already raise as well the violation of ethical duties by the senators under the Senate rules. Kaya sinait kanina ni presiding officer yung Rule 34, Section 93 hanggang Section 96 ng Senate Rules. Para pati yung mga publiko, kung may makita silang impropriety from the actions or the language of any senator judge, then they can do so.
For moving forward po, attorney, will the Senate as an impeachment court be, kasi nabanggit niyo po before, passive lang pagdating dito sa mga possible violations for sub judice. Moving forward, since may ganitong ruling na po, actively ba ititignan na din nila yung mga posts ng magkabilang council, or dapat pa rin i-raise yun ng councils from either teams?
The preference of the impeachment court is that it sits as a passive body, that those kinds of issues should be raised by both parties. So, yun yung unang preference ng ating impeachment court. So, it also goes to show kung gaano kapasensyoso ng ating impeachment court regarding those kinds of matters. That's why wala kayong narinig sa impeachment court about these things, despite and in spite of the fact na marami ng mga alleged violations na napapansin ng impeachment court. Hindi siya gumalaw until attorney season manifested last time. And that triggered the ruling of the presiding officer on the matter. Wala na po. Thank you. Maraming salamat po. Good afternoon. Sino po? May alias ka ba sa Facebook? Yun ang gagawin malamang, sir.